Good morning, everybody. Welcome back. Hope y'all had a good Memorial Day weekend. A little extra time. The official start of summer. We had a beautiful day over here. It was an awesome time to be outside and take that minute to just think about everybody who gets lost in wartime and what that means in our lives today. So, but now we're back. Now we're back for day 18 of Karen Reed, Commonwealth versus Karen Reed. And what's even going to happen? What's going to happen today? Are we coming back with Brian Higgins? I don't know. I don't know. I'm so just confused because I didn't get the normal what I expect from Judge Cannoni now, which is thank you, you're all set. The little signal there that the witness is done, the witness has been released. Thank you, you're all set. So we didn't get that. We just got that quick, hard cutoff at the end of the day on Friday, and now we're just here. We're just here. I don't know if we get more. The Commonwealth never got to redirect him. Didn't look like the defense was really done. So I don't know. We might get more Brian Higgins. We might not get more Brian Higgins. Really not sure what that is going to look like. But we all know, yeah, there's a lot of other witnesses still on this list that we're waiting for. And finally, at long last, is this a sign we are going to start getting to some of these forensic people? Are we going to finally maybe start to get a little bit of proof, just a little bit of proof that Karen Reed hit John O'Keefe with a car? That anybody at all hit John O'Keefe with a car? Are we going to finally get to that? Because boy, that's really what I'm waiting on here. That's what I'm continuing to wait on here. Not real compelled by this evidence of motive that we seem to be getting, that there was a fight with Aruba and some very cringy flirting with Brian Higgins somehow creates a motive for her to murder him. Really not seeing that at all. Certainly not a situation where it's so crystal clear that I'm like, yeah, she's definitely going to want to kill him. So I'm going to be inclined to believe even some pretty slight evidence here that would tend to suggest that that's actually physically what happened. That's not that case. That's not the case that we're dealing with here. So very marginal evidence of motive from what I've seen so far. And nothing at all yet to tell me that he was hit with a car. So that's really what I'm waiting for. That's going to be very, very critical in this case because, you have the big burden to overcome here with all the shady stuff that all these witnesses are doing as far as nobody's seen him that should have. People running around scrambling with the butt dial. We're on like the 10th butt dial or something that all of these people are just coincidentally having all with each other all at the same time. No, a lot of that sketchy stuff that's got to be overcome. And I just really don't know if they're going to be able to do that. Granted, I don't know the ins and outs of the testimony. I know they've talked some about this pre-trial. I don't know what they're going to have to try to show me that this guy was hit by a car, but so far from what I can see with my own eyes, it doesn't look like he's been hit by a car. Okay, the arm does not look like it was hit by a car. I don't know what possible theory they're going to have to explain that arm. So those are big deficits in my belief in the Commonwealth's case here that they're going to need to overcome if they're going to want to get me over the line to guilty here on Karen Reed. I continue to just be astonished that we are still in the Commonwealth's case in chief. Like, their standing is this bad and we're still in their case in chief. We haven't even gotten to the defense case yet. So to the extent that the defense has made progress here, and I tend to think that they have significantly undermined so many of these Commonwealth witnesses. It's really amazing that they've been able to do that solely on cross-examination, solely with hostile witnesses. They've still been able to get in a pretty good position here. So it continues to be this bizarre reversal of order, reversal of priorities, this pre-Rebuttal case that we got from the Commonwealth, trying to in advance take the wind out of the sails of the hoax, the conspiracy theory, the argument that these people were all working together to cover something up. And I just don't feel like that's gone very well, because there's just a lot of evidence here of something being covered up. Whether, continue to say, I can't say it was this, I don't know, but people are definitely acting shady around this death, and you have to wonder why. So we'll see what we get. A lot of these other witnesses still to come. A big problem here now, too, is we've been foreshadowed big problems with the forensics. All we've gotten so far is the solo cups in the Stop and Shop bag, and the piece of cocktail glass that got recovered. This is our evidence that has been taken into custody so far. And so we've already been previewed that there are some pretty big, pretty problematic challenges to really anything that they've done with the car, because if you're out there in the Sally Port waving your bioevidence around, like right there, unsealed, unsecured, in these terrible containers, it's very, very hard now to put any kind of credence on any kind of genetic evidence or something like that you might have pulled off of this car, because you've shown me on photo that you've got circumstances here that are conducive to contamination. I can't trust that this car has been secured, that it's been kept in a condition where cross-contamination isn't likely to happen. You showed me on a photo of you guys doing things that will lend itself to the possibility of cross-contamination. So a big, serious undermining from my perspective of any type of evidence like that they might be able to bring. But I don't know what else we have. We've heard little bits and pieces about stuff from the car computer. That seems like that's going to be pretty important. If somebody can tell me what the car was doing in the moments before John O'Keefe died, that's going to tell me a lot. Because if nobody saw anything, nobody heard anything, nobody heard a bang, nobody heard screeching tires, acceleration, anything like that, then it just, again, continues to be difficult to see how this could have possibly happened the way that the Commonwealth says that it does. I will grant you, people are inside, they're having a party, they're playing music, not necessarily going to hear all of the details of what's going on outside, but you would think somebody on that block would have. I mean, somebody in one of those nearby houses, if somebody is revving up their engine real high, accelerating fast, hitting something hard, you just expect that somebody would hear that in the middle of the night. So knowing what that vehicle was doing, what we can objectively say that vehicle was doing in the moments before he died, that's going to be very critical evidence. The taillight and what happened to this car altogether. These are going to be critical pieces of evidence. When a car hits a grown man, a large man, hard enough to kill him, you expect there to be some damage to that car. And we're seeing a taillight. We're seeing a busted taillight. Not real sure that is commensurate with what you would expect in a big impact event to a crumple zone part of the car, a part of the car that is literally made to fall apart when it makes impact, because that's just part of how it absorbs the force of the impact. It's part of how it keeps you safe there in the cab. Really doesn't look like the kind of damage you would expect to see. I'm going to want to know, how does this work where she only hits him with the right taillight? That's the only thing that causes damage, and he ends up as he does, ends up where he does, in the position he's in the condition that he's in. So that's really, I think, the main stuff I'm going to be keeping an eye out for at this point in time. I don't really care that much about more motive stuff. I don't really care. I feel like we've gotten the point on that. It doesn't seem like a very good point. And I remain concerned at the Commonwealth's kind of implied threat here that they're going to bring the kids on to testify about Karen's relationship with John, because that is just such a disturbing position to put those kids in. Even though I recognize they're a bit older now, it's not like we're talking about babies. We're still talking about young people who, this was a caregiver for them. This was somebody that they had bonded with, did have a good relationship with, and now being put in this position of being a hostile witness, of having to put her in the box, having to take on this very adult role, this parentified role of judging the relationship between these people and offering testimony about it, despite, being in a position as a kid in the house where you're not necessarily going to have the perspective on it. You shouldn't be up to speed on all of the relationship problems of the adults in the house. It's not your place. They should frankly be trying to keep a lot of that stuff from you. You're a kid. You should be able to be a kid and not have to worry about things, the same things that the grown-ups are worried about. So not clear that they're even going to be in a position to really know a whole lot. And yet we're going to potentially put them on the stand and put them in this position. I really don't like it. It is not something that strikes me as particularly healthy or in the best interest of those kids. Really, I mean, in most situations, there's a reason why in divorce cases, a lot of the times kids or parents will want kids to have the say. The kids will want to have the say. Kid at like 14 years old is pretty intolerable, right? They've got it all figured out. They know everything. I remember back then, sorry, Mom. Gotta cut myself some slack, because it's just part of the process that we all go through. But, you're young, you think you know everything, you have real strong positions. But you don't. You still have so much life experience and judgment that you need to gain. And so there's a reason why when maybe a parent wants to put a kid on the stand, point the finger at the other parent, or the kid may even want to do that themselves, courts very rarely allow that. It's just not looked positively upon to put them in that type of situation. So I really hope we don't go there, because I just don't care. I don't care anymore about any more of this motive stuff. I get what you're getting at. I get what you're trying to say. You're trying to say that, you're trying to say that relationship problems are the reason why it happened. Got it. I get it. I see. I understand. I don't need more. I definitely don't need to hear from these kids to get that point. So let's just, fingers crossed, let's move on from that. Let's scratch them from the list. Let's not have to go there. If we're going to have to start making decisions about priorities and who really needs to be called versus who in here is just extraneous fluff that doesn't necessarily need to be brought in to repeat the same details that we heard from everybody else. We heard from 12 firefighters, for heaven's sake. Like, did we really need to hear from every single one of them, every single angle on what they saw. I mean, it's overkill. You don't have to do that. You can just call the one or two that have the facts that you need to put in and call it good. If the defense has an issue with something that somebody else had in their report or whatever, or they want to hear from the rest of the firefighters, then great, let the defense call them. But you, the prosecutor, don't need to do that. Nevertheless, we're getting what we're getting here as far as a strategy for Mr. Lally. And it really does seem to be a dump. I mean, it's just a dump of everybody who wrote a report in this case, everybody who talked to the grand jury, everybody who was in the house, et cetera, et cetera. So don't necessarily have a whole lot of hope that when it comes to the list of, what is it? Let me count here. Approximately 18 state police. No, 17, 16, about 16 state police. Do we need every single one? I really doubt we're going to need every single one. Every single one of these guys has something unique and individual that only they can testify to. I doubt it, but I bet we're going to probably hear from all of them. So we'll see. We'll see. We'll see. The phone. Are we ever going to close the loop on this phone? I'm still just so perplexed by this phone because the last we heard was that Carrie Roberts put it in her pocket. She saw the phone under John and she put it in her pocket. What happened to it? Trooper Proctor said in his report he got it at the scene, but it's very vague. That's a very vague report. You got it at the scene. Well, you got it at the scene when and at what part of the scene? It's like he wrote it to make it sound like, well, right when I first got there, I recovered it. But just none of those circumstances are fleshed out at all. I don't know if this is when you went inside and talked to people. I don't know if somebody came out and gave it to you. Was Carrie there at the same time that Michael Proctor was? Did it come from Carrie or was it given from somebody else? Did Carrie give it to somebody else to give to Michael Proctor? I'm very, very perplexed by this phone. And a big reason why is because of that obscurity about what happened to it. If what happened to it is real clear and on the up and up, why wouldn't I already know? Why wouldn't you just tell me? It went here, it went here, it went here. This is the chain of custody for it. So it seems very strange. It seems like that's trying to be obscured. And I, at this point, am just left to remember that testimony with Jen McCabe about the phone calls that she was making in that 12:30 to 12:40 in the morning time frame, call after call after call that were all being unanswered. And yeah, I mean, I can certainly see an interpretation of that evidence where they're looking for the phone. They're trying to find the phone. Couldn't find the phone. And what were they going to do if they got their hands on the phone? That's what I want to know, because if they did get their hands on the phone, if Carrie Roberts gave the phone to one of these people, what were they going to do with it? Were they going to try to get in it? Were they going to try to get in the phone? Were they going to succeed at getting in the phone? I'm really fascinated by this phone. I just really, really want to know what the situation is there. Carrie Roberts says she saw it on the ground underneath him. Nobody else saw it, which I find a bit peculiar. You have first responders over there who are dealing with him. They're handling him. They're moving him around. They're getting him on the stretcher, getting him in the ambulance. Where is the firefighter, the paramedic who saw the phone? Where is that person? It's hard to put a lot of weight on that, especially when Carrie Roberts, while she did seem like a pretty good witness for the Commonwealth, at the same time, we already know she saw stuff that wasn't there. She saw the grass underneath John O'Keefe when they moved him, but that wasn't there. We saw the photograph. He was not in grass. He was on packed snow. We heard all the testimony about having to blow away the snow in order to get to the blood samples. They had come out of his injuries and kind of trickled down in the snow, and they had to blow the snow off to get it. So we know it wasn't bare grass there. Is there a memory issue here? Is there something going on with what she remembered about this phone? I don't know. Looks like they're still waiting to go into court. So a little bit of a late day again today from Judge Bev. I guess this is the only day we're getting this week. So hoping that we might make some kind of progress. If the Commonwealth had one of these strategies that is related to the theatrical sort of component of a trial, the fact that this is a presentation, there is a drama to it, there's a structure to it that works a lot like a show does, then timing matters and making impressions matters. Everybody, I'm sure, knows the primacy and recency principles, the idea that people tend to remember best the things that they heard first and the things that they heard last. And so what you do with that in a trial is you structure your evidence and your questioning in a way that your strongest points hit at one of these first or last moments. So the very first thing you say to a witness, the very last thing you say to a witness, or in this particular case, what's the last thing that the jury is going to be left with when they go on break for several days? This is an opportunity for the Commonwealth to leave them with something very strong to be simmering over, to help them form their impressions, because it's going to be the most recent thing that they've heard while they're sitting on the case for an extended period of time. But so far, the Commonwealth hasn't been very good at doing that. There's really only been one time where I thought they really pulled that off. And it was...
So can I see it sidebar?
It was when they left us with that picture of the taillight right at the end of the day, close the day, and that's what we were seeing was that body cam video from I think it was Sergeant Good, who went out to the house to do the welfare check. That was a good move by the Commonwealth. You close the day with that piece of evidence. You can't necessarily see all that clearly what's going on with the taillight, but if you squint at it pretty good, you can tell there does look like there's something different on the left.
Versus Karen Reed. Can I have counsel identify themselves for the record?
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Elizabeth Below.
Good morning, Ms. Little.
Good morning, Your Honor. David Unity for Karen Reed.
Good morning, Ms. Giannetti. Good morning, jurors. Before
You are unmuted.
I just want to mention that Attorney Jackson is not here today. Please don't consider that in any way. Certainly don't hold it against Ms. Reed for him not being here. Just don't consider it at all in your deliberations. So I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here? Everyone said no. Thank you very much. All right, let's bring Mr. Higgins in, please.
All right, so we're
And Ms.
getting Mr.
Giannetti, you'll be
Higgins back.
taking over?
I will, Your Honor.
Okay.
So much for that one witness being done in a day. And yeah, if Mr. Jackson's not here, then Mr. Yannetti is going to conclude. And that will be interesting. We get a little counterpoint in styles. And I have to say, I'm a big fan of Mr. Yannetti's style.
Truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
Good morning.
Good morning. Proceed, Your Honor.
Yes.
Sir, you provided to investigators what you claim were the complete text exchanges between yourself and Karen Reed and yourself and John O'Keefe, correct?
What I provided was the complete, I
let them know that it was a complete exchange between myself and the defendant. And I said that I may have had other text strings at other times with Mr. O'Keefe.
I'm going to proceed to ask you a series of questions which call for a yes or no answer. Can we agree that you'll answer yes or no to those questions?
If I can answer yes or no to the best of my ability, I will.
All right, I'm going to
Judge
keep the
Bev
question very simple,
reaching
sir.
for that mic.
Okay? You did not provide to investigators any other text messages between you and anyone else.
That's correct.
In September of 2022, you were served with a preservation order for your phone, were you not?
Yes.
After September of 2022, you never received anything in writing that canceled or lifted that preservation order, correct?
That's correct.
After September of 2022, you made the decision to dispose of your phone without consulting anybody about the decision to throw out your phone, correct?
Yes.
Before you threw the phone away, you did a factory reset of it, did you not?
No, I did not.
Well, you've previously testified that you testified in another proceeding on June 1st, correct, of 2023?
Yes.
Prior to that June 1st testimony, you met with some people and gave a statement on May 5th of 2023, did you not?
I did meet with them. I don't know if that was the date.
Okay. It was prior to June, correct?
Yes.
All right. May 5th doesn't sound wildly inaccurate, does it?
No.
And when you met with those people on or about May 5th, we'll say, or whatever date it was prior to June 1st of 2023, you told them that you did a factory reset of your phone ending in 5421. Did you not?
I don't recall that. No, I don't recall making that statement.
You don't recall what you said about the factory reset during that interview, we'll call it, in May of 2023, correct?
That's correct.
May I approach, Your Honor?
Yes.
Oh, Yannetti is just so clean. He's just so tight with his facts. This is great. This is how you do it. Already getting these nice, tight, clipped yes/no answers from the
Direct your attention
witness.
to the first highlighted line there, sir.
Why don't you give him a second?
If you read that silently to yourself and look up at me when you're done.
He is giving him a second, Judge. Good Lord. You don't have to run everything. He's telling him what to look at so he doesn't read the entire thing. Yeah, just surgically precise with these facts. And that's the key. You got to know the record in and out, every detail. What did he say at what point, when, so that you can be ready like this to come up and put the document under his nose and show him this is where you said it before, because that fact matters. A factory reset before you cut the SIM card? Yeah, you're really, really trying to hide what's on that phone. Now, could be legitimate if you're going to throw it away, but still.
Having read that document, sir, does that refresh your memory about telling those people in May of 2023 that you did do a factory reset of your phone?
That's not accurate. I did not tell them that. And I also didn't tell them that I saved texts with my father.
All right, so your testimony
Not
is
accurate.
that they got it wrong, correct?
My testimony is I didn't make those statements.
Your testimony is that they got it wrong, yes or no?
Objection.
Sustained.
Well, in any case, you took the SIM card out of your phone, correct?
No, what I testified to was that it's,
Did you take the SIM card out of your phone, yes or no?
I don't know.
Did you testify that that's what you do when you get rid of phones, sir?
What I said was that might have been the extent of it if I was to have done that.
And you either cut up the SIM card or ripped it up, correct?
I believe what I testified to was
I'm
I
not
would
asking
have,
you what you testified to. I'm asking you today, did you either
did
cut
you
up
do?
the SIM card or rip it up?
cut it up or broke it.
Cut it up or
And you
broke
will
it.
agree with me that cutting up or breaking the SIM card destroys the SIM card, does it not?
The card itself, yes.
That would have been the purpose in terms of cutting it up or ripping it up, to destroy it, correct?
Well, so nobody else could use the
Yeah,
phone.
that's correct.
Well, that was my next question. But
In another phone.
But the purpose of cutting up or ripping up or the SIM card is to destroy the SIM card, is it not?
Yes,
And you wanted to make sure that somebody couldn't put that SIM card in their phone and potentially access your data, correct?
no, that wouldn't be the reason why.
Okay. Well, we already talked about the fact that you testified under oath on June 1st of 2023, correct?
Yes,
And you were under oath when you were testifying on June 1st of 2023, correct?
yes,
You swore to tell the truth.
yes,
You raised your right hand.
that's correct.
And June of 2023, June 1st of 2023 was about a year ago, correct?
Yes,
It was about a year closer to your throwing your phone away, correct?
yes,
And in that testimony that you gave in June 1st of 2023, did you say the following, quote, "I made sure that somebody couldn't put it in their phone"?
Love this.
yes, I did say that.
In fact, by either cutting up or ripping up your SIM card, you also knew that that SIM card couldn't be put back in your phone either, correct?
Yeah, I believe that would be correct.
And you'll agree with me that you took that destroyed SIM card and put it in a trash bag, did you not?
I believe it went in a trash bag, yes.
Well, you used a
It
passive
went in
voice.
a trash bag.
It went in a trash bag. Did it fly out of your hand unexpectedly into a trash bag, sir?
No, sir, it would have been disposed of with the phone.
No, I understand.
Been
but
disposed
are you
of with the
reluctant to
phone.
say that you put it in a trash bag, sir?
Objection.
Can you answer that? Are you reluctant to say that?
No, Your Honor, I put it in a trash bag. Or with my
And
trash.
then you also took your phone, now without the SIM card, and you put that in the trash bag too, did you not?
Yes, sir.
Then you drove to a military base and you threw both the destroyed SIM card and the phone into a dumpster, did you not?
Well, I was cutting through the base, and I believe how I
Did you
testified
drive to a
was
military base, sir?
I was cutting through a base,
Did
yes.
you drive to it?
Yes, sir.
And then you put both the destroyed SIM card and the phone itself, which were in a trash bag, into a dumpster on that military base, did you not?
Believe that's what I did, yes.
And as you were driving away,
Great job,
you
Unity.
knew that that destroyed SIM card and the phone would be gone forever, correct?
Yes, I threw it away.
And before you drove away, you did not transfer anything from your old phone to the new phone, correct?
That's correct.
You lost all of your photos on that phone, did you not?
Whatever photos I had on there, I did, yes.
You lost all your videos on that phone, did you not?
To the extent if I had any.
You lost all of your other text messages besides the ones that you had with Karen Reed and John O'Keefe, correct?
Contacts.
That's correct.
And you knew that you did have text messages on that old phone with Kevin Albert.
He's a friend, most likely.
You also had text messages on your phone with Nicole Albert.
Most likely, yes.
And you had text messages on your phone with Brian Albert.
Yes.
It was important to you that no one see those text exchanges that you had with those three members of the Albert family.
Objection.
I'll let him have it.
No, sir, that's not true.
You took no steps to preserve those text messages, did you?
That's correct.
You did not ask your friend Matt Kelch, the agent, to help you extract those text messages, did you?
That's correct.
And when you went to that machine, you did not extract them yourself, did you?
He walked me through it. I did do the extraction.
You did not extract the 3 strands of text messages with Nicole Albert, Kevin Albert, and Brian Albert to preserve from that machine, did you not?
No, I did not extract those.
So the only place you knew they existed was on your old phone, correct?
Yes, that's correct.
The same phone that you put into a dumpster on a military base with a SIM card removed from the phone and destroyed, correct?
Well, I did throw the SIM card and the phone on the military base.
Right, and the SIM card was destroyed. You've already testified to
I
that.
said to the extent of if I did that, I would have done that.
And
To the
we're
extent I
talking
did that,
about
I would have done that.
the actual phone that would have had your text messages, again, with Brian, Nicole, and Kevin Albert, correct?
Yes, because the motion was denied.
Well, you've already testified, sir, earlier that you never received anything in writing that either canceled or lifted the initial preservation order, correct?
That is correct.
You knew when you were throwing that phone and the destroyed SIM card in the dumpster that from that day forward, no one would ever be able to access the content of what you and Brian Albert had discussed by text messages on your old phone, correct?
Anybody.
I have nothing further.
Mr. Lally?
Very powerful.
Thank you, Your Honor.
From Mr. Yannetti. Very powerful. God, he's good.
Morning, sir.
Good morning, sir.
Yes, because the
If I
motion
could
is
take you back,
denied is a
just
terrible
for a moment
explanation.
January 29th, early in the morning, you're pulling away from the Albert home, correct?
Yes.
And you had plow down in the front of your Jeep Wrangler, is that correct?
Initially, it was still on the ground, yes.
About how long distance again was that on the ground before you pulled that up?
Maybe a foot.
And with relation to the curb, specifically in front of the area with the flagpole and the fire hydrant, how close to the curb were you when you were pulling away from the Albert house?
I believe I looked both ways. There was no vehicles coming in either direction. I pulled out into traffic, and because that's a one-lane road, if there's no other vehicles, I'd be more to the center of that road.
Now, maybe a silly question, but with reference to the front of your Jeep Wrangler, that didn't have any red plastic pieces or anything like that on the front of it, correct?
At what time? At what point?
At any time.
No.
Looks like a nice,
And that's the same Jeep Wrangler that you then drove to the Canton Police
Linen
Station
blend,
immediately
maybe?
after?
Directly from there, yes.
And then you drove that same Jeep Wrangler back to your home in West Roxbury?
Yes.
And then you drove that same Jeep Wrangler back to Fairview Road the fall later on that morning?
Yes.
And then you drove that same Jeep Wrangler from Fairview Road to the Canton Police Station again later that morning, correct?
Yes.
Now, the text communications between yourself and Ms. Reed, again, who initiated those?
The defendant did.
And that was on January 12th, 2022, correct?
About 8:23 in the evening, I believe.
Now, with reference to that, what she claimed happened in Aruba, that was something that she mentioned to you via text, correct?
The incident itself, I believe, was through text, but I believe the actual location was when she had stopped by my place in West Roxbury.
But so that's to my point. So, sir, with regard to the incident itself, she referenced that both via text and in person to you as well.
Yes, that's correct.
And the kiss that she planted on you in the garage at Mr. O'Keefe's house, that was again something that she mentioned both in text and verbally in person. Is that correct?
Yes, that's correct.
Now, as far as the ghosting that you were asked questions about last Friday, there were some text messages between you and the defendant on January 19th, correct?
What was the date? I'm sorry.
January 19th.
19th?
Yes.
Yes.
And do you recall if there were any text messages between you going either way, between yourself and the defendant, between January 19th and January 23rd?
I think there were, not 100%.
Madam Mayor Pro?
Yes.
Need more of these texts? Really? Do we really need more of
I'm going
them?
to show you what's been marked as Exhibit 104A. Direct your attention to back there, specifically the back page, but a little bit before that.
What are the
If
odds
you
this
could
is a
just let me
text
know
we
whether
didn't
or not
already
any
read on
text
direct?
messages between yourself and the defendant misreads between January 19th and January 23rd.
Yes, looks like the 19th and the 23rd, both text messages.
But in between those dates, and what I'm asking about is January 20th, January 21st, January 22nd. There's no text messages on any of those dates, correct?
I don't see any.
And then as far as between January 23rd and January 28th, January 28th is when you texted her while you were both within the waterfall, correct?
On the 28th, yes.
So between the 23rd and the 28th, so on January 24th, January 25th, January 26th, January 27th, you didn't send any text messages to her, you didn't receive any from her, correct?
I don't believe so, no.
And then beyond that one text message that you testified to on the 28th, the next text message you received from the defendant was in regard to John being dead on the 29th, correct?
Yes, that's correct.
Now, you asked some questions about these text messages and whether or not you discussed them with various people. Did you discuss those text messages with anyone?
Not to my knowledge, no.
Why not, sir?
To be honest with you, I mean, on a personal level, I kind of keep things to myself. I was a little embarrassed. Wasn't really proud of them. Kind of maybe didn't show me in a good light with respects that I was John's friend.
And so with regard to that text on January 28th that you had sent her in the waterfall, she didn't respond as she was in the waterfall with her boyfriend, Mr. O'Keefe, correct?
That's correct.
Now, if the defendant did not have a boyfriend, wasn't dating Mr. O'Keefe, would you have been interested in pursuing anything further with the defendant?
I can't say. I don't know.
What, if any, reservations would you have based on the conversations that you had?
Just everything was so out of left field. I just found it hard to believe.
Now, with reference to going to the Canton Police Station after Fairview Road and moving the vehicles around, which is closer to the Canton Police Station? Your home in West Roxbury or the home on Fairview Road?
The home on Fairview Road would be.
And with the impending weather, why was it that you went to the Canton Police Station to move the vehicles around on that occasion?
He already told us.
Because as I stated before, if I
plow.
didn't do it then, I would have had to come back in the morning. And I knew the weather was going to be getting worse. I knew that I
you
had a
didn't
long
do
day.
it
I had been in
before you went and
New
started
York.
drinking
I
and
had been
driving
out
for
the
the
night
night.
before in New York, and I just thought it was best to get them moved at that point.
Now, you were asking questions on Friday about a phone call or something in a call log from about 2 o'clock or 2:22 in the morning of January 29th. Do you recall that?
I recall the questions, yes.
And you have an iPhone, or you had an iPhone, is that correct?
Yes.
Now, when you make a call on an iPhone, as you sort of place that call, you hit the button, there's sort of a timer that comes up and it starts counting off seconds as the call is being connected, correct?
I believe so.
Okay.
I'll allow it.
And so seconds are ticking off while the call is being connected, correct?
I believe so,
And
yes.
if a call is connected, then it starts ringing, and unless someone picks up immediately, there are further seconds that are ticking off on an iPhone while that call is ringing through, correct?
I believe so.
The objection sustained is to the phone.
The clock starts while the phone is
You were
ringing.
asked some questions about a
That's supposed to be the call log. I
callback
doubt
between yourself
that.
and Brian Albert around that time frame. Do you recall that?
Yes.
And you were trying to explain sort of what your answers were in that prior proceeding in reference to this, correct?
Yes.
What, if anything else, did you want to explain to the jury in regard to that?
Objection.
In that form, I'll sustain.
Yeah, bad question.
You were asked some specific points as far as your testimony in the prior proceeding, correct?
Yes.
What, if anything else, did you say in reference to that in the prior proceeding?
Objection.
Sustained as to the form, Mr. Lawler.
You don't get to invite him to just say whatever he wants to
Did
the
you ever
jury.
speak with Brian Albert at 2:22 in the morning on January 29th?
No, I did not.
Do you recall making a call or receiving a call from Brian Albert around that time?
No, I do not.
You were asked some questions on Friday regarding key card access within the Canton Police Station, correct?
Yes.
Now, as far as that door that you utilized, you would testify on Friday that you would sort of park down towards the back and then come in through the Sallyport area, is that correct?
So I believe I was referring to one of the two Sallyport doors.
And that was sort of your cut through in order to get to your office.
Yes.
Now, with reference to that particular area, as far as going in and out from the parking lot of the Sallyport, does the key card, you have to swipe the key card in order to go in and to go out?
So sometimes if you're close to the door, maybe having a conversation with somebody, it could activate the key card itself. But physically, if I'm going into the door, I would take it out and I would swipe it. I would hold it to the card reader. Some are more sensitive than others, is what I'm trying to
So
say.
some of these swipes are
And
just because you
similar
happen to be
when you're going
standing
in, when
there.
you're going out, does that require sort of swiping or using the key card in order to go outside?
So there are some doors that you need to swipe out of, and I believe the booking room and the Sallyport itself are doors such as those.
May I approach?
Yes.
I'll show you a document of place 149. If you could just take a look at that and look up when you finish. You recognize that, sir?
Yes.
Is that the same document that was essentially the same document that was placed before you on Friday?
Yes.
And that's a 167-page document encapsulating different key swipes within the Canton Police Station on January 29, 2022, correct?
Yes.
And from those 167 pages, at least on that first page, does there appear to be about 27 entries there?
Yes.
And so from 27 entries over a course of 167 pages, that'd be somewhere north of 4,500 entries within those 167 pages. Does that sound right?
Well, I went to public high school,
He's
but I'll
gonna
take the
need
word
a
for it.
calculator for that.
Would it surprise you
Mr.
that
Lally.
there are 18 entries within those 4,500?
So not what would surprise him. Ask the question differently, Mr. Lawler.
You know that there are 18 entries that contain your name within those records?
Objection. Another question.
No, I'll allow that.
Are you asking me if in the 167 pages, there's only 18 entries with me?
Yes.
I did not know that, no.
Would that surprise you as far as your, well, let me rephrase that.
Well, so then when
Now,
else
with
is he at
respect to
CPD?
your travels around Canton Police Station on that particular day, would you quarrel with 18 entries as far as where you went and what you did in Canton PD that day?
No, in and out, nope.
Now, sir, with respect to your phone, you were provided notification in regard to a preservation order in regard to your phone sometime in September of 2022, correct?
I received a subpoena on September 30th, 2022.
And that was in regard to a hearing in which counsel for the defendant was seeking your physical phone as evidence, correct?
Yes.
And is it your understanding, or were you informed after that date, sometime in early October of 2022, that that motion had been denied?
So I believe it was October 21st of that year, I was made aware that that was denied on actually October 5th.
Are you aware of a 30-day period by which a defendant has to file some sort of notice of appeal of a motion?
Objection.
I'll allow that.
I know typically there's appeal periods. In this particular sense, I wasn't familiar with the preservation order itself. What a preservation order was with respects to, that was kind of all new to me. Usually in an investigation that I'm conducting, it's a search warrant, I take the phone. I don't ask people to preserve it through a court order, if that makes sense.
And so when was it that you disposed of your phone?
It was about 2 months after that,
And why was it that you disposed of the phone?
because it was beaten, it was broken up, and I had already had a new phone, and only explanation is I threw it away. That's it.
And didn't save anything at all.
Now,
Didn't transfer over the old
Beyond sort
stuff.
of this case, what if anything else was going on with reference to your personal phone that led you to want to get rid of it?
So in July of 2022, I had a target of an investigation I was working who alleged that he called me on my personal cell phone. And when I questioned him as to the fact how he obtained my personal telephone number, he told me that his girlfriend had obtained it off of open source internet, which I later confirmed that number was out there.
What, if
It
any,
was out
concerns
there.
did that raise for you, sir?
Well, I had a lot of concerns, and so July of 22 is when I probably started thinking about, you know what, I got to get rid of the telephone number itself.
Yeah, you can
And a
do
lot
that
of the work
without getting
that
rid
you
of
were
all
doing,
of
at
the
least at
data.
that time, was undercover work. Is that correct?
Before this case right here, yes.
Now, as far as the SIM card that you're talking about, do you have any specific memory of doing anything with that SIM card?
No, and that's how I testified in that other hearing, that to the extent of what I would have done is I would have cut it up or broke it. And the concern would be that to my understanding, that's not holding any photos, that's not holding videos, that's not holding my contacts, it's holding phone information itself.
And as far as photos or videos or what, if anything like that, did you even have on the phone?
I didn't have much in the sense that I'm divorced. I don't have kids. I didn't have the typical memories that somebody would have had on their phone that they wanted to preserve. They were more like the text messages with the defendant where it would be a drink glass at a bar, food, something along those lines. I had more of a connection to my work phone and more of a value to my work phone than I did my personal phone.
Now, as far as that military base down the Cape, how often, let me ask you this, when you lived at the residence in Barnstable County, what would you do with your trash down there?
Well, if I was going through and I had trash or some recycling and I was either getting gas on the base or hitting the duty free, I would occasionally toss a bag of trash in one of the dumpsters there.
Sure you
or
would.
if I forgot, I would throw it out when I got back to my other property. And at the time, at one point, I was living in Canton and I had the house there and then I sold it and then I had the in-law I was renting. So I had other options to throw things away.
Do you have trash pickup at your residence in Barnstable?
No.
So if you were to throw away anything, any sort of trash, it would have to be either at the base or at one of your other homes.
It would be somewhere else.
And so with reference to the phone and the SIM card, if you even did you drive specifically to the base to throw your phone away or were you throwing it away with other trash?
It was just with other trash.
You were shown some call logs or some toll records or something to that effect last Friday with respect to calls that you had made or received around January 29th, 2022, is that correct?
Yes.
And was that anything that you had specifically preserved and given to the troopers, or that was something that someone was able to obtain even without your phone or without your SIM card, correct?
That's correct.
Can I approach this retrieve now?
Yes.
Yeah, which is how they know that you called Brian at 5:22
One
in
moment,
the
Charlie.
morning.
Yes.
Because of the call records. Because you couldn't get rid of those.
Well, sir, going back to January 29th, pulling away from the residents on Fairview Road, you didn't see anything on the side of the road, is that correct?
Absolutely not, no.
Absolutely not.
And what is it that you would have done had you seen anything, or had you seen Mr. O'Keefe on the side of the road
Object.
on January
No.
29th?
I've spent my whole life between being a firefighter, working in the profession that I work now, being a tactical medic. If I had saw John O'Keefe on the side of the road, I would have done something to make a difference.
No further questions.
Yes. Just feel free to stand up and stretch.
Okay, so poor lonely guy doesn't have any photos or videos on his phone. I'm sorry, your contacts are what you poured over to your new phone because nobody remembers phone numbers anymore. I'm gonna date myself probably if I talk about remembering way back in the day when you had the long list of phone numbers in your head, all of your friends, your family, your just the calls that you needed to make on a frequent basis. You had all those in your head. No more. That does not exist anymore. And people don't remember their own phone number anymore, let alone your mom's phone number, your sister's, your neighbors, your friends. That's what you poured over. That's what's an enormous pain to lose when you lose an old phone. You didn't transfer any of that over. That is sketch as hell. Sketch as hell. And it's because I'm supposed to believe that you use your personal phone for undercover work. That's the explanation. You use the personal phone for undercover work. I'm not buying that. I'm not buying that. You're using all of the official stuff for your personal business. You drive around on your personal business in the work car. No. No, I'm sorry. I don't believe that. I don't believe this story at all. I'm perfectly fine with you wanted to change your number, but you can do that without trashing your phone and not porting over your contacts.
Sir, you testified that a prime motivator of you to get rid of your phone was a July 22nd call from a target of an investigation that you were working on.
I never said it was a prime motivator.
Was it a prime motivator?
No, what I testified to was the phone number was what I was concerned about primarily.
Right.
Didn't have anything to do with the phone.
Oh, you did not change your phone number on July 22nd, correct?
July of 2022? Is that what you mean?
The date that you received a call supposedly from a target of an investigation you were working on was July 22nd of which year?
So it was, I believe it was July 25th of 2022.
July
I was so
25th.
concerned that I reported it to my supervisor.
Right, but you did not change your phone number after that for quite a while, correct?
I believe it was September.
Okay. So for those months, you kept the same phone number and kept the same phone, correct?
I did.
And September happened to be the month that you received the preservation order from this court, correct?
September of 22, yes.
Right.
Yeah.
Now, with regard to the text exchanges that you had with Karen Reed, you testified that you were embarrassed about them?
I wasn't proud of him.
I think your word was embarrassed, correct?
I can agree to that. That's fair.
Well, you already testified to that, right?
I believe that might have
5
been
minutes ago?
a word I used, yes.
And you also explained that you would keep things like that to yourself, correct?
That could be something, yes.
However, you would also agree with me that while they were going on, you told your boss about that text exchange, correct?
Well, I told her about the kiss.
Do you deny telling your boss about the texting that you were doing with Karen Reed?
I don't know if I specifically recall that, no.
But you don't deny it, sir, correct?
It's possible that I told her about
I
that.
told her.
I'm not going to deny it.
All right. And in any case, those text exchanges were preserved. You preserved those before disposing of your phone, correct?
Correct.
And with regard to the other text exchanges that you did not preserve with the Alberts, including Brian Albert, are you familiar with the term consciousness of guilt, Mr. Higgins?
Objection, Your Honor.
The objection sustained.
I don't know why. He's a cop.
Yes.
He knows perfectly well what consciousness of guilt is. But it's fine. That's argument. I suspect this is one of those argumentative objections that the judge is sustaining. But yeah, I think they should let him ask that. You know what that is.
One
You
more
know
thing.
how that
With
would look if
regard
this was
to
your target.
The date that you changed phone numbers on your phone, you would agree with me that was September 29th of 2022?
When I actually changed the phone number?
That's what I just asked.
Yeah, yes, I also got a new phone, yes.
Okay. September 29th of 2022, you changed your phone number and got a new phone. And then September 30th, the next day, you were served with the preservation order, correct?
I got the preservation order on the 30th, that's correct.
Nothing good.
All right, Mr. Higgins, you are all set, sir.
Thank
You
you,
are
Your
all
Honor.
set. There we
Thank
go.
you.
There's my cue. Now I know what's going on.
All right, Mr. Lally, who's your next witness?
May we approach?
Sure.
That sunny message from the judge. Oh man, Yannetti is such a killer, man. I just love him. I just really love his style. He is on it. He knows his record. He knows the specifics of what the people said. I mean, he had him trained, right? Mr. Yannetti or Mr. Jackson, they've been able to dance around him a little bit because he doesn't always have those details exactly right. And so they're able to push back and gain a little bit of breathing room from his question by pointing out, calling into question whether he has gotten it exactly right. And then if he hasn't, that buys them a little bit of space. Not with Mr. Yannetti. He knows exactly what is in that transcript, and they know he knows exactly what is in that transcript, so they're not even going to fight him on it. Are you going to deny that you said that? No. No, I am not. No, it's definitely possible. Why is it possible? Because you're here asking me about it, so it's probably in a transcript.
First, we're going to take a
That's what you
10-minute
want.
recess.
You are unmuted.
All rise to the court, please. Follow me.
So we're taking the jury out, I guess, to discuss whatever is next. So are we arguing or just taking a break?
Thank you. You may be seated. Close enough.
All right, so Mr. Lally, your next witness is a juvenile?
Yes, Your Honor.
Oh,
All right, so there's a
no.
specific media order that there'll be no transmission of this testimony. Well, and by agreement of the parties, the child witness will be sitting in the courtroom, in the witness stand when the jury comes back in. And that's by agreement, Mr. Yannetti?
Yes, Your Honor.
Okay, all right, so 10 o'clock or so we'll come back out?
Football rise.
Oh boy. So we're getting kicked out of the stream.
Hey
The
there,
fan
Karen
is
Reed,
not
Trout.
even on. Oh, they're doing it. They're doing it. They're calling those kids. Gross. That's really all I have to say about that is gross. I mean, so unnecessary. You're going to put kids through this. Yikes. Yikes. Really all I have to say about that, it's a big black mark against them, in my view. Even without seeing the testimony, even without seeing it. I saw from the statement of facts. Let's go ahead and pull it up. This is why we're going to put kids through this. From the statement of the case. Let me go ahead and share that. Right here. Now let me go through and find them. So this statement, as I understand it, by the way, is just basically a summary of what they presented at the grand jury proceeding. So it was essentially Michael Proctor's case. This is Michael Proctor's case that he put together, that they presented to the grand jury, and then summarized basically everything in this statement. So here, they were both interviewed on February 22nd. They lived with their uncle, the victim, for approximately 8 years following the passing of both of their parents. 8 years. 8 years they spent with John O'Keefe. I'm going to make myself a little smaller there. 8 years they spent with John, and then the last approximately 2 would have been Karen. So both children indicated that the victim and the defendant had started dating approximately 2 years ago after having dated sometime before in the distant past. They both indicated that the defendant would stay over their house on Meadows Avenue several nights a week. PF stated that the defendant and the victim argued a decent amount of time. PF recalled a recent argument over groceries and the victim expressing needing a break from the defendant. After that particular argument, the victim wanted the defendant to leave their house, however, she refused. PF indicated he had left the home on January 28th at 8 p.m. for a sleepover at a friend's house, was not present at the home overnight. Indicated neither he nor his sister had access to the Ring system, but believed the defendant did from the family computer within the home. Is that what this is about? This is about the Ring camera and the access to the computer. Okay, then I can cut you some slack for calling the kid. That's all you should be asking about. They argued a decent amount of time and argued about groceries. You should not be dragging the kid into this stuff. They don't know the ins and outs of the relationship. They don't know what normal arguments are. This is just so inappropriate. Argument over groceries, is that the motive? Is that the motive now? Is that why? Because all we just have is this general, maybe Karen didn't like John very much. Maybe John didn't like Karen very much. I mean, these are not motives to murder. These are toxic relationships. These are people maybe who aren't working well together. That is not motive to murder. You know how many bad relationships there are out there where people don't murder each other. KF indicated during her interview that the defendant and the victim had argued a lot toward the end, approximately 2 to 3 times a week. She further stated that approximately a week prior to January 29, she was sitting on the stairway inside the house while the victim and the defendant were arguing. Stated that she heard the victim tell the defendant that their relationship had run its course and that it isn't healthy. She stated that the defendant did not want the relationship to end and refused to leave the house. KF stated she had gone to bed approximately 11 on January 28th after her friend had left, was woken by the defendant at approximately 4:30 with the defendant screaming and acting frantic. Defendant ran into the victim's bedroom to receive KF's cell phone, and KF then began texting and calling the victim with no response. The defendant then had KF call Ms. McCabe and put the defendant on the phone with her. After speaking with Ms. McCabe, the defendant left the house and told KF to call Mr. Camerano to come and pick her up. KF indicated during her interview that the defendant changed her story several times while speaking to Ms. McCabe on the phone, with initially the defendant stating that she and the victim got into an argument and she dropped him off. So now we're going to drag the kids into the triangulation here, right? Triangulate Karen against her story, against her state of mind. We've already established Karen was frantic that morning, didn't remember that they had left the waterfall, didn't remember a lot of stuff. I mean, she was acting pretty frantic. But we're going to pull the kid in to testify to that, and then we're going to testify about this fight they had in the 3 weeks, about a week before January 29, they had a fight, and they're talking about ending it. Well, yeah, if you have concerns about infidelity within the last month, those are probably going to be getting fleshed out in the following weeks. This is just terrible. This is just terrible. That they want to bring these kids in to smear Karen, to assist in the smear of Karen. She did this because she wasn't happy with John because she's the crazy girlfriend. That's the case that I'm seeing so far, is that Karen Reed is the crazy girlfriend. I just don't know that I'm seeing that. I don't know that I'm seeing that. I've seen a guy with a drinking problem. This is what the Commonwealth has decided to show me about John O'Keefe, that he's a guy with a drinking problem and treated his girlfriend like a babysitter with benefits. Left her on New Year's Eve to entertain his kids while he goes in and gets drunk in the pool bar. So drunk that he's stumbling into the elevator, around the elevator hours later, when Karen sees something with one of the other guests that she doesn't like. This is not painting a crazy girlfriend picture to me. This is painting a picture of somebody who is upset by a boyfriend who isn't being particularly considerate, isn't being particularly generous, isn't being particularly grateful for the contributions she's making to his family. She's the child care. She's the child care. She's in that position now. I'm not seeing crazy psycho girlfriend in all of this. Those texts with Higgins, I'm not seeing crazy psycho in there. I mean, she could have gone crazy psycho with Higgins pretty easily. Didn't. Looked like she felt him out. Didn't like what she got. Walked away. Ghosted him. Not the nicest thing ever. Not psycho girlfriend stuff. And it's terrible because, yeah, it's going to put the defense in this position of having to question the basis for what the kids know and why they know it. Do the kids know that Karen thought that John had cheated on her? Is that information part of their processing when they're evaluating this fighting and stuff? You shouldn't be asking the kids that. You shouldn't be dragging them into this situation with this conflict. It's terrible. It's terrible. Because either they don't know the whole truth of the situation, which is better. Kids should never know the whole truth about these kinds of situations. They're too young to process it. Or they do know, or they need to know, or they have subsequently learned this information that's just going to tarnish their dad. That Karen thought he was cheating on her. Kids don't need to know that. Ugh, yikes. I'm going to update my banner here just so that it's clear what's going on. Oh, yikes. Yikes. Okay. So, I mean, that's it. That's the kids' testimony. That's why they're being brought in. I can understand. I understand there is some kind of controversy about the ring camera video, and an argument that some of it had been deleted, some part of it had been deleted. Don't know the details of that. The Commonwealth hasn't presented any of those evidence recovery people to tell me what they got, what they reviewed, how did they determine that some parts of it are gone, stuff like that. I don't know. It's not part of this trial yet. But I am aware that that is there in the background. I could understand calling the kid for the purpose of establishing Karen Reed had access to the ring system. If you're going to argue somebody deleted the video and you want to pin it on Karen Reed, then yeah, you need to explain that she had access. You need to establish that. This other stuff, terrible. It's terrible. Don't like that at all. Really don't like that at all. Who just randomly cuts through a military base? Who cuts through a military base? That's not a thing. That's not a thing. It's not a shortcut to go through the military base. You go through the security and flash your credentials. You have the slow. It's like slow in there. I just don't know that I am buying this explanation. It just happened to be there, so you just happened to throw it in the dumpster there. Not because it's secure. It's a place where you know perfectly well you leave garbage out on your street. You have abandoned it. Anybody can come and swipe whatever they want out of your trash when it's at the curb and use it for evidence purposes. You may have even done that yourself. You know that perfectly well, but you're going to have a hard time doing that on a military base because the access is far, far more limited. So unless, I don't know, one of the officers or one of the grunts that's there on base decides they're going to do a little casual dumpster diving, or unless the military police decide they're going to go get something out of the trash. Certainly your rando state police, your defense investigators, people like that, not going to be able to get onto that military base to get that phone out of the trash. That's why you would do that. The whole if I did it with the SIM card. I'm not saying I did do it. I'm just saying if I did it, I would have cut it up or broken it. Just saying if, but I don't know for sure. Look, that's your habit, your practice, your pattern, and that's what you do and what you did so that you can have confidence that you did it at this point in time. Or it's not, in which case, I don't know why you're even saying it if you don't remember it. You're just talking to fill space? Maybe you did? Or are you worried about what might be on camera? You know what's on military bases a lot is cameras. Now, it's going to be very, very difficult to get those cameras. In fact, I would doubt most of the time you're going to be able to recover surveillance video from a military base. I mean, TUI is one thing with the Department of Justice, TUI from the U.S. Army, the U.S. Marine Corps, going to be a whole other thing. There's going to be national security implications all over that. Oh, then you'd know where the cameras are, then you'd know how they operate. You just get a little bit too much information about the security system that they use there on that base. I got to think that's going to be pretty much a catch-all way to get out of having to do any kind of production in that situation. So I seriously doubt anybody is recovering video from the military base. But I gotta think you're worried about it, because that's why you're concerned. You're not sure if they got it. You're not sure if they recovered it. You don't know if they got the trash bag and got your phone and saw a broken up snapped SIM card. So you gotta cover your back that that's what you would have done. But you don't want to say you did it in this case, because you know that looks bad. Yeah. I don't know. Well, I guess we're going to have quite a long break this morning. I don't know if I'm going to have 3 hours worth of stuff to say here until they bring us back. Kind of doubt it. So I don't know, maybe we're going to pause here and come back. Unless you guys want to chit chat with me for that long. Boy, I don't know. I'll go ahead and see what we've got in the comments. We'll check in. Unhung Hero. Finally a stream about a trial and not Nick. Yeah, exactly. Enough said. Tina became a YouTube member. Thank you, Tina. Welcome. Thank you for supporting the channel. Farrell Drake, can the judge rush the defense's case clearly biased? So the judge has all kinds of discretion to decide the manner and order of the presentation of the evidence and to maintain control over the process, including the time of the process. So within some limits, yeah, she can. She can rush the defense's case. And really the limit on that is there's a constitutional right to present a defense that very significant magnitude. So you can't rush the defense to the extent that you impair their ability to ask important questions, to put on important evidence. There have been cases, now I don't know about Massachusetts, but there have been cases where, yeah, judges have said we're going to have a hard limit, 4 weeks for trial, and I don't care where you're at that point, 4 weeks, we're done, we're calling it off, and so the defense gets cut off in the middle of their case, because of course, you know, the Commonwealth doesn't have an incentive to put on less of their own information to leave time for the defense to have a fair shot at putting on their case. So that has happened, and that's been reversed on grounds that seem, to me as a defense lawyer, pretty obvious. Of course, I get a fair shake at putting on my evidence, and you don't get to just arbitrarily decide this is how much time you get. You get the time you need for a constitutionally sufficient process. So if that fits within the time frame that Judge Bev wants to spend, great. But if it doesn't, your option here has been this entire time to move the Commonwealth along. You don't have to let them lollygag like this. The controlling the order and presentation of the witnesses does not just apply to the defense. So yeah, I think if she were cutting off the defense, not allowing them to put on evidence, witnesses that are important, that are material to her arguments, that would be a huge problem on appeal. Furious. I know his step data isn't in evidence yet, but his phone was registering steps 10 minutes before he was loaded up on the stretcher. Yeah, see, that's interesting. This is the kind of thing that I want to see. I want to know about because I know so little about this phone. I just know that yeah, they were able to get data from it. So what's the chain? Who did the extraction? Was this a law enforcement extraction or is this something that the defense did to get the health data? I don't know. But yeah, if the phone is moving around while it's supposedly underneath his body at the scene, really only two explanations for that. One, this app is trash and it's not reliable. Or the phone is not where Carrie Roberts said it was. And she's the only person that saw it there. The people that were there hands-on with him, the people that are there in the position to notice this stuff and who are going to be accustomed to working with police in that context to draw their attention to things that they need to be focused on, that they're going to need to recover. They didn't see it. Option number two is we got another problem with Carrie Roberts' memory here. That isn't where she found the phone. She didn't find it underneath him. She didn't put it in her pocket at that point. That's not what happened. Yeah, we'd love to know, and I would love to know what the phone shows about that. GPS, are we going to have GPS from the phone that can show us where has the phone been? GPS is a lot more precise than pinging. It's not going to get you within inches more than likely, but it's going to be precise enough to tell you the difference between lying out in the front yard and being inside that house. 20, 30 feet away. Should be within that range to be able to tell that. So that's going to be a concerning piece of information. If the phone is moving around, the phone is taking steps when he is clearly not. I don't know these apps. I don't know this data. I don't know how it picks up the data. I remember the older school pedometers when this kind of thing, this health watch kind of stuff was first being on the market. It was a situation where you have to, it's like a standard pedometer, you have to measure your stride. And then it takes an average and it will detect the movement from when you're walking, when you take a step. And so it does a math problem. It doesn't actually fix you at a location in space. But this was years and years and years ago. And there have been so many developments in the technology since then where GPS is integrated with a lot of these things. I've mentioned Strava before and Endomondo and Map My Run and these types of programs now that they interface with GPS systems. So they map you, they put you on a location. I don't know if the Apple Health data does that, if it measures your steps by doing a pedometer type of situation, or if it measures your steps by incorporating GPS, or perhaps both. I'm going to want to know that because that'll make a big difference. If it's a situation where it's like a standard pedometer and it just measures steps, okay, then I can see room for error in that. I could see a situation where, for example, people are doing CPR on the man. Okay, CPR is honestly kind of disturbing to watch. It's a sort of violent process. A lot of force being used. I mean, very common to break ribs and stuff during CPR. So I could see a situation if he's lying on the phone, CPR is being performed, the phone is moving, it's registering a movement, it could mistake that for a step if it's just using a pedometer type of calculation. But if it's using a GPS, it's got GPS integrated, no, that phone isn't moving. It's not moving. So it's going to be important to understand what exactly is this data? What does it mean? What are the limitations of what it can tell us? JT, I have a new goal in life, never to be cross-examined by Yannetti. Yeah, the guy's scary. He's scary. He's, I think, got the best of both worlds in many ways because he's a former prosecutor himself. I believe a federal prosecutor. So he has the experience with the aggression, getting up in a witness's face, confronting them, j'accuse, being on that position of j'accuse. I am accusing you. I'm comfortable of making you into the bad guy. The defense is often not so much in that position. You're dealing with witnesses that you have to kind of handle with kid gloves because nobody really wants you to be mean to a complaining witness. You don't want to make them cry on the stand. I mean, stuff like that. So it can just be a very different type of dynamic you develop as a defense attorney compared to a prosecutor. So he's got that aggression, but he has the ability to do an extremely effective cross-examination that, as I've said before, from my perspective, you don't get that a lot of the time as a prosecutor because so many of your cases, you're unopposed. The defense isn't putting on a case. They're just trying to undermine yours. They're just trying to poke holes in what you've been able to present. But they're not necessarily handing up to you a lot of ripe opportunities to sharpen your skills at cross-examining a witness, at getting information from somebody who isn't friendly to you, who doesn't necessarily want to give it out. So he's got both of those skills, and he's a force, man. He's a force. If I had a choice between these two lawyers, Mr. Jackson and Mr. Yannetti, which one is going to cross-examine me, I'm probably going to want Mr. Jackson. I don't think I want Mr. Yannetti. He's a bulldog. He's a fighter. Yeah, very intimidating guy. And very effective. If I were going to critique him, it would be that he does seem to kind of only have the one gear. He's got the bad cop routine. He doesn't necessarily have a good cop routine that we've seen. But that can also just be a little bit of his personality, of his presentation. He's Bostonian. He's like these guys. He's got that New England machismo kind of attitude. So Mr. Nice Guy just may not be his thing. That may not be natural for him, and that's maybe okay, but that's all I would say as a critique is, man, if you could build up that part of your game where you have the nice, sweet Mr. Yannetti who's gonna get you smiling and then stick in the knife. Oh, man, lethal. Absolutely lethal. I would be terrified. But very minor point. I mean, he's fantastic. I'm very, very impressed with him as a lawyer. That opening statement, I can't help but keep going back to that opening statement because it was such a power move. It was so well delivered, very well crafted. When you compare it to what Mr. Lally did in his opening, where he just meandered everywhere, roved over times and people and dumped names on us and really never told us that much about what the case is actually going to be beyond there are going to be witnesses testifying, which we already know. We didn't need you to tell us that. You're supposed to be telling us what they will testify to and how that is going to support your theory that Karen Reed backed her car into John O'Keefe and killed him. That's what you're supposed to do with your opening. You compare what Mr. Yannetti did to what Mr. Lally did, and Mr. Yannetti's argument was just so easy to follow. It made sense. It fleshed out details at an appropriate time. It gave you the background about who these people are, what their relationships are with each other, why we need to be skeptical about them. It was very easy to follow. So when I'm taking notes, I try to organize it. I try to organize it like an outline. You know, I try to I figure if these guys operate similar to how I would operate, when you do an opening statement, you basically have it outlined. You don't write a script. You don't write every single word out that you're going to then basically read to the jury. That's not a good approach. It's not flexible. The jury doesn't want to see you reading. They want to see you engaging with them, utilizing the information with them. Just basically not looking like this is something that you have a hard time remembering or have a hard time delivering. They want to see, you know, the facts, you have felicity with the facts. If the facts are on your side, you can present the facts, and it's going to present a picture that's consistent with your case. You don't get that by reading. So what you do is you outline. You basically have an outline of, these are the points I'm going to make. This is how I'm going to get through them. It gives you structure to what you're about to present to the jury, but it allows you to riff within that. It's like, kind of like jazz, right? It's a little bit like jazz, where you have the general structure of the song, you know what key, you know where you're going to be moving to, you know what the bridge is, you know how long, how many bars you're going to give to each performer for their solo, and then it's going to segue into the next guy and stuff. You have the outline, but the details get filled in during the performance, and then that's what gives you your magic, is what happens in those details. You know, when John Coltrane has his amazing solo at that one particular show, that's why they had the outline, but it's the magic of that moment that really lands. And so that's what a good opening statement can do, and that's how it works. You just get that inspiration from the setting, from where you're at, from the material that you're working with. You get to let it affect you and decide what you're going to focus on, how you're going to influence it, how you're going to present it, color it, and all that stuff when you're presenting it. So when I'm taking notes of the opening statement, I'm kind of assuming, if you're not like Mr. Lally, if you're actually giving me a pretty well structured opening statement, that's more or less how you put it together. You outline the points you wanted to make, and then I'm just going through and trying to recreate that structure. So when I take notes on Mr. Iannetti's argument, very easy to do that. Very easy to recreate, okay, this was his main point, and then he fleshed it out with these sub-points. Then he went on to make another main point. You can see how it all fits together. Very much in contrast to whatever Mr. Lally was doing up there with the just vomiting of names and no real helpful information. So, very impressive opening statement, very clear, very structured, and yet it did have that inspired type of feel to it, because he's not reading it. It's not something that he spent months scripting out specifically. He did it on the fly. He did it off the cuff. He knew what he needed to say, and he decided how he was going to say it in that particular moment. So excellent lawyer. I'm very impressed with him on this team. Tin Cat, Higgins just keeps getting worse the more he talks. Everything is vague, nothing certain, completely incredible. That's what was so cool about this distinction between Mr. Iannetti's approach and Mr. Jackson's approach, is Mr. Iannetti had a lot more luck at getting him to pin himself down on specifics. Mr. Jackson, he took that room to be able to explain, to wriggle out of the yes or no. Mr. Iannetti really didn't give him that space. And it's much more of a game of chicken. Challenged him head on. Who's going to blink? Mr. Higgins is the one who blinked on that cross, not Mr. Iannetti. But yeah, it's he's not been a good witness where stuff, yes, is vague where it shouldn't be, it's specific where it shouldn't be. Just this is the problem, I think, when you don't have a good explanation for your actions and your actions are problematic. If they're not trying to cover up the murder of John O'Keefe, there can still be other reasons why they'd want to know what was going on with the investigation, what was going on in Canton Police Department that morning. There are other reasons why he could want to be there. Is Brian Albert going to have work consequences because of this? Is he gonna have to be under some kind of investigation, some kind of administrative process, a review? I mean, I can see why you might be concerned about how this could fall back on your friends, especially if you're all out drinking and driving the night before, ending up at your house, and the guy is dead on your lawn outside of your party. Maybe a situation where you could be concerned about admin is going to be asking questions. Is there some kind of policy issue here with how people are to behave off duty? I mean, I would like to think there's a policy that cops shouldn't drink and drive. Cops shouldn't get to break the rules that they're out there enforcing against everybody else. I'd like to think that would violate a policy. Maybe this is what they're concerned about. Maybe there's Colin Albert being underage in the house, drinking with the older kids, the older cousins. Maybe we're concerned about that, enabling that. That's a problem. I can see other reasons why you would be concerned about this investigation could backfire on my friends, the Alberts, that aren't, I'm trying to cover up a murder. But you just open yourself up to that interpretation when you act shady like this, if you don't come clean and explain that. If you had a good explanation, look, I realize it was bad for me to do this. I realize I shouldn't have been keeping tabs on the investigation on my day off. Spent my entire day there after I'd slept for 3 hours, 4 hours the night before. I shouldn't have done it, but I was just concerned about my friend. I didn't want him having an IA problem. Kept my ear close to the ground. Had nothing to do with a cover-up. I gotta feel like that's a better explanation than what we're hearing now, which is we had butt dial. Now we have butt swipes of the key card. You stand too close to it and it will activate. That's not a security system that I can really imagine a police department leaving in place long term. You stand too close to it and the door is going to open so the person on the other side can get in. You ever take people into the Canton Police Department to interview them, suspects to interview them? Do you do that in the police department? Because if you do, you don't want a situation where the door could just maybe open because somebody is standing a little bit too close for it. Nobody's expecting the door to open. That's going to cause you security problems. And that's just even above and beyond. You're a police department. You need to be monitoring who is where, particularly with places like the evidence room, the booking, the place where there's access to information, items, stuff that is kind of critical to the case, the people. You can't have a situation where you can't accurately track who is going in and out of those areas. So if this log is not doing that, I just have a hard time believing that's how the system works, that a police department would tolerate that. You're going to fix the problem with the doors opening when you're not trying to open them. So we have butt swipes now on top of everything else. Yeah, it's just not good. It's just not good. The strange amount of detail, and yet not very much detail about this extraction that they did. I understand we can't maybe ask him what Matt Welsh told him, or Kelsch, what was the guy's name? Matt Kelsch. I don't know, his other friend who had access to the FBI building, who's got the expertise in the forensic cell phone examination, the extraction process. Can't ask him what Matt Kelsch told him for the truth of the matter asserted, but we can certainly ask him for purposes of its effect on his state of mind. That's a non-hearsay purpose. But either way, so we get this strange amount of detail where he gets to both present it as thorough and comprehensive. He provided all of the text messages between him and Karen and him and John, at least in this thread, with the assistance of Matt Kelsch. But he doesn't really know how he did it or how that worked or what prompts he was given or what steps he took. He gets to be knowledgeable enough about it to try to present it as thorough, but also completely ignorant about the details. Because I have to suspect that the details aren't, they're not going to be good. They're not going to be good. You did have to limit this extraction somehow. What are the parameters that you chose? How did Matt Kelsch walk you through that? How did you tell him exactly what you wanted to do? And it just all comes back to the bottom line for me. There is no way that Matt Kelsch told you that the best way to get these text messages to the police was to screenshot your phone, to do that yourself, give them this limited extraction. No, the guy is going to tell you the best way is to hand your phone over to the police and let them do the extraction. Of course, duh. So yeah, it's very difficult to put a lot of weight on Mr. Higgins's explanations here for these reasons. It's just problematic that it's so helpful to him where it needs to be, but conveniently vague. I don't know for sure if I did it with this SIM card, but if I did, then I would have done this because that's what I do, but I don't know that I can say that that's what I do. That's what I think I would do. It's not good. It's not good. Tin Cat, I bet they don't cross the kids, not relevant. Yeah, I mean, I'd be kind of surprised if they did. They're certainly not going to cross the kids in a hostile kind of way. You just absolutely cannot do that, of course. These kids are victims. These kids are not the perpetrator. These kids are not involved. These kids shouldn't be involved. So I don't think you're going to go out of your way to make it worse for them. But yeah, I think the point is there's not much that they're going to get anyway. What are they going to get? The kids had a limited perspective on relationship dysfunction between the adults in the home. Unless the kids heard Karen say, I'm going to murder John by backing into him with my car and then pretend that he got hit with a snowplow or something. This just is not it. This just is not it. So yeah, I think you're probably right. I doubt that they crossed the kids. Britt Cormier, just sitting here thinking how different this trial would be if those phone preservation orders had come out just one day earlier. Not one, but at least 2 witnesses rid themselves of phones just in time. Yeah, the day that the hearing is happening is the day that Brian Albert decides to get rid of his and then not mention it later. And it's the day that Brian Higgins decides to go change his number. Another pretty big coincidence. I suppose they could have hammered on that a little bit more with Higgins too, about the date, the coincidence of that date. Mr. Albert had a pretty hard time explaining that. Why that day? Well, I don't know. It was 3 weeks after my birthday. Yeah, no. That's not why you chose that day. That's not why you chose that day. That just happened to be the only good day that you had in all of this time to go to the phone store and upgrade your phone. It just happened to be this day was the only day you could do that. Well, maybe, but if that's the case now for 2 of you, that this is now the only day that you could go change your number. I thought that was a great point that Mr. Yannetti brought out, that this supposed call that broke his cover with his personal cell phone number is in July. It's 2 months later before you did anything about it. But that's supposed to be your explanation. This is now on par with the, well, my birthday was 3 weeks before. I got this call 2 months ago. That doesn't tell me why you chose this particular day to do it. And I do find it hard to believe that you would be unaware that this process was going on. This court hearing was happening, that's being televised on court TV. It's dealing with your property, stuff that you're a witness about, and you didn't know anything about that. You just happened to choose that day to go in and do something with your phone. With one person, maybe you can buy it. With the 2 of them, no, I'm just not buying. I'm not buying it. I'm not buying it. It doesn't add up. It doesn't add up. My cover got busted 2 months ago, so I decided to change it today. It's not an explanation. My birthday was 3 weeks ago, so I got a new phone today. It's not an explanation. These are very, very bad explanations. So the coincidence of both of them choosing to do this the day before there is maybe going to be an order, when they know this is on the table, the possibility of an order saying you have to keep your phones is on the table, that's when they're choosing to do this stuff. Just adding to the remarkable pile of coincidences here that sure do make it look like something is really being covered up. Ed 2276. I know Jen McCabe deleted content from her phone and Higgins destroyed his phone/content. How many other witnesses did the same thing? Yeah, well, we know Brian Albert did too. Brian Albert got rid of his phone. With the rest of them, yeah, who knows? I don't know that they got phone data from anybody else. I'd have to think that what they could get was limited, even though we know this is coming from the feds and the feds' own investigation. It's going to be related to the feds' own investigation, the details of which are still kind of opaque. We don't know exactly what the FBI was investigating. We don't know exactly who the target was. So we don't know what their probable cause is. What is the crime that they are looking to uncover in this situation? That's going to tell you, I think, a lot more about what they're able to access, because it tells you why. Okay, you'd be able to get Brian Albert's phone. You might be looking for that. You'd be able to get Brian Higgins's phone. You might be looking for that. You'd be able to get Michael Proctor's phone. You might be looking for that. Jen McCabe handed her phone over, as we know, voluntarily. She wanted to make a point of telling us that, but we know she sanitized it first. So that, I don't think they had to go through the FBI for that. That would have just come directly from the Massachusetts State Police. They would have done that part. So did the feds get other people's phones? I don't know. We know Higgins and Albert got rid of their phones, so probably the feds didn't get to those. This is happening before we're hearing about that Fed process in June of 2023. This is all happening in fall of 2022. Yeah, I mean, who knows? Who knows? I have to think that if, for example, a Julie Albert or a Chris Albert or a Matt McCabe or somebody like that, if they had destroyed their phone, probably we would have heard about it. I just think that there's probably been there was no authority to seize and search their phones. I do know that the defense had asked, that's part of what all this preservation order stuff was about. The defense was asking, make the witnesses have to preserve their phones so that we can do an examination. And I don't know exactly who all was implicated in that order, whose phones were implicated by that ruling. Maybe it includes Matt McCabe, maybe it includes Chris Albert, maybe it includes Julie Albert, maybe it includes Carrie Roberts. I don't know. I don't know those details. But I have to think that if they had destroyed their phones, we would have heard that. We probably would have heard that. So I'm working with the assumption that it's just Brian Albert and Brian Higgins, and then Jen McCabe did the sanitizing before she can hand hers over, because hers was really supposed to be the crux anyway, right? She's the one at the center of the web. She's the one with the communication. She's the one who was talking to John. So if she can get the incriminating stuff off of there, then yeah, she's got a good record. It's just, you can't always get all the incriminating stuff off there, as unfortunately I think she is learning now. Teresa Kaufman, thank you, Andrea, for your fact-based commentary. Would it have been possible that the defense just stipulate to the testimony of the children so that they did not have to testify in court? Yeah, possible, but the Commonwealth has to accept that too. Both sides have to agree with if you're going to present evidence by a stipulation. There might be some exceptions to that in Massachusetts. A lot of this stuff goes state by state. So I can tell you, for example, in Washington, there's very limited situations where a defendant can force a stipulation on the prosecuting attorney. One example is it's what we call an old chief stipulation. It's from a case called Old Chief, and it deals with your prior convictions. If you're charged with a crime, that an element of the crime is you have previously been convicted of something. So, for example, unlawful possession of a firearm based on a felony conviction, failure to register as a sex offender based on a prior conviction. That prior conviction is an element of the charge. But of course, it can be very prejudicial to get that information into the jury, especially in a sex case. You don't necessarily want them to know exactly what the charge was. The defense can basically force the stipulation onto the prosecuting attorney. And so then the jury is just informed, you are to take it as true that the defendant has previously been convicted of a crime that required him to register as a sex offender. He's been previously convicted of a felony that prohibited him from owning a firearm, something like that. allows them to sanitize it. But that's a very rare situation because most of the time the Commonwealth gets to decide how they want to present their case. They get to decide how they want to put the facts in. And so they don't have to accept a stipulation from the defense. We don't know. We don't know what the story behind the scenes is here. But yeah, it's theoretically possible that the defense and the Commonwealth could have gotten together. They could have just pulled it from the statement of facts. They could have pulled it from what I'm assuming is prior testimony. If these kids testified at the grand jury, they gave interviews to law enforcement. Just present that. This is what they say. You are to take it as true, jury, that according to these children, here is the testimony. But the Commonwealth doesn't have to accept that. So I don't know that we'll ever know the story behind why these kids are on the stand. Alyssa Ramirez, can the phone data show what happened to John? Like in the Murdaugh case where it showed how many steps were taken, etc. Could it show if he made it into the house or if he was hit? Yeah. I mean, that's what we would expect. That's what we would expect because there is so much data that's available from the phone. And I just keep coming back to that GPS data. So many different things on your phone that are tracking your location. If you have location history turned on in your phone for Google, so that like Google Maps can, when you turn on the map, Google Maps can find you, know where you are, know what to present to you as far as, you know, restaurants in your area and stuff like that. If you have it turned on so that your phone will automatically adjust to a new time zone if you travel, and it'll pick up where you are and reconfigure your phone for you so you're on local time. All of these apps like the Strava and the Map My Run, et cetera, don't know about Apple Health. I don't know if Apple Health tracks GPS, but it wouldn't surprise me. Any kind of like, I don't know, navigation type of thing, a map, obviously a maps, Google Maps, something like that. Photos have GPS a lot of the time now, the camera programs, because they'll tag your location. They'll include that in the metadata where the location was where a particular photo was taken. So yeah, a lot of that stuff can be recovered from the phone from multiple sources. It's not just a ping type of situation of when is the phone communicating with the tower, with the satellite or whatever. I mean, it's all of these apps, all of these programs within the phone that are doing that as well. And that's even before you get to the emergency tracking stuff. A lot of emergency services on the phone to be able to locate a person, be able to place them pretty specifically, even if their phone isn't necessarily operating or working or connected to the network or anything like that. Because they want to be able to get 911 services out to you if you need them. And there are, still large areas of the country that don't have consistent, solid cell service. So if that's all you're relying on to be able to locate people and connect and provide emergency services, there's going to be big sections where that's not available. So there's a lot of emergency information like that that's available through the phone. Yeah, they should be able to get pretty specific location data from a lot of different sources on that phone. And this is a big enough area. This is a big enough area that it should be able to tell me. It should show me. We should be able to see John's movement corresponding with the movement of Karen's SUV arriving to the house. If he's hit and thrown under 10 feet, maybe that's not going to be enough to pick up on the GPS. But the point would be you would see movement with the car up to the point where he gets out of the car, gets hit, and then nothing, right? That's what we would expect to see. So that's going to be the $1 million question. Is that what the phone shows? I have a feeling, and from the comments I've seen, from some of the pretrial, the limited stuff I've seen from the pretrial, that, yeah, this is going to be an issue because that isn't what the phone shows. The phone shows other stuff going on. The phone shows movement at times when John O'Keefe is not supposed to be moving under the Commonwealth's theory. So if that is the case, they're going to have to explain why and what that means. And are we just going to get coincidentally, yet another thing is wrong here. The call logs have been wrong. All of the interviews have been wrong. Multiple things have been wrong. The extraction reports have been wrong. Is the health data going to be wrong too? I mean, it's a lot. You're asking me to believe a lot of stuff is just wrong rather than maybe it's all right and you just don't like it. You can't admit it because that makes you look bad. A lot of coincidences for all this stuff to be wrong. And if it's wrong, if something like the Apple health data is wrong, if something like the Celebrite extraction is wrong, then I'm going to want to know that it has a history of being wrong, that it's been wrong in other cases too. It's not just wrong this one time and every other time it works okay. That was something that I thought Alan Jackson did very effectively with Jen McCabe. It's not something that has a lot of impact in the moment, I think, because it's something he's setting up for his argument for later on. But when he was walking Jen McCabe through that time period when she got home to when she went to bed, and then, according to their records, the 2:27 a.m. Hoslong to Diane cold search took place. He connected that with all the other information they had from the phone, from her own health data, for example. That was accurate. That showed you walking, the approximate distance to get to your bedroom. The searches that you did that were recovered, those were accurate. They were accurate within the time frame. The texting you were doing with the group text, that's all accurate. It's just this one thing that isn't. That's a lot harder to believe. If this stuff is inaccurate all the time, it's easy for me to believe it was inaccurate on this particular occasion. So that's what I'm going to want to see from, say, one of these experts. If they're going to come up and try to explain, oh, well, the Life 360 data really isn't that precise. It can do these phantom trips where it seems like maybe you're driving to the school at 1:30 in the morning, but you're actually not. You're at home asleep in bed. If an expert's going to tell me that that's how the program works, then I'm just going to expect them to be able to give me examples of it doing that in other situations. That it's not just this case, because that's not believable. So yeah, very curious about this phone data. Really want to see what they're going to have, what it's going to show, and what the explanation is going to be for stuff that doesn't comport with the theory of the case. Falling outside the normal moral constraints, Yannetti woke up this morning and chose violence, and I loved it. It was great. It was great. I mean, bullied him right into the corner, put him in his position. Wasn't going to let him play the games he was playing with Mr. Jackson, with the explaining and the, well, I feel bad and stuff like that. Nope, we're just going to put you right on the spot with these facts that I know, and these facts I can substantiate. And if you are going to try to wiggle with me on these facts, then I am going to pin you down. Are you saying you don't remember? Are you saying you deny it? Because I'd be happy to walk up right here and slap this transcript under your nose and show you exactly where you said this to a federal grand jury. Yeah, boss move. Really like what Mr. Yannetti was doing there. Well, I'm going to go ahead, and since we still have some hours to kill here, I'm going to go ahead and pull up my latest piece that I put up on Substack, because I took a look at Judge Cannoni's appeal record. I talked a little bit about this a couple of weeks ago, And so I'm going to go ahead and share what I had put together. Because a lot of people, that's where we're at right now. We're starting to wonder, is this, if she gets convicted, what kind of chances are they going to have? What is this going to look like in an appeal situation? And it's tough because the appeals are always, you're always the underdog. The defendant is always the underdog on an appeal. As they say, appeals are for losers. You've already lost. The jury is found against you. And typically speaking, the jury is found against you for a reason. They're not just making it up out of the blue, deciding they want to put the label of criminal on somebody. There has been evidence that they found persuasive. And if they found it persuasive, then there's a decent chance the appellate court is going to find it persuasive as well. Doesn't always happen, but it's pretty predictable most of the time. So you're on the back foot because you're going into this new court. You've already lost, and the court's going to be reading over the same record that the jury heard and thinking to themselves, you're guilty. So they're not looking for reasons to bend over backwards to try to get you off the hook, to try to give you a new trial. The presumption is pretty much always going to be in favor of how do we preserve this conviction, this process, because we don't want to have to redo it. You never want to have to redo it. It's expensive, it's inefficient, it's unkind to all of the people who have had to go through this, to the jury whose time has now been wasted because all of it was for naught, their verdict gets thrown out. All of the witnesses who got called to testify, subpoenaed in, had to take out work, had to go through this process on the stand. Nobody wants to do that over. So there is so much pressure institutionally, psychologically, and written into the law itself to uphold that conviction. But there are certain types of issues that can give you a much better chance on appeal than others. And so that's the kind of thing when I'm looking at a case and I want to get a sense of what's the likelihood, what's the outcome of an appeal likely to be, you got to know what are the issues that you have to work with. On the scale of really, really, really likely to win my appeal to it's going to be a rubber stamped affirmed, disputes about what the evidence means and what should have been drawn from it, never going to get you a new appeal. Never going to get you a new appeal. Because the way that the appeal standards work is the court looks at the evidence and gives the jury's interpretation of it the benefit of the doubt. They figure this is the role of the jury. This is why they have them in the first place. We understand there's always going to be conflicts between testimony. There's always going to be things that people remember differently from other people. And it's the jury's job to sort that out, to go through it, decide who do we believe, who do we not believe, and then based on that, what does that mean for this overall picture of guilt or innocence? So a lot of times I'll see people thinking that, well, if this person testified to one thing and this other person testified to something that contradicts it, doesn't that mean the Commonwealth didn't prove the case? No. From an appeal standpoint, it doesn't. Because the appeal court is going to look at that, they're going to look at that conflict, and they're going to say, if the jury had the jury believed one of these people, if the jury believed the person that supports conviction, that their information would be enough to support a finding of guilt, then that's all you need. That's all you need. And it doesn't matter how unbelievable that person is, how incredible they are, how many times they've been caught up in lies and stuff like that. If they say the magic words that if the jury believed them, the jury could find the person guilty, that's it. That's the end of story. That is sufficient evidence from a legal standpoint. It may not be sufficient evidence from a sort of personal satisfaction standpoint, which I get, because there have been many, many, many instances of juries convicting people on evidence that I would not be comfortable convicting a person on. I don't think it's proof beyond a reasonable doubt. I'm not satisfied with it. We brought up Murdaugh earlier. I still have some questions about that. Definitely think he knew a lot more than he was willing to take responsibility for, and that became crystal clear during the cross-examination when he decided he had to get on the stand and give his version, and then his version is just getting picked apart, by the extrinsic evidence. The Snapchat that caught him there, that was a big problem for the defense case. That in and of itself makes it clear he knows a lot more than he's saying. Did they prove enough to put a gun in his hand to be the actual shooter? I don't know. Not to me. Not to me. They didn't put a gun in his hand. But enough to know a lot more than he let on, sure. I just don't know that necessarily adds up to guilty of murder under the particular circumstances of that case. You got to show complicity. You got to show you got to show what his role was. So this is just an example of disagreeing on kind of a personal level. If I had been on that jury, I'm going to struggle. I'm going to struggle with that charge for those reasons. But from a legal standpoint, is it enough? Yes, it's absolutely enough. You're not going to be able to go to a court of appeals and say there's not enough evidence here to support it. So those are the types of arguments that are very, very weak. Moving a little bit more towards the middle of what's hard to win, but it's not unheard of, are these rulings that are dealing with the admissibility of evidence. The judge has so much discretion to decide what's relevant, what's prejudicial, and how all of that stuff gets weighed in the course of a trial, that getting those judgments overturned is very difficult. The standard is essentially no reasonable judge could look at this evidence the way that she did. No reasonable judge would apply this reasoning that she applied. So it's not that it never happens. It does happen. It definitely does happen, but it's pretty rare. And so where you tend to have your most upside, your most potential for a good outcome on an appeal is when you're dealing with the judge's understanding of the law and the judge's interpretation of the law. Because the trial judge is not the final authority on what the law means. The Supreme Court of the state is the final authority on what the law of the state of Massachusetts means. And so that stuff gets reviewed under the least deferential standard of any type of appeal error. It's called de novo review. The court is going to look at it and independently decide for themselves. The judge said the law means this. Are they right? Is that what they mean? We're going to decide for ourselves what the law means in this situation. So those are the cases where you have the best chance, because the court isn't going to defer to Judge Bev at all. They're going to decide for themselves, and they are in the luxurious setting of their ivory tower over there in the state capitol, where they have their law clerks and they have all of the time that they need and the resources that are available to be able to research these issues exhaustively, think them through, ponder them over. The judge at trial doesn't have that. They got timelines. They got to get through this stuff quickly. They don't have, the state law library like right there next door. Often don't have law clerks. Sometimes they do, but nowhere near the type of institutional programming that they often have at the appellate level. So a lot of times they're doing all this work themselves. It's just a different ball game at trial, because that's not your focus. That's not your role. Your role is to do your best to call the balls and strikes. But the review, the camera is going to go up to the Court of Appeals. Where I think they're going to have the best option, the best opportunities in this particular case are, number one, if there are rulings that they can point to that deal with the judge's interpretation of the law and the legal requirements. Just in general, those are going to be the most fruitful. And where that is likely to come up is going to be in instructions. When they're talking about jury instructions, what specifically is the jury going to be told? What specifically are they going to be allowed to say or not say about the third-party culprit stuff, for example? Those types of issues, lesser included offenses, those types of issues are going to be a lot closer to implicating her interpretation of the law than just they let this stuff come in that seems marginally relevant and she let it in anyway, should they have. So much discretion in that decision, it's not always going to be helpful. But if they can show her ruling on something was colored by a misinterpretation of the law, that's where you can sometimes get some traction. If you can especially get the judge to spell out what their interpretation of the law is, and it happens to be slightly off, then that's ripe ground right there, because you can say, hey, a reasonable judge wouldn't adopt this interpretation because a reasonable judge would correctly interpret the law. This is not a correct interpretation of the law. A ruling that is based on a misunderstanding of the law is inherently an abuse of the judge's discretion. It can't be reasonable under the circumstances. So that's the type of thing that I expect them to be looking at. Not so much although I did see, I am getting some hints of stuff that seems to be a preview that everybody is on the same page, that if this case goes to appeal, this is going to be appealed. And one of those was the Aruba stuff. I thought that was signposted pretty clear because she gave that limiting instruction, clearly highlighting 404B analysis that she went through, finding it relevant, finding it more probative than prejudicial. And she made an offhand comment when they had done their sidebar and came back. She made an offhand comment that her findings are as she had made them at the sidebar. You have to make fairly specific findings on this type of analysis. So to me, that was a signal between Judge Bev and the defense. We both know you're going to appeal this. The Court of Appeals is going to want to look at my findings. And so that's what they are. I would suspect that's going to be up there. And that is one of those issues where it probably is, it's going to be reviewed under the discretionary standard. Is her decision reasonable? Is her, reasoning process, is that something that she's way out in left field on? Or is that something that, any judge, you might expect them to adopt that ruling? And so it's going to come down to real specifically, what did you find this was relevant for? What did you find the potential for prejudice to be? And how did you find that they weighed up together? Because to me personally, when I look at this evidence, I see such extremely marginal relevance, right? This whole motive thing is so vague and ambiguous anyway. The motive is she didn't like him. The motive is they were having a relationship breakdown. I mean, again, these are just not real specific motives to murder, because people break up every single day without murdering each other. It's just not a direct link to January 28th, January 29th, and what the situation was at that particular point in time. So I see the relevance as being so extremely marginal that it would not take a whole lot of potential for prejudice to say, no, this is too remote. This doesn't get to come in. So they fought in Aruba on vacation when John wasn't very nice to her, was getting drunk, leaving her to take care of the kids on New Year's. That's not a direct link to something that happened 3-4 weeks later. Without, you got to give me something more here. So it wouldn't take a whole lot of prejudice to overrule the value that you're getting from that. And is this stuff prejudicial? Yeah. Yeah, it is. This is a smear job. This is a smear job. This is here to just make Karen look crazy, psycho, jealous, making stuff up. It's clearly this picture that's trying to be painted, but I'm only seeing it through the words of these witnesses that I'm already kind of questioning. I'm definitely questioning Jen McCabe and Jen McCabe's testimony about when they're driving back up to Fairview and she's making weird comments about Bella's mom, and they talk about some other ex-girlfriend of John's, and she's freaking out about who's that. They're clearly, it seems to me, trying to paint that picture that that's who Karen is. But if Jen McCabe's testimony is where I'm getting that picture from, I don't buy it. If this girl from Aruba is who I'm getting that picture from, the one that, like, literally every time she's talking about what they did next, it's going to some bar and John is stumbling around so drunk and you're trying to take him back to the bar. I just don't know. I just don't know that your view of Karen in that situation is going to be all that persuasive to me. So yeah, it's prejudicial. That's the whole point. It's the whole point. It's there to smear her. It's there to try to get you to draw negative inferences about her. That's a situation where, even though this is discretionary, they might have something there. They might have something that's viable. You still have to get through the whole hurdle, though, of the court can find the error to be harmless. So that was a big introduction to what I was going to do here, was just talk about some of these cases that I had looked at. And I'm a little bit too big if I do that. To give me a little bit of a sense of how she does when she goes up to the Court of Appeals. How do they handle her? How have her rulings been received? So I did some research and I wrote it out. And so here's basically what I found. Now, I have to disclaim this because all I am able to search with my resources is published decisions. I don't have access to the unpublished decisions in Massachusetts. And the unpublished decisions are really the workhorse of the appeal process. It's the majority of them. The routine things that go up that, you have an indigent defendant, they appeal because they have a constitutional right to appeal, but you don't necessarily have a whole lot to work with. So not necessarily good arguments for reversal, but you just find what's there and you raise it and you see what you get out of it. This is the bread and butter of criminal appeals. Most of those, they don't have a lot of precedential value. They're not breaking any new ground legally. There's no real reason why those particular facts would need to be precedential for other circumstances. It's the law that matters. As long as the legal principle is clear, then how it gets applied to the facts is not, it's just depends on each case that gets presented. So overwhelming majority of cases are not published opinions. But the published opinions are the ones that matter. They're the ones where the decision was significant for some reason. This is where you were presented with an issue with first impression about the law. You were being asked to interpret it, and you had to make a call on that. So they're going to look at whether you got it right or whether you got it wrong. This is a really significant case. It's a capital case. It's a high-profile case. It's a complicated case. These are often going to be published because, they matter. These are cases that matter. Capital cases matter. Just seeing how complicated issues get worked out under the law can be a lot more helpful for precedential purposes than how do simple cases get worked out, because they can set a standard for the lower courts about here's how you should engage in the reasoning on this type of problem. So the cases that are important tend to get published. This is the rubber hits the road kind of stuff in the law, not the routine, everyday things that most of the time there's just not going to be a whole lot to argue about. So I found 10 of them since she's been on the bench, 10 published decisions, 3 of them civil, 7 of them criminal. She's been affirmed 6 times and reversed 4 times. So not really that great a record. Not that great a record. A little bit better than 500 average. But you really want more of a coin flip from the judge when it comes to being able to get it right. You don't want judges getting reversed a lot of the time. That's bad for everybody, for all the reasons we just talked about. You got to do it over. It's wasted everybody's time. You want judges to be able to get it right. So getting reversed a lot on the big things, that's not great. That's not great. We don't know to what extent she's learning on the bench. I mean, it does happen. There is a learning curve on the bench, especially you spent your entire trial, you spent your entire career in criminal justice. Probably just, it's natural that as time goes on, you get a little bit more and more specialized in your particular area. It's not that unusual that when you get on the bench and then you start hearing all kinds of different cases, yeah, you got a big learning curve. You didn't practice civil law, and now you're getting civil law cases that you got to decide. Yeah, you might make more mistakes in those. So I could understand if it was a situation where, you know, she got it wrong all the time in the civil cases, but in the criminal cases, she got it right. That's not how it worked, though. That's not how it worked. She got more right than wrong in her civil cases. And, you know, 3 of her reversals have been in criminal cases, in these 7 criminal cases. The thing that I found most intriguing about this record is that if we were looking at Judge Bev in a vacuum, just this case is the only thing we've seen. I know I am not the only one who is watching this thinking she is not giving the defense a real lot of benefit of the doubt here. She is not giving them a lot of leeway. She seems to be giving the Commonwealth a lot more leeway than she's giving the defense. And I say this recognizing that in some respects, yes, she has given the defense leeway. I appreciate that. She has held the door open on the third-party stuff. She hasn't said flat out, no, you can't do it. She's just said it's going to depend on how the evidence comes out. The Bowden stuff seems pretty clear. They're going to be able to elicit that and argue that. But direct third-party culprit, are they going to be able in closing to point their finger at Brian Albert, Brian Higgins, and Colin Albert? That's who they identified pre-trial as their culprits. Is she going to let them say, ladies and gentlemen of the jury, they're the ones who did it, not Karen Reed? It doesn't look like we're there yet, because she seems to be sustaining some of the questioning that they're trying to go through with these witnesses on those grounds, that it's questioning them about their personal implication in what happened to John. And she doesn't think that standard has yet been met for them to do that. But there have been other situations. The whole thing with the impeachment of the firefighter, Katie McLaughlin, the impeachment of Caitlin Albert as well, with these social media photos. Commonwealth had opposed that. She didn't let them in evidence because of Rule 17, hadn't been disclosed prior to trial. Arguable whether that was required or not, but she did give them leeway to bring it up in cross-examination. And then when they got to Caitlin Albert, even the stuff that seemed to be newly discovered, they were able to go into that. So she is giving them some leeway. But I understand how people looking at this case could potentially think, well, she's just very receptive to the Commonwealth. She's anti-defense. She's biased against the defense. She's not letting them work. She's letting the Commonwealth essentially do whatever they want, even to the point of boring us to tears with this repetitive and duplicative questioning, but she's not letting the defense ask questions that I think are fair. Yeah, they might be a little bit argumentative, but that doesn't mean that they're unfair. It doesn't mean you don't have an opportunity, that you shouldn't have a chance for the jury to see how does the witness handle that being put to them. So you might expect, well, this is a judge who rules for the Commonwealth all the time, and not by her appeal record. That is not what her appeal record shows. Her appeal record shows a pretty defense-friendly judge. She has, on multiple occasions, gone out on a limb ruling for a criminal defendant, and she's gotten her wrist slapped for it. She's gotten reversed way more often, in the published opinions anyway, for ruling for the defense than she has for ruling for the Commonwealth. The one case where she ruled for the Commonwealth and it went up on appeal, it was found to be error. Her decision was found to be error, but it was harmless. It didn't matter in the grand scheme of things because it didn't likely affect the outcome. The 6 other decisions that went up on appeal like this, they're situations where she had ruled for the defense and that got reversed. So, not necessarily what you would think that a judge is going to do if this was the only case that you were looking at. So then I got a little bit into the details of kind of why is she getting reversed and how are these decisions happening? And so what it looked like to me is she does seem to be somebody who reacts to the facts in front of her. She gets an initial impression of what's the right way to go based on how do I feel about the facts that are presented. Because when issues are presented that involve some fairly complicated legal work, the type of things where I need to parse the statutory language, I need to think about what the legislature had in mind to be able to understand what are they trying to accomplish here with this enactment that I'm supposed to be applying in this situation. Those types of decisions, she doesn't have a good record on. She's been reversed for, you misinterpreted the statute, you just basically didn't get it right. You reacted to the circumstance, the factual circumstance that was presented to you. You perhaps let your sympathies lead you in a direction that then colored your legal reasoning. So you interpreted the statute to allow you to go the direction you wanted to go, but the impartial Court of Appeals who is putting aside the facts, they're not necessarily going to follow that line of reasoning. They're going to be looking at it in a vacuum because they're not just thinking about this case right in front of me right now and what do I have to do for this person. The courts of appeal are thinking about how is this going to apply to anybody and everybody in the state under all circumstances, whether they are particularly sympathetic or not. So there was one case, for example, where the guy was clearly pretty sympathetic. This is an expungement case. The guy is petitioning to the court to get a 35 roughly year-old criminal conviction expunged from his record. He's had no violations since then. He has, according to the record, led basically an impeccable life since he made this mistake many years ago. He wanted to get some type of, the case didn't really flesh out in detail exactly what the situation was with his employment, but the implication was he wanted to get some kind of licensing or just get some type of job that having this conviction on his record was interfering with that. So it could be a situation where you need a license. You need a license from the state, or maybe you need to be able to carry a firearm, or you need to be able to be around children. I mean, just whatever. There's something like that somebody doing a background check is going to see this conviction in your record, and it's a no-go. You're not going to be able to get that job. So that's his reason for wanting to go to court and get this conviction expunged. So he's a sympathetic guy. You understand, at least I do. And Judge Bev has a defense background. I have to assume she's dealt with people like this. She's dealt with situations like this where, yeah, you really want to be able to get this guy something because it just seems really unfair. It seems overkill that somebody who has turned their life around isn't able to take full advantage of that, get the full benefits of that. They're always going to be tainted by this conviction, and you want to see deserving people get a second chance. The problem, though, is that the expungement statute really didn't allow it. It set out basically two different ways that two different pathways to getting a conviction expunged. One is just based on the time period that's elapsed, depending on the nature of the crime. Wasn't going to work for this guy because, given the nature of the conviction, there wasn't going to be enough time to elapse for him to be able to move for the expungement. So the other pathway is for a reason. And the way that the statute was written basically said, here's these specific reasons for the conviction, that if you can prove that one of these applied and the judge concludes that it's in the interest of justice to wipe that out, then you can get it expunged for that reason. And so those reasons had to do with things like, well, there was fraud in the procurement of the original conviction, or there was some other type of defect in the original conviction. What Judge Bev did is she read through the statute. She saw that last bit where it said the judge can find in the interest of justice that the conviction should be vacated. And she just seized on that. Well, this is a catch-all. This says I basically have total discretion to be able to decide to throw out convictions if I think it's in the interest of justice to do that. And I think it's in the interest of justice here, so I'm going to throw it out. But the problem was, no, if it doesn't satisfy one of these reasons for the conviction having been obtained in the first place, if it was a justified conviction under the circumstances, then your only other pathway is to go through the time pathway. Wait till enough time has elapsed, and if enough time is never going to elapse, then it's too bad. You're never going to get that thing expunged. That's the way the law is written. And so that's what the Court of Appeals said, was that you don't have total discretion. You don't get to wipe this out. You're going to have to either find a basis here, in the cause. He's going to have to show the conviction was flawed for one of these particular reasons, or it's going to stay on his record. And the remedy for that is go to the legislature. If you don't like the rules that are in effect for getting rid of these type of thing, for giving people the second chance, if you don't like the second chance limitations that are written into the law, the remedy for that is to go to the legislature. It's not to judicially rewrite the law from the bench so that you can do what you think justice is in this particular instance. So that was a situation where seemed like a sympathetic guy, wanted to get a particular outcome. The facts were very influential to her to such an extent that she made a legal error. She didn't get the law right. Another situation, there's a guy waiting for trial during COVID. He's 80 some years old. He's in a wheelchair. He's non-ambulatory. He can't walk himself around. He needs a massive amount of care. But he is being sought to be committed as a sexually dangerous person. These are proceedings, they're very similar to civil commitment proceedings, like the sectioning we heard about earlier in this trial that they did to Karen. It's a civil process to detain somebody based on dangerousness. And so with civil commitment, it's you have a mental condition that's making you dangerous to yourself, dangerous to others. And so for that reason, you need to be hospitalized against your will if you're not willing to go along with it until you can be stabilized and it's safe for you to be out in the community again. The sexually violent person statute, a lot of states have these as well. It's a similar civil commitment process where you have a condition that causes you to commit acts of sexual violence. So we're talking about, predatory, dangerous people. Usually preconditions are things like you have a conviction for a violent sex crime or something like that. You're going to be, but your sentence is served and you're going to be released. They don't think you're safe to be out on the streets because whatever condition you have, maybe you're a psychopath, maybe you're a pedophile, maybe you have, some other type of condition and a pattern that just leads people to conclude you haven't fixed the problem, you haven't had insight, you're not cured, and this is not a disease we want a lot of people out in the community wandering around with. It's just too dangerous for innocent people. So the sexually violent person process is that civil commitment for somebody. It's usually when they're about to be released from prison on a sex crime, and maybe they haven't participated in treatment. Maybe there have been behavioral problems in custody. They don't do it with everybody, right? In fact, they do it with the minority of people. Most people serve their sentence, and if it's a sentence that is, short of life, they're going to get out at some time. Most of the time, they're going to get out. I mean, the reality is most sex crimes are not violent ones. I mean, other than just obviously the inherent act is an act of violence, but not in the sense that you're, that we're thinking of like forceful, using force, using weapons, stuff like that. It's usually coercive, or it, involves minors or bad situations like that. So it's a pretty limited subset of people that we're talking about that typically go through these types of proceedings. So in this case, the guy is 80 years old. He's in a wheelchair. He's not going around on his own. He's got a nurse with him, giving him 24-hour care, but he's going to get released on his sentence. The Commonwealth wants to keep him detained. They don't think he's cured. They think he's going to commit more crimes if he goes out. Now, is a jury going to buy this? I don't know. I really don't know. Seems a little bit hard to imagine, but stranger things have happened. And when you walk into a court with violent sex crime history, the jury's usually not real inclined to give you a lot of the benefit of the doubt. So who can say? But this guy is awaiting for trial, and then COVID happens, and COVID puts a hold on everybody having trials. So it created these big, massive backlogs. And then when it came time to start working through that backlog, well, guess what? The criminal cases get priority because they're the ones that have constitutional speedy trial protections. You can't hold somebody indefinitely pre-trial charged with a crime and not ever get to the point of getting them in front of a jury. Evidence can disappear, witnesses can vanish, they can lose their memories, things like that can happen that affect the ability of that trial to be a fair process for adjudicating guilt or innocence. So basically, these are due process types of implications that just go a little bit above and beyond the idea that, you are presumed innocent. You shouldn't necessarily be able to have something like this held over you indefinitely, until the Commonwealth wants to get to the point. So criminal cases have these speedy trial protections that civil cases don't, because civil cases most of the time are just about money. Now, in this particular case, it's about liberty. But these are still considered civil cases. It's not quite on the same level as the criminal case when it comes to those type of protections. Now, having said that, I would suspect these cases are going to have higher priority than something like the boundary fence dispute between the neighbors. Or your raspberries are growing on my lawn and I cut them out, and now we're in a big fight. It's probably going to have higher priority over that case, but it's still going to have lower priority than all of the criminal cases that are waiting for guilt or innocence to be determined. So this guy is having to wait. He's having to wait for his trial. He's having to wait for his trial because the Commonwealth is saying, I want to have a jury trial. Under the statute for these types of proceedings, either one of the Commonwealth or the defendant, the accused, can request a jury trial, can require a jury trial. So the guy was willing to say, forget the jury, let's just try it to the bench. Then we don't have to worry so much about the COVID restrictions, because we're not worried about bringing in a jury to socially distance, and the courtroom has to be a lot more, a lot more closed. Just the whole area, when you're going to socially distance a court and a courtroom, it changes the whole process of what you're able to do. I mean, frankly, probably within the entire building, it just makes it all much more complicated. So if you don't have to do that, you don't have to worry about getting a jury in, getting them socially distanced, et cetera, you can get through it a lot faster just in front of a judge. He's willing to do that. The Commonwealth is not. The Commonwealth is saying, no, we have a statutory right to a jury trial. We want the jury trial. Well, in this particular case, Judge Bev said, you know what? I think it violates due process for the state to be asking for a jury trial under these circumstances. Given these COVID delays, he's having to wait. And he's an old man, 80-year-old man. Don't even know how much longer he's going to be around. Doesn't sound like his health is very good. He has a due process right to that adjudication, the shot at freedom or detention. He should not have this hanging over him. He should have that decision made. And so waiting for a jury to be available under that circumstance, according to Judge Cannoni, she thought it was a violation of due process. The Court of Appeals disagreed with that. And that's a situation where it isn't even you need to interpret a specific statute, something that can be fairly complicated. This is really just a knee-jerk fairness type of impression when you're talking about due process. Due process ultimately always comes down to fairness. What's fair? And so, yeah, there's a lot of case law that fleshes that out under different circumstances that the judge is going to be expected to be aware of. But it goes a lot more to just instinct, knee-jerk instinct. You think this is unfair, so then it's easy to see the procedural requirements in that light. If they are producing this unfair requirement, then this unfair outcome, then those requirements themselves are potentially unfair. And if they're unfair, that's a due process violation. Court of Appeals did not see it that way. She got reversed again. No, the Commonwealth has a statutory right, and under the facts as they were presented, it was not such an egregious type of situation that it would shock the conscience that the Commonwealth is asking for a jury trial in this situation. And that's what the standard is for due process, is a shock the conscience, substantive due process argument. So the judges on appeal, their consciences were not shocked, and they didn't support that. So it just goes to show, it does seem to me like she has a little bit of a pattern of the facts get to her. The facts get to her, the specific case in front of her, she forms an opinion about it, and then that colors her reasoning of it. And so if we look at that in this particular case with Karen Reed, I think we can see she has a very skeptically colored perspective on the hoax argument, on the third-party culprit argument. And that might be coloring some of the rulings that she's making that are limiting her ability to present the third-party culprit defense. So just something to bear in mind. Just something to bear in mind that when this goes up on appeal, the Court of Appeals is not necessarily going to share these impressions when they're interpreting her rulings. She did, I had mentioned this before when I was first talking about her appeal record. I talked about it on Defense Diaries. I don't remember if I talked about it here too. But she had a very, very, very recent case involving third-party culprit stuff. And I found that extremely interesting because it made me wonder if this has given her kind of an over harsh example of what third-party culprit testimony can be, what that evidence can be, and she has perhaps mistaken that for the sort of universe of what it should be. It's anchored her in her expectation of what a third-party defense is supposed to look like that might be a little bit more stringent than what the actual legal requirements are. And I say this because the legal requirements, they were laid out in the briefs pre-trial, and it's not really that stringent. There's a lot of stuff you can find if you're looking online or you're Googling or whatever. There's a lot of commentary about the some other dude did it defense, the SODI defense, they call it. Some other dude did it. That's what we're talking about here with this third-party culprit stuff, the SODI defense. A lot of states have put some pretty hard limits on being able to present a SODI defense, because the idea is if you can just point your finger at anybody and everybody, well, that becomes a sideshow, that becomes a distraction. If you can argue, well, you know, neighbor Jane did it just because Jane was home that night, that doesn't really narrow the field between all of the other people who were home that night that also could have done it. It doesn't give you any particular reason to think that Jane did it. So you need more than that. You need more than just somebody else could have done it. You need some type of evidence that somebody else, in fact, did do it. And that in and of itself, I don't have a problem with that reasoning. I don't have a problem with that reasoning. I mean, yeah, a lot of people could do something. It's not necessarily relevant to point out what could happen. We're here to establish what did happen, what is reasonably likely to have happened. So if that information doesn't make it more likely that she actually did do it, then no, it's not particularly helpful. It's damaging to neighbor Jane to have to go through that, to have to suffer that type of accusation, and it doesn't distinguish her in any way from everybody else, you know, who, consistent with the laws of physics, could have done it. So I don't have a problem with that kind of reasoning in the classical, this is probative versus this is prejudicial type of balancing. It's really not that probative, and it is prejudicial. So I don't have a problem with something remote like that being kept out. But some states have gone really, really far in the other direction, where you would have to prove more to establish a third-party defense than you would have to prove to charge the person with the crime. To charge a person with the crime, you only need probable cause. That can be based on circumstantial evidence. That can be based on evidence of motive, intent, opportunity. You don't have to have direct evidence of each and every element of the crime, and oftentimes you don't have that. Oftentimes your case is inferential. Certainly, at least in part, when it comes to stuff like the mental state, because unless the defendant is getting on the stand and testifying, yes, I intended to murder this person when I did X, Y, and Z, then you're going to be inferring what their mental state was based on the evidence that you see. What did you actually do? Talk is cheap. What you tell me your intentions are may or may not have any weight with me at all. It's just one particular piece of evidence. But actions don't lie. Actions tell you a lot about people's motivations. So that's how you get there 99% of the time in most murder cases. It's not because you have direct evidence of that element, that mental state element. It's because you infer it from what you can see and the conclusions that reasonable people can draw from it. Well, there are some states that will say you have to have direct proof that this person did it in order to be able to present a SODI defense, a third-party culprit defense. So that's an extremely difficult standard to meet. Very difficult standard to meet. You need an eyewitness who puts them there. You need DNA that connects them with the crime, fingerprints, some type of forensic evidence, something like that. No question we don't have that in this case, at least not at this point. We don't have an eyewitness. We don't have anyone saying he was in the house. We don't have them on camera doing anything. We don't have them admitting anything in text messages that have been recovered. We don't have anybody admitting anything in interviews. There's no direct evidence. It's all circumstantial, but it's based on, you certainly had the opportunity. He was coming to your house. He was there. He was found outside the lawn where you were. And there was a period of time where Karen had left, you're the only people alone with him that are in a position to interact with him, do something with him, know what was going on with him. So there is opportunity here. Intent is, again, one of these things that's typically inferred by the actions. So the question is, was John O'Keefe beat up? If there is evidence that is going to come in from a medical examiner or somebody like that, somebody with medical expertise who's going to say, yeah, these don't look like car accident injuries. This looks like the dude got punched in the forehead and punched in the nose, and that's why he was bleeding, and he fell down and cracked his head on something, because that's what happens when you get cold cocked. That's how people die in these stupid street fights that you see. Oh God, never do a street fight on concrete, people. Like, never do it. If you absolutely are gonna be a dumbass and you're gonna street fight out there, try to find grass or something to do it on, because that's what happens. You get dropped, your head cracks the ground, and you know, that can be extremely dangerous. Obviously, people can die from that type of thing. The medical examiner is going to get on the stand and say his injuries look like he got beat up and cracked his head and got the brain damage, and that's how he died. And the dog got a hold of his arm and was, you know, yanking around on his arm, and that's why his arm got all mangled like that. That's evidence of intent, because intent to beat somebody up, it speaks for itself. You don't need somebody to get on the stand and say, well, yes, that's what I was trying to do when I punched him. It speaks for itself. If somebody hit him, that speaks to your intent to assault him. So they got that. The only piece that they're really missing here is the opportunity, is the motive. And that's where I have such an issue with this Aruba stuff and with this Higgins and these texting, because it sure looks a lot more like that gives them motive than it gives her motive. I mean, Aruba, like we said, 3 weeks before, but Higgins is texting her that night. He's texting her that night. They're trying to get John over to the house. You're coming with me. Are you coming over? Even Higgins is checking in with him. Are you coming over after you just welled his girlfriend? This looks a little more to me like a direct, like an immediate motive than all of this stuff we're hearing about. 3 weeks ago, they were fighting. 3 weeks ago, they were fighting, so she decides to back her car into him. No, that doesn't make a lot of sense. But you were hitting on his girlfriend, and you're getting the brush off, and you're not happy about it. That looks a little bit more like an immediate motive to me. So they have all that stuff, right? They have all that stuff. To me, I don't know. I just don't know that the limitation on the third party is justified. I can see the argument. It's justified right here, right now at this point, because all of that evidence is not in. So if the defense puts on an expert that says, yeah, this guy was beat up, he was not hit by a car, he was beaten and left to die, I would have a hard time seeing how we have not crossed that hurdle at that point in time. So where this is really gonna come down to the wire then is not so much with these evidentiary rulings that are being made piece by piece by piece, just as the case aggregates, as the evidence aggregates, and each new thing is being offered, we have to evaluate it in light of what's been introduced so far. Those are not really the critical decisions, I don't think, on this third-party culprit stuff, because the defense is going to they have their own case that they're going to be able to put on. They're going to be able to revisit a lot of these things. They have a lot of these people on their own witness list to potentially be able to call them back if the situation then changes as far as opening the door to the third-party culprit stuff. Where it's going to hit the wire is when it comes to instructions and when it comes to any type of limitation on closing arguments. If Judge Bev is going to say, I'm not going to allow you to argue that in closing, that's where her interpretation of the third-party culprit standard is going to be critical. And that's where there is potentially room for that to be revisited on appeal, because Massachusetts is not one of these super, super strict, you got to have crazy direct evidence of involvement in order to present the third-party culprit defense. You have a constitutional right to present a defense, and that's always going to be weighed against the court's ability to cut you off just for kind of convenience grounds or fairness grounds or whatever. When it comes to fairness, the defense being able to present their case, that carries a lot of weight. So this particular case, I thought, was extremely interesting, because this was a situation where there was an eyewitness. This was a third-party culprit case where the guy is being charged with capital murder. This is a situation where a drug dealer has gotten shot multiple times in his home. Mr. Tavares is the last person who had called him on his phone. He interviews with the police. His phone had pinged off of the tower in that area, which we've talked about pings before. That may not be particularly precise at all. You could just say he's within miles of the crime scene. But then he also interviews with police and gives them information about, he has a relationship with the guy that got killed. He had a dispute with him about a drug deal where he felt he had been overcharged. Texted to his friends, "Yo, I got bagged over some weed that he bought." He's got his fingerprint on the door, which to me is, I mean, that's nothing. You don't know when that came on. If we can see that he's buying drugs there anyway, then you would expect there's going to be, if you look hard enough, there probably is some physical evidence that he's been there. Doesn't mean he was there at the time of the crime. So they never recovered the murder weapon. They searched his house, never found it, never found anything like that. But then what happens is, right before trial, the Commonwealth gets a proffer from a confidential informant. And this confidential informant tells them these two other people committed the murder. It was they were going there to rob the drug dealer, and he went and grabbed for the gun, and they shot him, and he died. Well, that's definitely direct evidence that somebody else did it. And what happened is Mr. Tavares's lawyer, he had a private lawyer that he had hired for a flat fee of $5,000. I will never be able to say this enough. You get what you pay for when you hire a private criminal defense lawyer. I make that distinction very carefully because, granted, I'm a bit biased on this, but public defenders, a lot of public defenders are going to be some of the best trial attorneys that exist. There's a lot of bad ones. Please don't get me wrong. I'm not out here to say that public defenders are always, head and shoulders above everybody else, because often that is not the case. Often public defense can be kind of the dumping ground for people who just are not very good lawyers, who have been problematic for other reasons, because there is a massive shortage of public defenders. So they tend to be desperate. Anybody who's willing to do the job can typically get it. So there is a lot of bad work, a lot of attorneys too that are just, they would love to do a good job, but your caseload is too big. You got too much on your plate. It's very, very difficult to just be able to do everything that you need to do when you got 500 other cases on the burner that you're having to be working as well. So I'm not trying to say in every instance public defenders are always awesome. However, a lot of public defenders that are out there are some of the best attorneys that you will ever find. And it's just because they are so experienced. They have been to trial so many more times than anybody else. They have seen everything. They have seen all of the cases. They have litigated all of the cases. They know the issues. By the time you've put in 20, 30 years in a public defense office, I mean, you're pretty solid with some skills. Private criminal defense attorneys aren't always that. They aren't always that. They don't always have that kind of experience. They don't always have criminal experience. it's just kind of all over the place what you get. Yeah, there are also some private criminal attorneys who are excellent that had long careers as prosecutors, as public defenders, whatever, went into private practice and have done very well. It's a common pathway. But there are a lot of private attorneys who simply aren't that good, but it's kind of just a low bar type of practice to get into, because it's not glamorous. You know, if you're a lawyer wanting to go into private practice of some kind, say you want to make the money or something like that, you don't choose criminal defense. Okay, you go and you do mergers and acquisitions, or you do corporate stuff, you do transactional stuff, you do personal injury stuff. I mean, you get that one unicorn case with, multi-million-dollar verdicts, and you're pretty set for life on that. You don't choose criminal defense for that type of thing. And so a lot of times it's just something that people fall into because they find that people have a sense that if you're paying somebody to do the job that your public defender could be doing, but you're paying somebody to do it, you just automatically assume that what you're getting is better, even though a lot of the times it's not. You're getting somebody who's far less experienced. You're getting somebody who doesn't have the relationships potentially with this courtroom, doesn't know how this prosecutor works. A lot of times it's a disadvantage to have that private attorney compared to the public defender. But a real big tell for when you're getting a lousy criminal defense lawyer is when you get a ridiculous financial deal like this. A $5,000 flat fee to do a capital criminal case. My opinion, this should be illegal. This should be illegal. We have rules in the rules of ethics about attorney fees being reasonable. You're not allowed to charge unreasonable fees. And this is always interpreted in the context of you don't get to overcharge people, or you don't get to tack on things that they weren't expecting as far as expenses or rates or things like that. You don't get to charge wildly extortionate, amounts of money to represent somebody in a criminal case. But it never gets interpreted the other direction. And I've often wondered, it's weird. It should be, shouldn't it? Shouldn't it? If a fee needs to be reasonable, to be ethical, doesn't it need to be reasonably enough to actually compensate you for the amount of work that you need to do? Because otherwise your incentive is, I get the check, I cash the check, I work for a few hours until I have earned all of that check. And now where is my incentive to keep working? I don't have it. My incentive is to put this case aside and go get another $5,000 check from somebody who will pay me to put in a few hours on it, and to just keep doing that over and over and over again, chasing the money that is paying you, instead of working on these cases that you've committed to, you've undertaken, but you're not actually getting any type of compensation for the time that you're putting in. My opinion, that's unreasonable. Shouldn't be allowed, but whatever. It's nobody has agreed with me about that at this point. That's my own little hill. But yeah, you should be alarmed if the attorney is offering you a deal that seems too good to be true, because chances are it is. Chances are this attorney needs $5,000 right now. They have a cash flow problem. You're the opportunity for them to be able to get that. And when it's going to be time for them to do the work that your case needs, $5,000 isn't going to cut it. So they're going to be disinclined to do the work. Well, unfortunately, what happened in this particular case was the attorney decided not to follow up on any of this, not to follow up on this witness. Gets the information the day before trial. The witness is actually in court and is ordered by the judge to be available for the trial in case you're needed. I'm hearing the court's back. Oh, they are, my goodness. Let me get there. I'm going to go ahead and get us paused here so we can see where they're at. So remind me, I'll come back to finish that case when we're at the end. But for now, it looks like we are about to get some more testimony. So I'm going to play it back fast until we get to the court being live. Here we go. And they're back.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor, the Commonwealth call Dr. Justin Rice to the stand.
Okay, so now we have a doctor. Dr. Justin Rice.
Right up, watch step on it. Yep. May see in face clerk. Raise your right hand. You solemnly swear the underscript of the court and during the case out here to the truth, the whole truth, and
So
nothing but the
he's
truth,
from
so help you
Good
God.
Samaritan
Thank you.
Medical Center. He was one of the ones at the hospital.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good afternoon, sir.
Hi.
Could you please state your name and spell your last name for the jury?
My name is Justin Rice, R-I-C-E. Is that what you asked me to spell?
And sir, that microphone in front of you, however you want to position that, it's flexible, so
Too far away. Is that better?
that's perfect. Thank you. And what do you do for work, sir?
I'm an emergency medicine physician.
And how long
You're
have
a
you been
doc.
doing that?
I finished my residency in 2008, so I've been attending since 2008.
And where is it that you work now?
My current employer is South Shore Health.
And how long have you been working for South Shore Health?
I started there in October of this past year, 2023.
And where did you work prior to that?
Before that, I had been full-time at Good Samaritan Hospital in Brockton.
And how long was it that you worked at Good Samaritan?
Let's see. I started at Good Samaritan in 2010.
Now, sir, if I could, I'd like to just talk a little bit about your educational background. Where did you go to school as far as your undergrad was concerned?
I went to undergraduate at the College of William and Mary in Williamsburg, Virginia.
And what, if any, degrees did you graduate from there?
I obtained a Bachelor's of Science in Chemistry.
And following your graduation from there, where did you go to school after that?
So after that, I attended University of Virginia for medical school. Is that what you asked me? I'm sorry.
And following your graduation from medical school, where did you go after that?
Then I did an emergency medicine residency in Philadelphia at University of Pennsylvania.
Ooh, he's
And
seen
what
some
is a
stuff.
residency, sir?
So residency is there's several years of training that's where doctors will specialize. For me in emergency medicine, some people choose to be surgeons, pediatricians. That's when more of the specialization, if you will, happens in
You
medicine,
are in
medical training.
Philly.
And how long was your residency?
He's seen some
It
stuff.
was 4 years.
And following your residency, where did you go from there?
So I, in 2008, finished residency. I worked for 2 years in Manassas, Virginia at Prince William Hospital for 2 years.
And are you board certified?
I am by American Board of Emergency Medicine, yes.
And what is it that you're board certified?
Emergency
Specifically
medicine.
emergency medicine.
And when you use that term as far as board certification is concerned, what goes into that? What does that entail?
So when I obtained board certification, it was a two-step process where there was a written exam administered at one of the testing centers. And after you pass that, then there's an in-person oral exam, I guess is what they're called. And that's where you've given like didactic or individual cases. Assuming you pass that, then you're board certified.
And your board certification is up to date currently?
Yes.
Now, with reference to the time that you worked at Good Samaritan, as far as the emergency department is concerned, can you describe to the jury sort of what does the emergency department at Good Samaritan look like as far as staff, bedding, sort of layout, like describe that for the jury?
Sure. So at the time and currently, there's 36 treatment rooms in the main ER, a lot of hallway stretchers as well. There's also an express care kind of area, but for the purposes of this conversation. 36 beds in the main ER. Staffing wise, there'd be anywhere between 4 to 5 and 12 nurses. And for the purposes of this discussion, it would have been 2 docs on and probably 1 either nurse practitioner or physician assistant in the morning.
And as far as the morning, I'm going to turn your attention to is the morning of January 29th, 2022. Were you working at the Good Samaritan on that day?
If that's the morning of this incident, then yes.
And is there a particular shift or what kind of hours would you be working around that time at Good Samaritan?
I'm pretty sure I started my shift at 6 a.m. that day. There was a 6 a.m. to 2 p.m. It was either 2 or 3 to, excuse me. It was either 6 to 2 or 6 to 3 p.m., but the shift would have started at 6 a.m. as I recall.
And on that date at Good Samaritan, do you recall becoming involved with a treatment of a patient by the name of John O'Keefe?
Yes.
And Your Honor, may I approach the witness?
Yes.
Is he going to have opinions about John O'Keefe's injuries? Are they going to let him go down that road if he does? That's what I want to see. A guy who did his trauma residency in Philly, he's seen some people beat up.
You want me to look through each page or just acknowledge that?
Just as far as, do you recognize what that document is?
Yes, of course.
And what do you recognize that to be?
So it looks like is a transcription or a copy of the medical chart that I would have produced or dictated. And on the front page is also it's called like a code sheet, which the nurses would have put together and I would have signed off on, detailing what resuscitative efforts, as in the specific details and timing of the resuscitative efforts that were performed on Mr. O'Keefe's behalf.
Thank you. Your Honor, with the court's permission, may the witness hold on to that during the course of his testimony?
Yes.
And Your Honor, what I would seek to introduce in a minute as the next exhibit would be a redacted copy of those same records.
Okay. Is there any objection?
Your Honor, we can just review those.
If you're from Philly, you know exactly what I'm talking about. All right, it's not Baltimore, but it's quite a place to do a trauma residency. So this is this nice textured blue on Karen today. I like this blue. I like this blue. It's not the royal cobalt, but it's still a very pleasant blue. And I like the whole zipper effect, the no collar. It's a little edgy, right? Makes it look a little kind of like a motorcycle jacket or something. I mean, obviously not with that full, but just simplified, pared down, the nice bling. It's a good jacket. I like it. The zippered sleeve. Yeah. I want to see the whole top to bottom. I wasn't a fan of that last look we had on Friday, that really structured blazer over the flowy dress. It just didn't work for me as a combination. Somebody tagged me after in the photo of them arriving to court. Okay, so this looks like it's either a suit or it's a suit, not a jacket dress. It's a nice suit, a little on the short side.
Okay, thank you. And Mr. Lally, I'll let you hold
But
on
she is
to
sitting.
what's been marked SS for identification.
Okay. Now, Dr. Rice, with regard to Mr. O'Keefe.
Exactly.
About what time did he come into your facility at Good Samaritan?
Would you like me to look at the chart here? Let's see.
Sure. If you can't remember things and you need to reference the chart, you can do that, Doctor.
Okay, thanks. So it looks like, based on the code sheet, first line starting at 0647, so I'll say 6:47 a.m.
And as far as his presentation, Mr. O'Keefe's presentation, when he came into the emergency department, how would you describe his presentation upon his arrival?
So he would have been, well, he was unresponsive and intubated, as in with a breathing tube into his airway via his mouth.
And as he came into the emergency department, what, if anything, was fixed in regard to CPR or other resuscitative efforts?
So he would have had CPR in progress. And also someone would have been ventilating his lungs via the endotracheal tube.
Now, there's mention within that record as far as a cardiac arrest, is that correct?
I don't know. I'm sorry. I don't understand what you're asking me.
Sure. Well, let me just ask you, familiar with the term cardiac arrest?
Yes.
Can you describe to the jury, based on your training and experience, what your understanding of that term is?
Sure. So, as in he arrived with in cardiac arrest, which by definition means that his heart was not autonomously or independently pumping blood, or in his case, without electrical activity as well of the heart.
And are you familiar with another term called perfusion?
Yes.
And can you explain what perfusion is and how that relates to the condition of cardiac arrest?
Sure. So, for example, you and I right now, because our heart is autonomously, pumping blood, the heart is the pump and responsible for pushing blood throughout your body, therefore perfusing your body. In a scenario like this, where a patient is in cardiac arrest or asystole, or as in not having any electrical activity in his heart or mechanical activity of his heart, the perfusion that is happening is by CPR, as in the chest being pushed upon, indirectly is, you call it maybe indirectly pumping or moving blood flow. So there is perfusion, but in a significantly limited compared to someone not in cardiac arrest.
And as far as that perfusion process is concerned, what, if any, relation does that have to the organs within the body?
Well, so, if your perfusion is limited, then your organs are not getting the normal amount of blood flow and therefore oxygen and all the other nutrients that your blood's providing. So your organs will begin the process of failure.
You use the term in there as far as asystole. Could you explain to the jury what you understand that term to mean?
Sure. So asystole would be when you put the electrical leads on a patient's heart. The complete absence of intrinsic electrical activity from the heart would be asystole. So as in not having any observable or detectable electrical activity would be asystole.
Now, as far as these conditions, as far as cardiac arrest and asystole, what, if any, concerns does that raise from a diagnostic perspective in relation to Mr. O'Keefe?
I guess your question with respect to it from a diagnostic perspective, I don't know exactly what you're asking me there.
Let me rephrase that. So with regard to those conditions that are observed and noted within the medical chart for Mr. O'Keefe that you have before you, how would that relate to his condition or sort of how he's presenting and what, if anything, you're doing treatment-wise?
Well, so even with good CPR, the perfusion of the brain, for example, and this is what I think about frequently during resuscitative efforts like this, as in, I couldn't tell you an exact time, but there's a certain, without perfusion of the brain for a certain amount of time, you're limited with respect to, well, the concern is that the patient, even if you resuscitate their body, that there's potentially going to be brain death or anoxia or lack of oxygen to the brain, and a poor outcome with respect to neurological outcome.
Now, as far as the resuscitative efforts are concerned, is there any sort of standard sort of resuscitative protocols that would be undergone with someone who presents as Mr. O'Keefe did?
Yes.
And can you explain what those are?
So, you know, in broad terms, there's ACLS, which is Advanced Cardiac Life Support. That's an algorithm that through medical training, you know, I've learned and is frequently, the algorithm can be adjusted. There's also a TLS for trauma patients. So there's an algorithm there with respect to resuscitation or
Algorithm? I don't
guidelines, I
think-
guess, with respect to resuscitation.
Algorithm is the word he's looking for.
And within
protocol.
those
He's not a
sort of
computer
guidelines
running
and
an
protocols, are you familiar with a medication called epinephrine?
Yes.
And how would epinephrine play into sort of the treatment or the diagnosis of Mr. O'Keefe?
So, you know, in the time that I've been practicing, epinephrine is probably the only medication or drug that has persistently been in the ACLS pathway. It's adrenaline, so the idea is loosely that you're attempting to affect upon the heart itself more squeeze, as in more pressure, and also to increase the potential, or if there is electrical activity, to increase the amplitude of that electrical function at the cellular level.
Now, in addition to the cardiac arrest and the asystole, as far as Mr. O'Keefe was concerned, what, if any, presentation did he have related to hypothermia?
So I know his initial temperature was low. I'd have to look, but I can see here that the nursing wrote in their notes that his, I see T equals 80.1 R. So I interpret that to be his temperature was 80.1 degrees by rectal temperature.
And if you could explain to the jury sort of your understanding as far as hypothermia, what is it and how does that present itself?
So, you know, as it pertains to this case, there's a few ways to get hypothermic. If I, at 12:20, were to have a cardiac arrest right now and stop perfusing, my current temperature, my current temperature, I'm guessing, is 98.6, right? A normal temperature. Without perfusion, the body will lose, or excuse me, the core temperature will decrease over time. The specifics of that I couldn't, or beyond my knowledge and training, but that's
guy.
Does that answer your question?
Yes. And so as far as hypothermia is concerned, is there a certain sort of baseline or what is sort of the typical temperature under which someone would be declared sort of hypothermic or treated as such?
I don't know if I could give you a definition of medically what a quote diagnosis of hypothermia. I couldn't tell you a number. I can tell you that 80 qualifies as hypothermia, but I couldn't tell you a number under which that definition applies.
But the temperature that Mr. O'Keefe presented with certainly fits within those parameters, is that correct?
Yes, 80 degrees is very cold.
And as far as resuscitative efforts as they pertain to the core body temperature or the low core body temperature of Mr. O'Keefe, what, if anything, was done with relation to treatment of that?
Sure. So as the nursing note mentions, there's a bear hugger was applied. So that's a blanket that has warmed air being pumped through it. So that's a way of externally warming someone. He also, having reviewed the chart earlier, I don't see it right in front of you. Actually, I take that back. He had warm IV fluids running, so IV fluids not at room temperature, as in a warm or an oven of sorts, would have been given to him via intravenous or central venous access.
And as far as the body temperature is concerned, what if any relationship does the body temperature have and the warming process have as to a declaration of deceased in relation to Mr.
Well, so there's a goal in resuscitative medicine to attempt to rewarm a body. Loosely, the idea being that the heart, among other organs, will function better or function at all in a warmer environment. That's one goal of resuscitation. With him, as I recall, despite resuscitative efforts for approximately half an hour, there was not a significant warming of his core temperature.
And so, sir, with reference to Mr. O'Keefe, at some point, was he pronounced deceased by yourself?
Yes.
And do you see any indication within the chart as to what time that was?
Sure, I'll just need this moment here.
This doctor's not awesome, but these questions.
According to my note, it looks like the time of death was, death declaration was 7:50 in the morning.
Is that 50 or 15?
50.
750. The questions
Now,
are terrible.
as far as the observations that you made as far as a systole and the cardiac arrest, did that persist throughout the course of your treatment of Mr. O'Keefe?
Yes.
Now, may I approach the witness?
Yes.
Let me just see that document.
What you normally do with a doctor is kind of like you do with a cop. You just ask them to tell you what they did.
What's the fourth page in, the bottom of it says 2 of 4, and I direct your attention to the top of that page. Do you see that, sir?
Yes.
And as far as this is sort of a listing of observations or, well, let me ask you, can you describe what is listed at the top of that page there?
Sure. So this would have been the physical exam documentation of my note. So, with respect to the head, it says, excuse me, the first word is other, which I believe is a function of the computer system. As in, I typed in the right superior orbital ridge region, approximately 7 millimeter laceration, and then with surrounding soft tissue swelling / contusion.
Sir, if I could just stop you there. As far as what you're talking about with the right superior orbital ridge region, could you explain to the jury or demonstrate to the jury?
Sure. So the orbital ridge is the bone above your eye that you can, like where your eyebrow is or should, would normally be.
7
And
millimeters, pretty long.
As far as the other
Big
sort of
gash.
things that you noted over the course of your physical exam or review of Mr. O'Keefe, what, if anything else of note, did you observe?
Well, according to my note, the only other kind of observations other than would be that he had breath sounds present bilaterally. I observed that he was pulseless. His abdominal exam was atraumatic on my charts, and then extremity exam or musculoskeletal exam, I wrote that he had superficial abrasions on the right forearm.
And from a medical perspective, when you use that term abrasions, so can you explain to the jury what you understand the term abrasions to mean?
Yeah, I use it as a medical synonym for scratches, if you will.
And under neuro or neurological, there's a listing as far as a GC3, is that correct?
Yes.
And can you explain what that is and what that means?
So GC is what I charted. What I intended to write there was GCS, which is a Glasgow Coma Scale, which is a scoring system to identify someone's level of consciousness or unresponsiveness.
And as far as the three, what is, like, where does the scale start? Where does it go to? And where does the three fit in?
So there's three components: verbal function, motor function, and eye or ocular function. And someone who's completely unresponsive, as in no motor, no verbal, and no eye movement or function, completely unresponsive, the lowest you can get on the scale is 3.
Thank you, sir. May I approach Sister Retreat?
Yes.
Weird scale. Starts at 3. Okay.
Now, later on over the course of that same morning, did you have occasion to become involved in the treatment of another patient by the name of Karen Reed?
Yes.
And may I approach the witness again, Your Honor?
Yes.
So I'm showing you another document, just asked you to look at that. To the extent you can recognize it and look up whenever you finish. In general, sir, do you recognize what that is?
Yes.
Or what do you recognize it to be?
The first part I recognized would have been the medical record or medical note with respect to Miss Reed, who was also a patient that morning.
Thank you. Your Honor, the Commonwealth seeks to introduce in the minutes the next exhibit, a redacted copy of those records.
Regarding no objection, subjects to the redactions.
Thank you.
Exhibit 106.
Thank you.
So we'll be getting a Ms. Little cross.
Now, sir, if you know, about what time was it that Ms. Reed came into the emergency department at Good Samaritan that morning?
I mean, I can tell you from this chart, it looks like that her, at least the first posted vital signs were from 7:51 in the morning.
And in reference to Ms. Reed, what is it that she came into Good Samaritan in regard to? Why was she there?
I'd have to review Daisy's note, so
Well, let me ask you this, sir. Was it in reference to Section 12? Do you recall?
yes.
And with regard to Section 12, patients that come in regard to that, what kind of involvement do you have, or who, if anyone, do you work with in regard to those types of patients?
Sure. So Section 12 I would define as involuntary detention of a person, usually for a mental health concern, whether that's self-harm or harm to others, or if someone who's, afflicted with schizophrenia or psychosis, members of the public can bring someone to or the police or members of the public can bring someone to the hospital on a Section 12, which, again, involuntarily detains them for evaluation.
And in addition to yourself, is there other staff? You mentioned that there were physician's assistants or nurses that were working. How much involvement would you typically have with someone who comes in on that kind of prognosis and diagnosis?
I would say, to answer your question, my involvement is variable and dependent a lot of times on what that nurse practitioner or physician assistant feels like they need or want my involvement to be.
And what kind of involvement would you have as far as when someone comes in with that kind of issue? What is sort of the typical protocol or policies that a Good Samaritan would undergo with reference to that patient? What are you doing with reference to the patient when they arrive?
I'm sorry, I think I don't really understand what the question is.
No, understood. Let me rephrase that. So
It's terrible, the questions.
with regard to a patient coming in on a Section 12, what happens with that person once they present in the ER?
So whether they're evaluated by me or a nurse practitioner or physician assistant, if that person feels like, based on their evaluation, that they need a mental health consult or evaluation, then they would have that initiated, as well as what we do for a lot of patients, or all patients, vital signs, and sometimes blood work as well.
And when it comes to that sort of blood work or assay, as far as what's being done with someone who comes in with that kind of report, what is sort of being tested and what is being looked at as far as the blood work is concerned?
Well, there's a few reasons to get blood work, but in general, part of the evaluation is, with respect to the medical presentation, to make sure there's no medical emergencies present, in addition to whatever the mental health concern may be. There's also blood work drawn with respect to disposition, as far as some people, for example, it would be inappropriate to have a mental health evaluation if, for example, I were intoxicated on alcohol and my alcohol level were elevated, because I think the idea is that you're not getting, a true representation maybe of what's going on.
So am I correct in that someone presents and then there's you medically clear that person as far as any sort of injuries or anything like that first?
I wouldn't say first necessarily. I think a lot of times these processes happen in parallel.
So in parallel, you have the medical clearance and then sort of psychological clearance as well?
Sometimes, yes.
And then sort of involved in both of those, there would be blood drawn and reference to Section 12, as far as a typical one would be looking for sort of alcohol and drugs of abuse, things of that nature.
I mean, I'm hesitant to answer yes because of the word typical, because I wouldn't say there's really a typical presentation with respect to
Just ask him about this
mental
case,
health
for
presentations in
heaven's
the
sake.
ER.
Ask him what he did in this case.
And from your
And then if any of that's
memory
weird.
and or your review of the chart, was that done as far as the blood work done with regard to Ms. Reed on this day?
Are you asking me if blood work was drawn?
Yes.
I believe so. I have to double check. So yes, it looks like there was blood work drawn.
See how easy it is to answer those
And
questions?
among the things that were tested within the facility, within Good Samaritan, was the alcohol screen. Is that correct?
Yes.
And what is the result of that alcohol screen that's contained within those records?
Do I answer or no?
Yes.
So it looks like 93.93. I'd have to maybe look deeper in the chart to tell you the units of that measurement. I don't want to guess. So but to answer your question, 93.
May I approach just briefly on?
Yes.
I just.
Yeah, this is about it, isn't it? Could you tell us sort of what, if anything, you did kind of with regards to the blood and the draw? How compound can we make it?
Direct your attention to a tap portion of that.
Sure.
Do you see the units that 93 pertains to contained in that record, sir?
So yes, it looks like it's milligrams per deciliter.
Thank you, sir. May I approach just to retrieve, Your Honor?
Yes.
Yep.
Thank you, sir. I have no further questions of this witness, Your Honor.
All right, Ms. Little?
Here we go.
Good afternoon.
Hi.
You testified that you treated Ms. Reed when she arrived at the hospital on January 29th, correct?
I don't know if I testified that I treated her, but I was involved in her care. Yes,
You actually wrote the reports regarding her care, correct?
that is not correct.
Would it refresh your recollection to take a look at the report?
The report, I believe we're talking about the note, the emergency room note was written by a nurse practitioner.
Would it refresh your recollection to take a look at some additional reports from January 29th?
Sounds like you want to show me some reports, so sure.
Thank you.
Well, he hasn't said he didn't remember. But she got away with that one a little bit.
May I approach?
Yes.
Take a look.
Yep, okay.
Is your recollection refreshed? Do you recall treating Ms. Reed on January 29th?
I do not.
Do you recall writing a report that has your name, Justin Rice, on it from January 29th?
No, it depends what you define report as. To best answer your, well, do I recall writing this note? No. Is that what your question was?
So is it your testimony that do you recall treating Ms. Reed at all?
No, I don't.
Do you recall actually ordering her blood in this case?
No,
Do you recall sending it out to the labs at all?
no,
As you sit here today, you don't know who collected the blood?
that's correct.
You don't know who packaged the blood?
That would also be a fair assessment, yes?
And you don't know who submitted that to the lab?
Correct.
And it wasn't you, correct?
I can confidently say that I did not, collect blood work. Yeah, I did not do that.
Okay. You testified that you treated Mr. O'Keefe upon arrival on January 29th, correct?
Yes,
Did a firefighter ever approach you on the morning of January 29th and tell you that he had information suggesting that the victim had been struck by a vehicle?
Objection.
Do you remember that?
I do not.
So if a firefighter indicated that he informed you that he had information suggesting that Mr. O'Keefe had been in some sort of vehicular accident, that's something that you would have included in your report, correct?
I don't know if that's a fair assumption.
But as you sit here today, you have no recollection whatsoever of anyone telling you that the victim had appeared to be in some sort of car accident, correct?
Well, I think, I don't have it in front of me, but I think my note that I prepared for Mr. O'Keefe states that per EMS for,
Sorry, what was that?
Dr. Rice, you have no record. Apologies.
It's confusing what's happening since we're just staring at Karen here. Camera guy.
So I don't think he finished his answer.
so I think that what I was trying to say, right, was that on my note, it says per EMS report. So one of the medics, as in one of the folks on the ambulance who brought Mr. O'Keefe in, again, I'm not right in front of my note, but as I recall, it said something to the effect of per EMS report, the patient may have been struck by a vehicle.
Well, can I show you a copy of that report?
Please.
Have you read any of the news about this case, doctor? Have you heard anything about it outside of your own treatment of her? I would want to know that now, if it's not in his notes. Then where did this memory come from? Memory being a funny thing.
Yes.
You could take a look at that.
All right, so,
I'll ask the question. Is your recollection
course.
fresh?
yes.
Is there anywhere on that report that says that the patient came in and there was a statement by EMS that the victim appeared to have been struck by a vehicle?
Just give me a moment to read through the.
Sure.
So no, there is not.
In fact, there's no mention of a vehicle whatsoever, correct?
That's correct.
Dr. Rice, did you observe Mr. O'Keefe's injuries when he arrived at the hospital that morning?
I guess you'd have to define what observe injuries means.
Well, during the course
Really?
of your treatment, did you inspect him for injuries?
So, yes,
You testified that you observed certain abrasions and scratches on his right arm, correct?
yes,
Aside from his injuries to his right arm, and I believe you described sort of a laceration above his eye, John O'Keefe did not have a single other injury on his body from the neck down, correct?
I don't know if that's fair to say.
Well, you didn't report a single injury to his shoulders, correct?
Correct,
You did not report a single injury to his chest, correct?
correct,
You did not report a single injury to his torso, correct?
correct,
You did not report a single injury to his back, correct?
correct,
You also did not report a single injury to his ribs, correct?
correct,
No injury to his hips, right?
correct,
You observed no injury to his knees, correct?
I reported no injuries to his knees, correct,
No injuries to his shins, correct?
correct,
No injuries to his ankles, right?
correct,
And no injuries to his feet.
correct.
From the neck down, he did not have a single broken bone, right?
I don't know if that's a fair assessment or statement.
You certainly didn't notate in your report that he had any broken bones from the neck down, correct?
No, I did not. I'd happy to explain that, but to answer your question, no, I did not.
You did not report a single fracture from the neck down, correct?
I did not report a single fracture, correct?
The injuries that you testified to today were that he had sort of a laceration above his eyelid, correct?
The injuries that I testified to today, correct, yes.
And the scratches on his right arm.
On the right forearm, yes.
What about the back of his head? The big old
No
gash
further
on the back of
questions.
his head.
Hey, Mr. Lally?
Weird.
Dr. Rice, with reference to fractures or broken bones, can you explain sort of why that may not have been noted or why that wasn't included within the chart?
Sure, yeah, I'd like to. So with a patient like Mr. O'Keefe who came in, the focus of myself and the team of physician assistant, nurse practitioner, and nurses, whoever was helping in a case like this, the focus is in core resuscitative medicine, of securing an airway, making sure he has a breathing tube in, making sure that the CPR is being applied the right pressure to the right place, making sure that the core resuscitative elements of medicine are happening, unless, as in the mind can only focus on so much. So I think in cases like this, because the attention is on resuscitation of someone's heartbeat, their life, there's less focus on injuries or observations that don't coincide with the resuscitation effort or not pertinent to that resuscitative
Well,
effort, if that
he
answers
had massive
excuse me, if that
internal
answers your
injuries,
question.
Those would
So
be
in that vein,
pertinent.
it's not like you're doing x-rays or a full skeletal survey or something like that?
No, we're not doing a full skeletal survey, no.
Because you're more concerned with the fact that his body core temperature is 80, his heart isn't pumping blood, and he's pulsing, correct?
Correct, unless there was an extremity injury that would be pertinent to his resuscitation. If he had had a traumatic amputation, as in removal of a leg, for example, that would be pertinent to a resuscitation, but an otherwise intact extremity,
Well, if his brain was
is not
hanging out of his
necessarily within
head,
the realm of resuscitation.
that would matter. If he was bleeding internally,
Yes.
that would matter.
I'm going to direct your attention on the document, indicates discharge and clinical impression. If you could just read from that, look up when you finish. Read to yourself.
I'm sorry, what would you like me to read out loud?
So as far as the chart is concerned, as far as your clinical impression of Mr. O'Keefe, can you read sort of what you?
Sure, right. So I wrote clinical impression, cardiac arrest, head trauma, exposure to environmental cold.
May I approach this to retrieve him?
Yes.
No further questions.
Anything further, Ms. Little?
No further questions.
All right, thank you, Doctor. You are all set.
Thanks.
That was a little weird.
Rather than where it's 10 minutes of one, jurors, can we do an abbreviated lunch today so we can get as much of the testimony in as possible? So it's 10 minutes of one, why don't we come back here at 1:30? And can we go until 4:30 today? People seem to say yes. If that changes, just let Officer Delano or Officer Biden know. Okay, thank you. So we'll see you back here at 1:30.
All rise for the court, please.
You are muted.
Okay.
So taking a lunch, and they'll come back at 1:30, which is 1:30 my time, which is 40 minutes from now, and then they are going to go to 4:30, which is 1:30 my time. I found that strange. I definitely understand that doctors often don't like lawyers. Doctors are the ones who, you know, they don't like getting their deposition taken. They don't want to be converted into any party's expert witness. Oh, they're having a conversation about something.
So the two of you talk, and if you're not in agreement, I would like a copy of both by 1:15 so that I can decide it before it goes in, and then it will be the next exhibit, either with or without the additional redactions. Okay?
Okay.
All right, thank you.
Sorry, guys, I'm going to pop back so I can see.
We'll see to say yes. If that changes, just let Officer Delano or Officer Biden know. Okay, thank you. So we'll see you back here at 1:30.
All rise for the court, please.
I should have known, of course, the one time
You
the jury
are muted.
leaves, that they wanted to have the conversation about that. Give us a second here. We'll see what they said.
No, I can.
Wow. Wow, Karen says. Yeah, wow. I agree. It's weird.
Thank you. You may be seated.
All right, so as far as the redactions that you think should be there, Ms. Little, and you perhaps don't, Mr. Lally, I don't know if the testimony opened the door any on some of what may or may not have been there. I don't have it in front of me. I haven't seen it. So the two of you talk, and if you're not in agreement, I would like a copy of both by 1:15 so that I can decide it before it goes in, and then it will be the next exhibit, either with or without the additional redactions. Okay?
Okay.
All right, thank you.
Okay, so that was about redactions to the medical record, which is quite strange because they have admitted it already. You have admitted it. You have admitted it, and it hasn't been redacted yet. So you don't have an agreement on what's been admitted or not yet. This is just so bizarre with Judge Bev being super hyper technical about some stuff and super loosey goosey about other things. You don't go messing with exhibits after they've been admitted. He's already testified about the contents. It's in. It's just nuts. So I understand doctors don't always love lawyers because lawyers accuse them of malpractice. Lawyers drag them into their lawsuits. And lawyers, can try to turn the ER doc, the treating doc, into the expert, try to get all of his opinions about stuff. You're not paying him to be an expert. It's not his job to necessarily have those opinions. So they can resent that kind of thing. Like, I totally get that. But this just came across as a little bit weird to me. He doesn't want to acknowledge, like he's trying to create room for there to be injuries that he didn't observe. It seems strange. I mean, I guess I already know the big old gash to the back of his head. He didn't observe that, but this explanation is not a good one, because if the explanation is, you only look for injuries that are pertinent to the resuscitative efforts, well, yes, you need to know if somebody has an internal injury that is bleeding that is going to interfere with your resuscitative efforts. If somebody has been in a car accident and it's a massive force and it's torn the aorta of their heart, like, Princess Diana or something like that. These things happen. You can pump on that heart all day. You're not going to resuscitate that guy, because until you deal with the problem of the blood can't complete the circulation because of this injury, you're not going to resuscitate the guy. It's kind of relevant. He's bleeding to death. So it does not explain if you didn't look for internal injuries, that's not a reason. That's not a reason why. That's not a good. It's very strange. I don't know why. I don't know why he seemed quite defensive about that. We know he doesn't have an independent recollection of this stuff. But insisting he didn't write the note, but then he did write the note, and then he remembers what's in the note about the EMS, but it's wrong? Is that maybe in somebody else's note? Boy, I don't know, but I would have wanted to have known. Dr. Rice, have you watched any of the press coverage on this case? Have you seen this case in the news? Have you been aware of some of these factual allegations from other circumstances? That's all I need to ask. I don't need to ask him, is it possible that's covering your memory? That's affecting your memory of these things? Because that's the logical conclusion from it. That's the argument. You can make an argument. You don't have to ask him that. But I want to know the facts, because I want to be able to explain, why is he coming up with this information about what the EMS might have said about a car accident when you don't remember anything independently and it's not in your notes? Why would you even be thinking that's in your notes? Somebody suggest that to you? Did you have conversations with the prosecuting attorney about your testimony? Did you have any conversations with the medical examiner about your testimony? I would want to be exploring possibilities for memory contamination there. Yeah. Just a bit strange, and somehow missed that enormous gash to the back of the head, where I'm pretty sure he had skull fractures and stuff. I can totally get you're not going to run and do a head x-ray while you're trying to give a guy CPR. That makes sense to me. But you don't even notice that? You didn't see that on the back of his head? Like, wouldn't it be like matted with blood? Wouldn't it be noticeable? I guess it doesn't matter. So you don't write it down, but you wrote down the one on his forehead. Why would you not write down the other one? Does it make him look bad with the thoroughness of their inspection of him? Maybe. I don't know. Maybe that's what it's about. Just a bit strange. I saw a lot of people not impressed with the doctor. I wouldn't want this guy treating me. This guy can't even explain, hypothermia and stuff. I'll cut him some slack on this too, because his questioning was terrible. The questioning is absolutely terrible. I mean, we're not here to learn about medical protocols, about what you would need to know in law school for the general knowledge that you apply in a specific situation. All we need to know is what happened with John O'Keefe. How did he present? What did you do? And then if we don't understand any aspect of that, clarify that. Can you spell out for us what that means? Why was that significant? I don't know why we're trying to do this testimony like what he did is just some abstract process here. No, he worked on an actual patient in an actual condition, did specific things. That's what you're there to talk about. So just really terrible questioning that he got. And so, yeah, no wonder he's very confused a lot of times about, I'm not sure what you're asking here, because Mr. Lally is trying to get him to talk about the significance of things that he, Mr. Lally, the non-medical professional, thinks are significant, but they're not speaking the same language. They're not in the same place. So he doesn't know what you think is pertinent and relevant. That's why he's not talking about that. Yeah. I'll cut him some slack on a lot of that stuff. And ultimately, it's not his job. He's not an educator. He's not there. He doesn't need to educate anybody in his ER about what's hypothermia. You just need to know how to recognize it, treat it, what to do, who needs to do what, who stands in what position, who's getting what tool, who's taking the note. I mean, that's what you need to do. That's what you need to do to be able to treat a patient. So him not being able to explain all of this stuff in layman's terms, that doesn't particularly bother me. It doesn't mean, to me, it doesn't mean he's not a good doctor. But he didn't make a great impression. It was very, very strange, very strange. And I'm still I'm very baffled about what role he had in the Section 12. It's not clear to me he did anything at all other than just be the attending doctor in the ER that day. Did he even see her? I don't know. And I'm left very confused still of what the process even is. I mean, what the process even is. What do you do a psych exam or not? I mean, you're not a psychiatrist, but I presume in an ER you have some basic low-level stuff that you can go through to identify basic issues, common problems. The ER, yeah, you see a lot of people who are in mental health crisis. You see people who are psychotic. You see people who are under the influence. So what do you do with the section? I don't know. All I got was, well, sometimes you do a medical and sometimes you do a psych, but like maybe not always. Well, okay, well, why not? I mean, they're there for psych. Section 12 is psych, right? Mental disorder that's causing you to be dangerous to yourself or others. I did not like how he then threw out this side, or if you're schizophrenic or psychotic. No, you do not get to be hospitalized just because you are schizophrenic and psychotic. Crystal clear, U.S. constitutional precedent, you must be dangerous. It is the dangerousness that justifies the detention, the restriction on your liberty, not simply being mentally ill. It doesn't matter how schizophrenic you are. It doesn't matter how psychotic you are. It doesn't matter how out of touch with reality you are. If you're not a danger, you're not causing a risk of harm to anybody, that is not grounds to detain you. What I think he's probably getting at is that there's a lot of places that allow a detention under what I will call, because it's what we call it in my state, a gravely disabled standard. It's not directly I'm harm to myself because I'm gonna injure myself or I'm gonna injure somebody else. It's more that I'm unable to take care of my own needs, and so because of that, my condition is likely to decline. I can't feed myself. I can't keep myself safe. I can't keep myself clothed. These things are going to get me into situations where I am vulnerable, or I am going to be, I'm like, if I'm not feeding myself, I will eventually starve. I'm gonna affect my health and my ability. It's not a deliberate thing, but just because I can't take care of myself. I think that's what he's getting at. This kind of gravely disabled standard. Somebody who is floridly psychotic is often, but not always, going to be in that state. But I would certainly expect, if he's running into people in the ER, he's probably running into those types of situations as well. So what do you do? What do you do? What's the process? I'm completely in the dark still about what this process is, what your role was. Did you do anything besides just pull Karen Reed's blood? See what her blood alcohol level was? You didn't tell me anything about the process of how this was done, and I'm interested to know this. And the big reason why is because in a lot of states you've got specific procedures for blood draws for alcohol stuff. So like if you're the police, somebody's DUI for whatever reason, they end up in the hospital. Maybe it's an accident type of situation. There's been an accident. They're in the hospital getting treatment. You're doing your DUI investigation. You have probable cause to think that person was driving under the influence of alcohol. They're not going to consent to give you a breath test. You're going to get blood instead. Very, very common for states to have real specific protocols for how that blood is drawn, because the requirements to get a valid sample for blood alcohol analysis is different than the protocols that hospitals often use for drawing blood for any and all purposes. And the reason why is because very common to use alcohol as a disinfectant. When you get the little swab, on your arm before they stick the needle in. Yeah, that's often alcohol. And so typically if they're going to do a blood draw for alcohol, well, this is a problem here, isn't it? Because you're putting there the presence of the thing that you're trying to test for endogenously. So they often have to adjust that by using iodine or betadine or something like that, some other type of disinfectant before they put in the needle, so you don't contaminate the sample. It's not the normal process that you use in the hospital, so that's why you often need a specific protocol for this type of blood draw, because it's not normally what the hospital does under those circumstances. So I'd like to know that. I would like to know that. I mean, that's a very important part of this blood draw, and the validity of this blood draw is, what did you use for disinfecting? Who stuck the needle in? What did you swipe her with? I mean, I'm gonna need to know that. I'm gonna need to know that. If you swiped her with alcohol, we can throw out this result. It's not gonna influence me, because I can't count on it to be measuring only what's in her blood and not what you just put on her skin and then stuck a needle into. If you used iodine or betadine, it's gonna have a lot more weight, So I'm gonna want to hear that. This guy doesn't seem to know much of anything about that, doesn't seem to have had really any involvement at all. So I guess we'll get that from some of the other medical professionals. And I'm assuming that's what we're getting today. We're going to get the folks who were there, who were the treating at Good Samaritan. Maybe we'll get the person who did the blood draw. We've got, besides Dr. Justin Rice from Good Samaritan, we have Daisy Ormseth, who is the nurse practitioner. We have Kathleen Wilfert, who is a registered nurse. We have Dr. Gary Fowler, the medical director. I don't know what he did or would have done in this situation that added anything to that. Way down the list is Nicholas Roberts from the Massachusetts Office of Alcohol Testing. Are they the ones that tested the sample for alcohol? Did they not test it in the hospital? I don't know. All very confusing how all of this stuff is going to fit together. So that's going to be important. If the nurse says, yeah, I swabbed her with alcohol, and then we sent it off to this off-site place to measure the alcohol, I'm going to be wondering, what does this have to do with the Section 12? And what did you actually do relating to a Section 12? Because I haven't heard anything yet. And then I'm going to want to know, you know, how can this be valid? How can this be valid? I don't know. Well, guys, before we jumped, I was talking about my Substack piece, and I'll go ahead and pull that back up and kind of finish my thought process about that. Because we were talking about this third-party culprit case, this Tavares case, where it's so different from what we're dealing with right now, because we had an eyewitness. We had an eyewitness who said it was somebody else who did it. The attorney never investigated that, even though it had been provided before trial. The judge had the witness had been in court, and the judge had ordered the witness, you need to be available. You need to, in case you need to be called in for this trial, in case they need to talk to you, you need to make yourself available. So he's, for practical purposes, kind of like being under subpoena, but they never followed up on it. The trial attorney never followed up on it, never asked for a continuance to follow up on any of it. When he was asked to explain, the attorney basically said, well, I didn't want to continue the trial because I didn't know if my other witnesses would be available at a continued trial date. Sounds like a strategic reason, kind of, but strategic reasons often get a lot of deference from a reviewing court looking at, did this attorney give an effective assistance of counsel? If they made a reasonable strategic decision, it's not going to be overturned. So you're not required to do everything that is possible to do in a case, because you may very well have reasons for not doing certain things. A door will be open that you don't want to open. You don't want to highlight certain things for the jury. If I call this person to testify to one thing, they have bad information that might also come in. I mean, there's a lot of these types of calculations, these trade-offs that you're going through. when you're making a decision about how to present a case. So it's not a situation where, oh, there was something good and they didn't use it, therefore it's automatically ineffective assistance. No, they're going to look at why you didn't use it and how good was your reason for not using it. In this particular case, they said, that's not a good reason, which I mean, I tend to agree. You can get the witnesses under subpoena, and then if they don't show up, they should be under subpoena anyway. If they don't show up for a new trial, then you can get a material witness warrant if they're significant. And in that particular case, they said, well, these weren't even, frankly, very good witnesses anyway, because they didn't help you out very much. They weren't so significant that they justified not potentially exploring this guy who can put the murder weapon in somebody else's hand. That's a pretty important piece of evidence. So anyway, this case I thought was it was very intriguing just because it was so recent. Judge Canoni did say this trial attorney was ineffective. She threw out the conviction, awarded this guy a new trial, and that was all affirmed on appeal. They upheld that decision because this was such a potentially strong third-party culprit defense. And by not pursuing any of that, you've essentially waived his ability to be able to present that. So gets a new trial out of it. And it's just such a strong contrast to what we're seeing here, where they're hardly, being allowed to explore the third-party culprit stuff at all. And given what I think I've seen in her record with this tendency to be colored by the facts, by what she knows, to have kind of an initial reaction to the case, and then her rulings tend to follow that impression rather than to drive it, to be driving the ship. That because she's anchored by, well, this is what a third-party defense should look like. This is what it should look like. This is a strong one. This one is so good that it's ineffective to not be investigating it, to not be pursuing it. If she's anchored on this, then yeah, Karen Reed's third-party culprit argument, it's not this. She doesn't have this case. She doesn't have this guy. But does that mean it's not enough to get to the jury? I think, like I said, if they have someone that's going to be able to get on the stand and say this is a guy who was beat up and died, not a guy who died in a car accident, then yeah, I think that hurdle has been met and they should be allowed to do it. And so I'm gonna wanna see if they get to. I'm gonna want to see if they get to do that. But of course, again, this all is very dependent on what emerges, what comes out. So this leaves me with not a lot of optimism for Karen Reed on appeal, just in general. It's good in the sense that if they can find the right issue, if they have the right issues and can frame them the right way, not Judge Canoni made unreasonable decisions about admitting or excluding evidence, those are not particularly strong arguments. Although I do think there are some that they will probably raise there, like this stuff with Aruba. But it's going to be more, I think that Judge Canoni misunderstood the legal standard when she was making this ruling. Those are stronger. And that's where she doesn't necessarily have a great record of getting it right. Because she is so colored by my initial reaction to the case, that then colors my interpretation of what the legal requirements are, because they converge on the outcome that I want to achieve. That's potentially a stronger argument for her, because if her initial reaction of this case is this hoax thing is bullshit, she shouldn't be able to do it, then you're going to be interpreting the law, in a way that suggests that's the right outcome here. And it's just not clear to me that that's a reasonable interpretation of the legal standard here. Other types of rulings like that involve a lot of these pure legal determinations, well, some of the stuff dealing with pretrial things about disqualification, about recusal, stuff like that, those can be issues where you didn't have the right legal standard in mind when you made the decision that you did. particularly with the DA's office, that ruling on not disqualifying the DA's office was quite a challenge for me. I didn't get it because she's saying straight out these statements that Mr. Morrissey made in the press conference violated the rules of ethics. Like, they crossed the line, they were improper, but they weren't improper enough to require him to bow out. Like, I don't understand. I don't understand the distinction that I guess she was drawing there. So that's an area where there, can potentially be room for them. But having said that, the standards are so extremely deferential, and what we've seen is a lot of times when she rules for the defense, it doesn't hold up. It doesn't hold up. The reviewing courts are not necessarily particularly defense friendly. And so it doesn't mean that they're going to knee-jerk reverse because the outcome would be in her favor. Like, I'm not saying that the Court of Appeals necessarily has an ideological bent that they're going to be stuck on. But it does give me concern just about the progress of this trial, because it is natural that people learn from those types of outcomes, that if you rule for the defense and you consistently get reversed, you learn the way to not get reversed is to not rule for the defense so much. If you haven't been reversed ruling for the Commonwealth, you are going to see that is safe. It is safe for me to rule for the Commonwealth because even if I make a mistake, they're just going to say it's harmless error. So it does give me some concern about what we are seeing in this case potentially, and some of the reasons why we could be seeing it. Because it's easier. It's easier, safer to rule for the Commonwealth than it is to rule for the defense. So I went ahead and, if you're interested in any of this, by the way, I linked those cases that I looked at and just gave a little summary of what they all were. I don't know, it's just kind of interesting, I think, to see sort of how a judge's process gets broken down. So anyway, if you're interested in that, check it out over on my Substack. It's andreaburkhart.substack.com. You can find my page and check it out. I'm putting a lot of stuff about this case on there. I did my scorecard. Finally got my scorecard out a little bit ago. So broke it down round by round to see where we're at right now. We're in the Commonwealth's case. They should be so far ahead. They should be so far ahead with all of this stuff. But they're not. They're not. And it's kind of wild. I mean, the defense hasn't even put on a case yet. Defense hasn't even put on a case yet. They should not be in this position. They should really not be in this position to be able to make all this hay, It's just a little bit nuts. So guys, I'm going to take a real quick break here since we're on the lunch. They're going to short us. We got about 10 minutes left. I got to run out and check on the animals and make sure I got my tea ready for the afternoon session and stuff. So I'll be real quick, but I will be right back in a few minutes. So please go ahead and hang with me. Okay, trying not to jump scare here, but I am back. Made it quick this time. I'm going back over the evidence list now. God, sorry guys, I don't know what's up with my voice today. I think it's getting to be allergy season. Anyway, I've gone back over the witness list here to see where we're at, and I am still getting a count of 41 witnesses still on the list for the Commonwealth. A little bit over halfway. They had 87 total on there. We got 41 still to go. And we're about to wrap on week 5 at the end of the week here. Yeah, I don't think we're going to be done in 6. I don't think they're going to be done in 6. I thought they were going to be done in 4. I don't think they're going to be done in 6. I think they might not be done for like 8. I will grant that a lot of these people may be short, may not have a lot to say or a lot to add. But some of them are not. Hello, we already know Michael Proctor and Yuri Buchanek. These are not going to be short examinations. The medical examiner, I would not expect that's going to be a short examination. This is stuff that is going to take time. Very, very alarmed by the Commonwealth's pacing here. Their just seeming inability to be able to get this stuff done in the time frame they said they would be able to get it done. They should know. They should have enough trial experience that they know how long it takes them to get through this stuff. And so their inability to correctly project that in this particular case, yeah, that bothers me. But really, it should be bothering Judge Bev, and yet it doesn't seem like it is, and that's a little alarming as well. Let's go ahead and go back and see where we're at with the comments until court gets back with us. Law Nerd Junkie, what are your thoughts? Here we go. What are your thoughts on the Commonwealth not calling the lead investigator Proctor? Also thoughts on the defense calling him? Well, yeah, it's a real problem if they don't. I mean, right? That's pretty much an admission that they can't call him because he's the lead investigator. He's the one who coordinated all this stuff. He's the one who put it all together. He's the one that presented it to the grand jury. If you don't get that information from him, you're going to have a challenge with, I mean, for certain things like the phone. How are we going to establish the chain of custody for the phone if Michael Proctor doesn't get called? He's the one that's put in his report under oath. He recovered it at the scene. So if he got it, he's the one who put it into evidence. He's a critical part of the chain of custody there. Maybe other stuff like that as well. I don't know. We'll have to know the details. But certainly he's the one that made those types of decisions about how the investigation was going to unfold. So to the extent you already know the defense is relying on challenging your investigation and arguing it was deficient, it was bad, you messed all this stuff up, it's on him to overcome that. It's on him to justify why you proceeded the way that you did, how this, if and how this is consistent with policy, why you would do it that way and not another way. Why didn't you record any of those interviews? Big question I have. Why would you not record the interviews? It's as simple as turn your body cam on, and you didn't even do that. It's as simple as hit record on your phone, and you didn't even do that. Yeah, we would I think like to know why. So it makes them look very, very bad if they don't call him. And the defense then has options for what they're going to do about that. Well, very possible you get a missing witness instruction under that circumstance. A missing witness instruction is a situation where if one party is in a, I guess, peculiar position, a special position to be able to call a witness forward and chooses not to do that, then the jury can be instructed that it's because you didn't call him because the jury can assume that evidence would have not gone well for them. It would have been against their position. It would have been unhelpful. It would have undermined their case. So it's a powerful instruction that can be given when it's appropriate, when the standards are met, because I mean, you get to infer. I mean, the jury is explicitly told, assume it would have been bad for him. So that's one option they could potentially have to deal with it. They can potentially call him themselves. Yeah, they can potentially call him themselves if the Commonwealth doesn't present him at all. And that's where this whole issue with the cell phone could end up being a little bit of a boon to the defense, because even though Massachusetts allows a party to impeach their own witness, it's not a place where once you call a witness, you're stuck with their credibility and with what they have to say on the stand. You don't get to contradict them in any way. We saw that in Duck v. Heard. It was kind of one of the limitations that they were dealing with there in Virginia. You're not allowed to impeach your own witness. Massachusetts doesn't have that rule. You are allowed to do it, but still typically you're not allowed to call a witness for the sole purpose of doing that. You have to have some valid independent reason to call them, some information that you need to be able to elicit from them that justifies you calling them in the first place, and then you can potentially go down the road of impeaching them. So that's where the John O'Keefe cell phone, that could be really important. That could be really important because he put himself in the chain of custody for that phone in his report. That's a legitimate fact for the defense to elicit, and they can call him for that purpose. And then if it so happens that he's impeachable on that or on anything else that they have cause, they get to just sit there with his report, go through his report, anything that's in his report that's helpful to the defense that they'd want to call him for. Yeah, they get to do that. They don't have to impeach him on that. They can call him just for the purpose of establishing you didn't record this interview, you didn't record this interview, you didn't record that interview. These are just facts. These are not impeaching his credibility. These are just facts. It just happens to make the Commonwealth look bad. But it's information that the defense is entitled to elicit, and they're entitled to elicit that through just direct testimony. He will admit it or he will not, and if he doesn't admit it, then you're going to go impeach him with his reports and so forth, his prior testimony, anything like that. So, yeah, I think a pretty decent chance that if the Commonwealth doesn't call him, the defense will. And the reason why is just because there's too much good to get from him to just rely on that inference. I mean, the text with the friends, my God, you gave us that in opening. we need to see that now. We're going to need that. We're going to need that in the case. Those texts with your friends, the where's her nudes, the nothing's going to fall back on the homeowner because he's a Boston cop too. Yeah. That's pretty important evidence for them to get in. So they're not just going to rest on a, we'll get a missing witness instruction and the jury will be told to draw presumptions against him. Yeah, I think they're going to call him. I think they have a good basis to call him because they still get to make the point to the jury in their argument. Why didn't the Commonwealth call this guy? We had to call this guy. We had to call this guy. And here's why, because you can see all the bad stuff that comes out when this guy gets put on the stand. It doesn't help the Commonwealth to try to avoid it because it's going to come in anyway. So all they can do is try to take that little sting out of that argument. The Commonwealth didn't even call him. You can take that one away. But the rest of it, it's going to find its way in. It's going to find its way in. So, yeah, I think there is less than a 1% chance that we don't hear from Proctor in the course of this trial. Tim Harris, it seems like the logic of impossibility of any reasonable alternative is accepted by us peasants, but not by you lawyers, e.g. Murdoch trial. Well, so I've explained that a lot of times when I'm talking to a jury, when I'm pitching a case to the jury, this is how I talk to the jury about reasonable doubt. I talk about, are there reasonable alternative explanations for the evidence? Because if you can reasonably fit the evidence into an alternative explanation that hasn't been proven out, it's not just possible, but it's it's a plausible interpretation, then I argue that's reasonable doubt. And so the only way you should be convicting is if there is no plausible alternative explanation of the facts that would fit it. And I mean, there is a lot of the times, if somebody's on video and they've got a terrible excuse, I mean, how do you come up with a plausible alternative explanation for that? Lots of times you can't. But in many cases, yeah, there are doubts around the edges. There are questions about who did what, where, for when, what was their motivation, all of this type of stuff. And so that's where a lot of the defense argument is made. Maybe you have my client dead to rights on the actions were committed, but it's not really clear what motivated them or what led to them. Maybe it's not clear whether this is an animus, intentional murder type of situation, or this was an accident, this was a recklessness, this was some other type of mental state. So if I can pitch to you a plausible interpretation of the evidence that supports my argument, I'm going to be arguing to you that's reasonable doubt. Now that's just the way that I think about the cases. With the Murdaugh trial, I mean, that's what I'm saying. That's I have not ruled out a plausible interpretation of that evidence being that he was there and he knows a lot more than he's telling us, but he's not the shooter. And he's got a million other things he's trying to hide that are playing into why he wouldn't want to be telling us what he knows about what happened in that situation. Particularly, he's a slimy kind of guy. He's a liar. We can't really trust anything he says anyway. So it's just a situation where I felt like they didn't really have him dead to rights. They really hadn't ruled out all of the plausible alternative explanations there. Obviously, the jury disagreed with me, and that's fine. I'm a defense lawyer. The jury is a jury. They are going to have a different tolerance, I think, for getting it wrong versus getting it right. I'm sitting here as a hypothetical person at my desk, not having had to sit on that jury and make a decision and then go home and live with myself with the consequences of the decision I made. So you're always kind of Monday morning quarterbacking that type of stuff. I don't know what I would have voted if I'm on the jury. I don't know what the experience was like in the jury room. You always like to think how you would behave under a certain setting, but I don't know. I haven't been in the position of having to make a decision like that. So all I can really do is think about it hypothetically, think about it in terms of how I encourage jurors to think when I have them in front of me on the other side of a case like this. And so it's not that I'm especially credulous. I think I'm actually quite not credulous. I'm very skeptical. I just don't believe much until I have good evidence of it. I have very little faith in what people say. I have very little faith in what people see or what they report they see or what they remember. These are too flawed. These are very flawed. And so I'm always going to be skeptical when those are the main bases for somebody to be put in a box, somebody to be locked away and put in prison. Doesn't mean there's no circumstance where I wouldn't convict just on testimony. Lots of cases are he said, she said. Not saying I'd never convict if that's all there is, but just it's difficult. It's difficult for me to say beyond all reasonable doubt. I can put that much confidence in somebody's word alone. That's just me and my perspective. That's not going to be everybody, and that's fine. That's why you have jurors of multiple people, so that they can all come together and try to reach some kind of compromise viewpoint that everybody can live with. So maybe what we just differ on is what a reasonable alternative is. maybe the argument is that it's not a reasonable alternative, that Mr. Murdaugh was there, knew what happened, saw what happened, had more information that he was letting on, and still somehow wasn't involved as an accomplice. maybe that's not reasonable. I don't know. But I don't think he was charged as an accomplice. I think that was part of the issue. He was charged as being the principal shooter. And if that's all they have to go on to prove that he was the one with the gun, I personally, it didn't clear that hurdle for me. But yes, I totally accept that could be tainted by my perspective, just based on this job that I do. Anton Ivanov, how bad for the Commonwealth if Proctor not called? Yeah, same thing. It's bad. It looks really bad. How do you not call your lead investigator to the case? You need him to establish certain things with chain of custody and so forth. So you have to. You just have to. You can't not bring him in. You can't not have all the pieces tied together about who was interviewed, why, how these decisions were made, what conclusions were reached, how you got all this evidence. You can't leave that on the table when he's tied to so much of this critical stuff. Nikki B, might we see a law enforcement custodian of records testimony? I'll come back to this because court is coming back in now. Let me go ahead and get it up here.
Thank you. Please be seated. Court back in a second.
All right, so your next witness, Mr. Lally?
Yes, Your Honor, the Commonwealth called Dr. Gary Fowler to the stand.
So this, if I'm not mistaken, is the guy who's the medical director. Okay.
Just watch your step forward. Step right up. Raise your right hand, please. You solemnly swear the evidence you give the court and jury the case now here to the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Thanks.
Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for the record?
Gary Fowler, F as in Frank, A-L-L-E-R.
And sir, that microphone in front of you, you can move that any way you wish. So if you want to bring it up or down, just the wand itself. And what do you do for work, sir?
I'm a pathologist.
And
Pathologist.
where is it that you work?
I work at Good Samaritan Medical Center.
And how long have you been working as a pathologist at Good Samaritan?
Since November of 2015.
Now, if I could ask you just a few questions about sort of your educational background, starting with your undergrad, where did you go to school and what, if anything, did you receive a degree in?
My undergraduate education, I went to Tufts University.
All right, so doctor, I'm going to ask you to put the microphone perhaps underneath your mouth and speak into it, because in order to keep this room cool, we need to have these fans going. If they can't compete with you, we'll have to turn them off, and I think everybody would prefer to have them on. So please speak loudly.
How am I now? Okay?
Perfect.
Okay. So
Please
Tufts
don't
University,
eat the mic.
undergraduate. I have a degree in biology. That was
And after you received your degree in biology from Tufts, where did you go from there?
I went to Tufts Medical School in Boston for 4 years there.
And after you graduated from medical school, where did you go from there?
I went to a residency in pathology, anatomic and clinical pathology at Tufts Medical Center. So I stayed within the Tufts system. Okay.
And how long was that residency?
That residency was, at the time, pathology residency was 5 years. It's now 4 years, I believe, but it's a 5-year program. I finished the residency with the chief of resident in pathology in my 5th year.
And then following your residency, where did you go for work from there?
In 1996, I finished residency, and my first job was at Kearney Hospital, beginning the end of June of 1996.
And how long did you work at the Carney?
I'm still on medical staff at Kearney. So ever since I was transferred to help Good Samaritan Medical Center in 2015. My full-time job is at Good Samaritan now since 2015, but I still cover Kearney Hospital every now and then.
And are you board certified?
I am board certified in both anatomic and clinical pathology.
You've used that term, and just if you could explain to the jury what your understanding of that term is as far as pathology and sort of the difference between anatomic pathology and clinical pathology.
Sure. Pathology, there's two subspecialties, I guess, in pathology. One is anatomic pathology, which is basically if you, as a patient, go to a hospital or have a biopsy or a tissue biopsy or an excision or anything like that, it comes to the pathology department, and an anatomic pathologist is responsible for making the diagnosis for that patient. So we abbreviate that as an AP, anatomic pathologist. So in residency, you can also train to become a clinical pathologist. And clinical pathologist is a pathologist who basically deals with, to put it simply, if you have a blood test that goes to that gets sent to the lab, we are essentially responsible for the quality and the safety of that blood test to help ensure the lab tests that are done on the specimens are accurate.
Now, with regard to your position at Good Samaritan, what is it that you do at Good Samaritan? What are your sort of duties and responsibilities in relation to that hospital?
I am the chief of pathologist at Good Samaritan Medical Center. I'm also the laboratory medical director. So my job at Good Samaritan is to ensure, quality of both the anatomic pathology side of things as well as the clinical pathology side of things. Ultimately, my job is to help ensure that any laboratory report coming from Good Samaritan is accurate.
Now, the lab at Good Samaritan where the testing is done, is that accredited?
Yes, it is.
And can you explain to the jury sort of what that accreditation means, who it's by, and sort of what goes into that accreditation process?
We are accredited by the College of American Pathologists. We abbreviate that as CAP, if I mention that later, just so you know. And the accreditation process, the CAP has been in business for 75 years or so. They, according to their website, are the preeminent accrediting body for medical laboratories. So what that means is every 2 years we have an in-depth laboratory survey. That's every 2 years, and there are over maybe 3,000 elements or checklist requirements that the CAP will look at in our lab, which ranges from anywhere, for quality, mainly quality control, making sure that we have enough staff members, just about anything that can affect a laboratory result. There is essentially a checklist requirement that we need to fulfill and pass. So that's every 2 years.
And is that accreditation, is that up to date as of now?
Yes, it is. We will be having another inspection. Our window opens in July, so it's coming up. We have a 3-month window where the CAP can come anytime unannounced. So.
And was that accreditation up to date prior to January 29th, 2022? Now, far as the clinical portion of the lab, what are some of the things that get tested as far as, what are some of the things that are tested for in the lab as far as blood work is concerned?
Just ask him, do you test for alcohol?
Many different things. As probably all of you know, when you go to a hospital, you have your blood tested, and the physician is looking for different tests such as like a sodium, a potassium, a chloride, some basic tests that if they show abnormality, that could help them help the clinician make a diagnosis on you. So the most common things would be like a glucose, sodium, potassium, chloride, stuff like that.
Now, there's some sort of like standard algorithm for things that are tested, or does it sort of dependent on
Stop saying
the
algorithm.
patient's
What's
presentation?
with the algorithm today?
I think it's depends on the patient's presentation. There's no standard ordering test that one can order. So it depends mainly on what the doctor is thinking and his differential diagnosis. He will order, a variety of different tests. Some tests are pretty standard. When you go to a hospital, they might order, the test that I just talked about, a CBC. They want to look at your complete blood count.
Just a little louder, please.
Okay, sure. Things like that. Want to look at your hemoglobin, hematocrit, maybe sodium, potassium.
hematocrit.
Those are some of the really
You can
common
look at
tests that
hematocrit. We can talk about
would
that.
get ordered in the hospital.
Now, as far as drugs of abuse, including alcohol, is that something that's dependent upon the presentation of a patient to your facility?
I think an alcohol test or a drug of abuse test is not a routine type of order or test. It all depends on if the clinician or the primary care physician is suspecting could be drugs of abuse or alcohol on board, and they need to know if so to help treat the patient.
Now, would that also include sort of a patient that presents in regard to a mental health status or Section 12 drugs of abuse? Would that be somewhat standard in relation to testing or blood work that's done in relation to that kind of patient?
As far as Section 12, I do not know if there is a standing order for a routine ordering process for a patient that is admitted to Good Samaritan under Section 12. So I'm not sure.
Would that be abnormal, though, as far as doing a blood draw and testing for alcohol and someone presenting on Section 2?
Foundation.
I don't think so,
He's
no.
the pathologist.
Now, with regard to a blood draw in Good Samaritan Hospital with reference to testing for alcohol specifically, what, if any, sort of policies or protocols are in place in reference to that type of blood draw?
I think a test for blood alcohol is the phlebotomist pretty much has to run through the same protocol that he or she needs to follow for any type of blood test, except for the fact that we do not want to use an alcohol swab
Thank you.
to
Yes, that's
clean
important.
the area before the blood draw. In theory, if you use an alcohol swab and you're testing for alcohol, then you can, in theory, contaminate
Indeed.
the blood sample with some of the residual fluid of the alcohol. Some people say if you let the alcohol swab dry for 30 seconds, it's not going to contaminate it, but we don't go by that process. We have it specifically in our policy never to use an alcohol swab when an alcohol test is ordered.
Now, in that vein, Doctor, with reference to Good Samaritan and the emergency department, what, if any, precautions have you or your facility taken in regard to those types of blood draws in testing for alcohol with regard to alcohol wipes being used?
My phlebotomy supervisor has removed essentially all, not 100%, but all of the alcohol swabs down in the emergency room. So a phlebotomist who perhaps could forget which they shouldn't, because we have competency policies for them. So we have that in place where she's removed almost all of them so somebody can't mistakenly use a swab down in the emergency room.
Okay, so keep your voice up again, please, doctor, especially at
Well,
the
that's
end of
weird
your
if you only need them
sentences.
for
Thank you.
alcohol tests, and the alcohol tests aren't routine.
Doctor, the removal of those alcohol wipes from the emergency department of Good Samaritan, does that predate January 29th, 2022?
It's been in place for a long time. Before that, there was a policy that they would use betadine for swabbing, but that policy has been in place for a long time, and before that day of 2022.
You've spoken a little bit about, as far as phlebotomists working within Good Samaritan. If you could just explain to the jury sort of what is a phlabotomist and what is it that they do?
A phlebotomist is
The vampire of the
any
hospital.
person who is trained to draw your blood when you come to a hospital. So if you come in, we train people to draw the blood.
And as far as with regard to phlebotomists at Good Samaritan, you mentioned that there's some proficiency testing or some protocols that they have to adhere to. Can you explain that a little bit more to the jury as far as what's involved in those?
So with anybody who works in the laboratory, per CAP checklist requirements and the government's requirements, there has to be competency policies and assessments on anybody who works in our laboratory, including phlebotomists. So any new phlebotomist, they get an initial training, and they'll get a training, and then they have to be assessed to make sure that they know what they need to do for their job, including knowledge of all policies. Then after initial training, our competency
That's
policy
something a vampire would
states
say.
that we need to assess them again at 6 months. We do the same thing, make sure they know what they're doing. And then 6 months from that, so that's a year from when they started working for us, and then annually thereafter. So the CAP is, we have all these competency policies for everyone to make sure the lab technicians know what they're doing. We also have competency policies for pathologists as well. So it's all about making sure the final result is that comes from our lab is a good quality.
May I approach the witness?
Yes.
I'm showing you two sets of documents. You can just look at those and then we'll go on.
I'm guessing the notes are either going to be silent on the nature of the swabbing.
Just in general, do you recognize what those are?
Yes.
And what do you recognize those to be?
There are two of our policies that we have for Good Samaritan Medical Center, one for the phlebotomists, one for our laboratory technicians. The first one is a patient preparation for specimen collection policy, which defines our policy for drawing the blood for the phlebotomist. The second is an alcohol policy, which is one of, I don't know, thousands of policies that we have in the lab to describe how our policy for alcohol testing. Every laboratory test in our hospital has a separate policy.
Well, everything from hematocrit to sodium to potassium chloride has its own policy, is that correct?
Correct.
And the policy you have before you, that's for alcohol testing?
Correct.
And those two policies that you have before you, were those policies, what was in place on January 29th, 2022?
Correct. Yes.
May I approach again, Your Honor?
Okay.
Almost seek to introduce in a minute the next two exhibits. Almost seek to introduce the next.
Any objection?
No objection.
All right.
So we're spending a lot of time on
So,
this so they can
Madam
argue
Court Reporter, I don't think we
it was
marked
according to
SS
policy
into evidence.
because I'm betting the
Did
note
we-
doesn't say. The
do
note
we have
doesn't
that ready
say
to
I
go into
prepped her with
evidence?
iodine, I prepped her
I
with
don't
betadine,
believe so.
whatever. Just says I sterilized
All
and
right.
stuck in the needle.
So these instead, Madam Court Reporter, will be the next two exhibits. Thank you. And what is 107, Madam Court Reporter?
I believe 107 is in reference to, excuse me, I believe 107 is in reference to the alcohol testing, and 108 would be in reference to the sample collection.
All right, thank you.
May I approach the witness?
Yes.
I'm just showing you a document as far as some medical records. Are you familiar with those records?
Yes.
Those records are in relation to a patient named Karen Reed that visited the Good Samaritan on January 29th, 2022. Is that correct?
Correct.
Now, with reference to, may I approach again, Your Honor? Just
Yes.
Sure.
Your attention to a previously tapped portion of those records. Do you see a result for alcohol within those records?
Mr. Lally, you have to keep your voice up when you're here as well.
Let me say it again, sir. Doctor, with reference to those records in the page that I've opened up to, do you see a record in regard to a lab results for alcohol testing with regard to Ms. Reed?
Yes.
And what is it reported as, sir?
It is reported at 93 milligrams per deciliter.
And is that, as far as milligrams per deciliter, is that a relatively standard way of reporting an alcohol result?
Yes, it is in our hospital systems.
Could you explain to the jury sort of milligram per deciliter what that reading means as far as the metric that's used there?
Well, it means 93 milligrams of alcohol per deciliter of the blood.
And as far as, if you could explain to the jury sort of the testing process or the protocols that are in place at the Good Samaritan, so the blood is drawn by the phlebotomist, and then what happens from there as far as the testing is concerned?
Okay, so in our-
Before you do that, Doctor, so we might have to turn off the fans, which we don't want to do. I really need you to keep your voice up so that the court officer over there, so that folks down there can hear you.
Okay, so at Good Samaritan, I can go through the process. The doctor will order the test in the emergency room. We have 2 phlebotomists down in the emergency room. That test will print out, the order will print out down in the emergency room. And it will print out a label for the blood tube. It will print out on that label the color of the blood tube to be ordered, and will also print out what on the label what is to be tested in our lab. So that order will be seen by our phlebotomists in the emergency room. They will then locate the patient and perform the venipuncture or the blood draw. And use the correct tube. They'll go through their process of one of the most important processes in testing somebody's blood is accurate patient identification. So within our policy, we ask the patient to state his or her name, first and last name and date of birth. We have them say it out loud to make sure we have 2 forms of identification. Once that's confirmed, there is also a bracelet on the patient, so we'll match it up with a Good Samaritan ID number. So the first step is to make sure we have the correct patient. So then the phlebotomist has the order in front of her or him and uses the correct tube. Before drawing, they have to find the correct vein, a good vein for the patient, which is usually in the forearm antecubital fossa area. They will find that vein. They will cleanse the area with a non-alcohol swab, which in this case was, the order was for
All
alcohol.
right, so doctor, I'm sorry. I'm going to stop you. I think part of it is that you're saying so much and your voice is fine and then it drops and it's fine and then it
Okay.
drops. So Paul, can we turn the fans off, please? It's important that all the jurors hear everything you say, doctor.
Yeah, sorry.
Okay, so but speak into the
I'm
microphone.
going to bring it really close.
All right, this
So,
should be better with.
And hopefully you can turn it back on when I get better at this. So I'm sorry. It's hot. I'm hot too. One is we make sure that it's correct patient identification. We use the correct tube. We draw it. We don't use an alcohol swab. We use one that doesn't contain an alcohol in that. Then the phlebotomist will then put the labels on the tube or tubes in front of the patient, then bring it back to his or her area. Make sure they sign their name they initial their name on the tube, as well as the time. Then it will be put into a bag, and in the emergency room, it goes through a chute and it goes directly to our laboratory for testing. Once we get it, it's called receiving the blood work. A technician, lab tech in our lab, will scan. There's a barcode on the label. They'll scan it, and that will document the time that we received it. They will also manually enter the name of the phlebotomist and the time of the blood draw, so we have accurate records of what we received and the time. Once that's done, it's entered into our system, and then the technician will decide what needs to go next. In this case of an alcohol test, we're using a green top tube, which has lithium heparin, has an anticoagulant in it. It's to prevent clotting. So we'll get that tube, and once it's entered, we will centrifuge it. And that is centrifuged for about 10 minutes or so that we can separate the layers of the blood. In the blood, when you first see blood, it's all red, and there's no separation of the elements. But within blood, there are red blood cells, there are white cells or inflammatory cells, and there's the liquid portion of the blood. So for alcohol testing, we there's an anticoagulant in it, and so we will centrifuge it to separate the different layers of the blood. The different layers, the red cells will go to the bottom, and the aqueous portion or the plasma portion will go to the top. And when we test for blood alcohol in our lab, we're testing the aqueous portion or the plasma portion of the blood. So that's why it's important for us to centrifuge it and separate the components. Once that is done, that takes about 10 minutes or so, maybe a little bit longer. Then that tube will be brought over to our machine, which is a Roche Cobas machine, and it will be put onto the machine, and that machine will test for the alcohol or whatever else is ordered on the patient. I think I covered everything.
Now, with regard to, you used the term a couple times as far as a centrifuge, can you describe to the jury sort of what that is and how that instrument
It's a
works?
spinner.
Sure. So when the tube that we take is a blood tube, and we want to test the aqueous plasma portion of the blood, and the only way to get that plasma portion or the watery solution of the blood is we put it in a centrifuge, which will spin the blood at a rapid rate, something like 3,300 RPMs or so, which is fast, and it will separate the blood into those three layers. Also, in the tubes that we use is a gel that comes in the tube, and it nicely separates the red blood cell component from the water or aqueous plasma component, and keeps those two portions of the blood separate to make it easier for us to test on our machine.
Now, as far as the blood testing is concerned, is there a difference between sort of what's known as whole blood versus serum and plasma?
There is a difference. Whole blood is basically the whole blood. When somebody has a test drawn, and if we test something on the entire blood without separating it, that would be whole blood. If we say we're testing on plasma or serum, we're actually separating the components of the blood by the centrifuge process.
Which of the two, as far as serum plasma versus the whole bloods, which would record as far as a higher percentage of alcohol in the testing?
Alcohol, the answer would be plasma or serum would have a little bit higher blood alcohol content compared to whole blood.
As far as the separation that you're talking about, is there a specific area as far as the separation is concerned where alcohol tends to concentrate within?
Yes, alcohol tends to go into the more into the watery or the aqueous component of the blood. So when we like serum or plasma has a 98%, reportedly 98% water component. Whole blood, if you look at the whole blood overall, it has a lesser percentage. If you look in the literature, it can be 86%, or there's a range.
There's a range.
But so since alcohol tends to go to the watery components, if you measure alcohol like we do in hospitals on the serum or plasma, the value that we get will always be a little bit higher than total, than measuring on whole blood.
Aware of, through your training experience, sort of a conversion that can be done between sort of what's reported as the testing from the serum plasma to a whole blood count?
Tell me about your
in the
whole
hospital,
blood conversion.
we're pretty much in the business of, reporting alcohol, in serum or plasma, and we're not in the business of the legal aspects of alcohol testing, because alcohol, what I understand is the alcohol legal limit in Massachusetts is 0.08 grams per deciliter. We don't make any conversions in a hospital. We're not in that business to do that. We just report on the serum percentage or the plasma level, and we don't make any attempts to do any official
we're going to
conversion.
talk about this, guys. We're going to talk about why this matters.
If we did, we'd have to validate. We'd have to do many studies, and we're just not in the
Yes,
business
you
for
would have to
that.
do many studies.
And I understand that's not how it's reported within your record.
Except
or at
that you have the
facility.
actual
My
blood
question is,
there
are
with
you
you.
aware of a process by which you can sort of then mathematically convert from milligrams per deciliter to a gram?
I am aware of that. Recently, I had to read about it, but up until recently, I was not aware. So I'm not in that. We're not in the business for whole blood. But there is a formula. I do know about it, and it's there is a if one wants to convert a whole a serum or a plasma level to a whole blood, there are formulas that basically you need to. It's a simple formula, but there's varying opinions on which formula can be used.
Now, as far as this specific patient, the defendant, Ms. Reed, do you have any sense from the chart in front of you as far as sort of the timeline of when the blood was drawn to when it was tested and reported and things of that nature?
I think it was the order was 9:03 in the morning. 5 minutes later, the phlebotomist. It happened pretty fast. 5 minutes later, the phlebotomist got the labels printed. Then 5 minutes after that, they went in and drew it. It was very quickly, I don't have the numbers in front of me, but ultimately it was received in our lab, I think, 10 minutes after the order, the blood, very quickly. And then the final result, when the alcohol level was reported in the computer system, was, I think, 50 minutes from the time of the order.
May I approach?
Yes.
Okay.
And that lab results done pursuant to the testing and the policies and protocols and everything in the lab was 93 milligrams per deciliter, is that correct?
Correct.
Thank you, doctor. I have no further questions.
Cross-examination?
Good afternoon.
Good afternoon.
You testified that, hospitals are not in the legal business of calculating the BACs. Do you recall that testimony?
Yes,
And you'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are done in labs, correct?
correct.
And the purpose of testing in sort of a clinical setting at a hospital is to assist in the quick diagnosis and treatment of a patient. Is that right?
Yes, correct.
And so your priorities may be different than those if you're at a forensic lab where the goal is to ensure accuracy and reliability at all costs, correct?
I don't agree, not correct.
Yeah, that's not a good
Well,
question.
hospitals use serum tests to screen for the presence of alcohol, correct?
Correct.
And you'd agree that serum testing does not measure alcohol directly, but it actually measures the presence of NADH.
Correct.
And NADH is the byproduct that's created when the body breaks down alcohol.
Correct.
And the reason hospitals use a serum test rather than a whole blood test is because it's quick and efficient and you can get test results within 20-ish minutes. Does that sound about right?
Correct.
And you'd agree that NADH, which is what serum essentially tests for, can also be elevated by factors other than alcohol in the blood.
I'm not aware of that.
Are you familiar?
Yep.
Are you familiar with any medical literature that has found that NADH is created when the body has elevated either lactate or LDH in the system?
Correct. There are some issues, in our policy. There are some factors that can lead to falsely elevated or falsely lowered serum alcohol. One is lactic acid or LDH. Another one is Waldenstrom's macroglobulinemia, which is a hematological problem, and other things that can interfere with not just any test or lipids, high levels of lipids or hemolysis or high levels of bilirubin. But our machines are very sophisticated now. If there are any elevations of, let's say, hemolysis or lipids or bilirubin, the Roche machines will detect that and flag it as a possible interference, or it won't even let us result a test. So with any test, there can be interferences, and I'm sure there can be interferences with the forensic way of testing as well.
Sure. So there are other causes of high levels of LDH and therefore NADH also include things like trauma, muscle weakness and loss of muscle tissue, or abnormal tissue formation. Is that correct? Have you read studies about that?
I haven't read those studies, no.
would you agree that there may be other sort of medical stressors or things that can't necessarily be captured by the technology, but that could cause error in testing?
I don't understand that question.
Well, you testified that there can be certain errors in testing. That's something that we see throughout all different types of sort of scientific literature, which includes ethanol testing.
Yep.
And there are certain sort of factors that could cause a higher level of NADH that might not necessarily be picked up by the machines that you use at the hospital. Is that correct?
I am not familiar. I mean, if there is, it's not not a common phenomenon. Our methodology for doing many tests are based on this NADH enzyme methodology, and we've never had issues with it. I read a lot. I haven't read about major faults of our methodology for testing. Most hospitals, when we look at when we actually have to do proficiency testing with any test that we do in a hospital. So 3 times a year we get sent unknown levels of alcohol and 5 samples to be accurate 3 times a year, and we're able to look at not only our results, make sure they're correct, but we're able to look at how what other hospitals are doing across the nation. So when I last looked, and it's held true for over 10 years, maybe 20 years, is that of the, I think, 5,000 hospitals that are testing for alcohol, it's over 80% of them are using our methodology, which is the alcohol dehydrogenase and NADH, and I can't imagine if there were any
Because the
major
point
issues
is there
with
aren't
alcohol
major
testing
problems.
using that
There are
methodology.
occasional problems.
Why would it wouldn't be that high of a
Well, as you testified, the goal in a clinical setting, obviously, is to test for the presence of alcohol, but you're not in the business of trying to sort of calculate BAC, correct?
No, we don't. We don't.
So your goals are to make sure that you're screening for the presence of alcohol, but you're not quite as concerned with the precise amount that you might see in, for instance, a whole blood test in a forensic lab.
Well, we result in terms of in the serum. We know the Massachusetts laws and laws across the nation are based on whole blood, but there are in the literature formulas that you can use if it were a medical legal case that one can use to convert our level to a blood alcohol. We don't do it in a hospital. We won't report a serum alcohol and then we don't do the conversion, but because it's a very rare event that that a level will end up in court. But there are forensic lab people that can provide that formula.
And when you get a test result from a serum test, that information does not establish when alcohol was consumed, correct?
Correct.
And so you're just looking at a specific point in time to say this is what the serum test reflects at 9:08 a.m. on January 29th.
Correct.
Thank you. No further questions.
All right. Mr. Lally, any follow-up?
Just briefly. As far as the interferences or anything that would lead to elevated levels from your review of Ms. Reed's chart, was there anything like that present there?
I didn't see anything, no.
And the interferences would be accounted for in the sense of the machine would sort of vet them out and not result or not recorded in the chart if that were to occur. Is that correct?
Objection, Your Honor.
The form of the question, I'll sustain the objection. You can ask it differently.
Sure. Dr. Fowler, with regard to the interferences that you were talking about, what, if any, impact would that have on the results being reported?
if there were the three major things that could interfere with the result, like high lipids, hemolysis, or high bilirubin, our machine would flag that, and we would have some information that our result may not be valid. And sometimes we will report a result with a disclaimer, or sometimes if those levels are
not
so
high
high, we won't
LDH.
report it at all. But in this case, there were no flags.
Nothing further, Your Honor.
Anything, Ms. Little, or are you all set?
If I could have one moment, Your Honor.
Sure.
Right, just one moment, Your Honor.
The problem is if you want to imply high LDH or something like that as an interference, you need to establish Karen had high LDH. Can you do that?
No further questions.
All right, Dr. Fowler, thank you, and I'm sorry I gave you such a bad
Oh,
time about
okay,
your
I'm
voice.
sorry if I, thank you.
Thank you.
The bigger problem here is with the conversion and with the math.
Your next witness, Mr. Lally.
Yes, Your Honor, the Commonwealth will call Mr. Nicholas Roberts to the stand. Your Honor, may we approach just while the witness is coming in?
Yes.
So when we get to the end or an afternoon break or something like that, I'll talk a little bit more about why all this stuff matters, what the weakness in this issue is as far as the plasma conversion, the serum conversion to whole blood. It's very strange to me that Mr. Lally is throwing around hematocrit testing, because that's the problem. The problem is that everybody has a different volume of liquid to solids in your blood. Hematocrit is measuring the quantity of red blood cells in your blood. Some people have a very high quantity of red blood cells. If you go spend a week up at Denver for a while, you're going to end up with a high percentage of blood cells relative to your normal baseline. People who live in that environment will often have an elevated blood cell system. Medications can increase your level of red blood cells. And so it's a big variable that is individual. And so the formulas to convert serum to whole blood are based on an averaging. It's not based on an individual person's measurement. When they had her actual whole blood sample, they could do it unique to her
Do solemnly swear the evidence you give the court
because they
during
can
the case now
calculate her
herein
whole
shall be
blood
the truth, the whole truth,
volume.
and nothing but the truth, so help you God.
I do.
Thank you. You can have a seat. I just need you to keep your voice up really loud. If you're too soft, we're going to have to turn off the air conditioning. Everyone's going to get mad at you.
No problem.
All right, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Would you please state your name and spell your last name for the jury, sir?
Sure, my name is Nicholas Roberts, Roberts.
And what is it that you do for work, sir?
I'm currently employed with a company called Thermo Fisher as a field service engineer
And how long have you been doing that?
since November of last year.
And so prior to that, or prior to November of last year, 2023, where did you work before that?
I was in the Massachusetts State Police Crime Lab in the toxicology unit.
And how long did you work in the toxicology unit at the Massachusetts State Police Crime Lab?
Since October of 2014.
Now, if I could turn your attention to prior to joining the lab for the Massachusetts State Police, can you talk a little bit about your educational background? Where did you go to school and what did you go to school for?
Sure. I have a bachelor's degree in applied forensic science with a concentration in chemistry and toxicology from Mercyhurst University. That's in Erie, Pennsylvania. And then I also have a master's degree in forensic toxicology from the University of Glasgow in Scotland.
Now, after receiving your degree from the University of Glasgow in Scotland, where did you go from there?
I returned home to the British Virgin Islands where I taught at a community college.
And what did you teach there?
Mainly chemistry and a term or two of physics.
And then following your teaching in the Virgin Islands, where did you go from
I was hired then at the Mass State Police Crime Lab.
Now, when you're initially hired at the Mass State Police Crime Lab, you're working initially as a forensic scientist 1, is that correct?
Correct.
And can you explain to the jury sort of what your duties and responsibilities are, what your work looks like as a forensic scientist 1?
So a forensic scientist 1, you're essentially going through all the trainings that they provide at the lab. We do a number of different testing, mainly on blood and urine, looking for the presence of drugs and alcohol. We also do serum conversions and retrogrades. So during your training period, I started as a FS1, so that went up until I was fully signed off to actually write reports that would be issued to ADAs across the whole of Massachusetts, in which I became a forensic scientist 2.
And so what are the difference, sir, between sort of your work as a forensic scientist 1 versus your work as a forensic scientist 2?
So essentially as a 2, you're essentially fully trained and you're able to do all the testing that we do in-house. You also are able to go and give testimony based on the reports that you write, whereas in a forensic scientist 1, you're still in that training process.
And did you work essentially as a forensic scientist 2 from that point in time till the time that you left the lab in November of 23?
Yes.
Now, with reference to while you were working at the lab, was there sort of an ongoing, continuing educational component?
Yeah, so we would habitually receive articles based on different discoveries within the forensic field. So different ways they would find certain types of drugs in different bodily fluids. It's always a revolving door when it comes to drugs being discovered as well as being manufactured, what's illicit on the street, et cetera, et cetera. We would often get different articles, just research papers based on what they're doing to discover these things within the matrices that we are looking at.
Now, in addition to that, while you worked at the lab, what, if any, are you familiar with the term proficiency testing?
Yes.
And what, if any, proficiency testing would you undergo while you were at the lab?
So we receive both in-house and external proficiency tests. Essentially, the process would be just the same. The only difference would be we'd have internal people sending us samples as if it came from an external source. And then the external proficiency testing that we receive is actually part of our accreditation. So it came in just like regular samples, and we would test it accordingly per our protocols.
And as far as the proficiency testing that you undertook over the course of your time at the lab, did you pass each of those tests?
Yes.
Now, you mentioned a little bit as far as accreditation with regard to the lab. What, if any, accreditation did the State Police Crime Lab have?
We had accreditation. It's a internationally accreditation board for forensic scientists, as well as any kind of lab in particular, and the branch that our lab would have fall under. We have a certain set of rules that we have to adhere to. Mainly it's a standard known as an ISO 17025, but we have a different accreditation board, and they have narrower requirements because of the type of lab that we are.
It may be pretty well understood, but that as far as the accreditation is concerned, that's done through an external entity, is that correct?
Yes.
Now, with regard to the lab, as far as your assignment of work, at the time that you left the lab, about how many forensic scientists were working within the lab in your toxicology?
By the time that I left?
Yes.
Oh. So within the toxicology unit, there was one more when at the time that I left.
And as far as you and sort of the other forensic scientists too, the time that you worked at the lab, was there some sort of rotation, or how were you assigned work as it related to your work in the toxicology?
So throughout my time there, we had more forensic scientists, 1s and 2s, and we would delegate each type of assignments that we would look for to different types of testing. On a monthly basis, we would get a different group of tests that we would perform throughout that month, and it would rotate to the next person as the month, at the end of the month. So that's how we did the testing.
Now, sir, if I could turn your attention to May of 2022, you're working with the lab at that time, is that correct?
Yes,
And were you assigned to serum conversions at that particular time?
I was, yes.
And at some point were you specifically assigned to a case involving a Ms. Karen Reed?
Yes.
Now, as far as a serum conversion is concerned, if you could explain to the jury sort of what goes into that process and what is it that you're reviewing or you're looking at, how is a serum conversion, what is it, and how is it performed?
Sure. So with serum conversions, usually what happens is that we get hospital results. So that would be the police or the ADAs would get results from the hospitals that whoever was attended to. We get the results, and usually hospital alcohol results they use serum in order to test alcohol. Serum is essentially the liquid portion of blood. Let's say, for instance, you fall and you cut yourself, that red stuff that comes out, that has serum within it. What the hospital does, they centrifuge it or spin it very fast in order to get the red blood cells, the white blood cells, and all kinds of the heavier materials out of that blood. And what's left is the serum. So they use that to test their alcohol. What studies have shown is that we actually tend to have a higher alcohol concentration in serum than in blood. So what that means is that due to the chemical nature of alcohol, it likes to stay in that liquid portion more than throughout the whole blood. So a serum conversion essentially is able to convert the alcohol content from that serum that we get from the hospital into what it would be in whole blood.
And did you have occasion to perform a serum conversion in regard to Ms. Reed's medical records?
Yes.
May I approach the witness?
Yes.
So I'm showing you a document, just ask you to review that as I'm finished. Do you recognize that, sir?
Yes.
And what do you recognize that to be?
So this is the serum conversion report that I made, with the calculations were made on May 3rd of 2022.
And as far as the result that you received, in addition, so what kind of materials did you receive in order to perform that analysis?
We got the medical records.
May I approach the witness again?
Yes.
I apologize, Your Honor. If I could, looking for the exhibits. So I'm going to show you what's been marked as Exhibit 106. And directing your attention to this last page contained within this document here. Is that a portion of the medical records that you reviewed in regard to Ms. Reed's serum alcohol level?
Yes.
And if you could, what was reported in the medical records that you reviewed and using in your serum conversion analysis as far as the level?
The level was at 93 milligrams per deciliter.
And so with regard to that 93 milligrams per deciliter, I'm sorry, was there also a time that specimen was collected as far as your review of those records?
Yes.
And what was that time, sir?
It was at 9 in the morning, 9:08.
Now, as far as, just in terms of the general term, as far as forensic science, what you did at the lab, can you explain what that term means or what you did in relation to that?
What do you mean specifically?
That was very poorly phrased. Let me try to restate that a bit. What is your understanding of forensic science, and can you explain that?
Oh, forensic science is essentially
Forensic science.
A scientific study based on anything dealing with the law. So whether it comes to ballistics or DNA analysis or toxicology, like I did, anything focused or based on the law or for legal purposes, essentially that's what forensic science kind of encapsulates.
Then forensic toxicology, would that sort of be a subset of forensic science?
Yes.
And can you explain to the jury sort of what your understanding based on your training and experience, what is forensic toxicology?
So toxicology in general is essentially just a study of poisons, plainly speaking. So anything that'd be harmful to the body, essentially that would be toxicology, because you also not only have forensic toxicology, but you also have like environmental. And the forensic toxicology is just, like I said, again, with the forensic science, it's just basing it on things for legal purposes.
Now, through your training experience, are you familiar with sort of the difference between a serum plasma level versus a whole blood level?
He just
Yes.
said that
And
already.
can you explain to the jury sort of what your understanding is of each and what, if any, differences there are between the two?
So just plainly your serum plasma level, or the serum plasma is what it's called. It could be referred to as either or one or the other. So that is just the alcohol level in your serum, whereas your whole blood is your alcohol content or regular BAC in the whole blood. This difference between the two is, like I said previously, in your serum or plasma, that alcohol content would be higher as it would have been in the whole blood.
Now, as far as the milligrams per deciliter, how that's reported in the Good Samaritan medical records referencing Ms. Reed that you reviewed in this case, is that typical as far as how hospitals would report sort of the serum plasma levels?
Yeah, from my experience and all the times that I've seen serum conversions come to the lab, milligram per deciliters are the units that they use from the hospital, yeah.
Now, as far as that 93 milligrams per deciliter, what, if anything, with regard to serum conversion, what, if anything, are you then able to do to convert that to a BAC or a blood alcohol concentration?
So based on some studies, they came up with a few different conversion factors, knowing that the blood alcohol content would be higher than the serum plasma content. They're
be
able
lower.
to apply different conversion factors to the numbers that we would get in serum. And we usually get, excuse me, we usually give a low, an average, and a high, being that it's kind of hard to say what one particular person's conversion factor would be between the two of them,
Correct.
since it's dependent upon like age, sex, the water content, what you had to eat that day. So it's harder to pinpoint, therefore we give a good range as what it could possibly be pertaining just in case a person converts, or their conversion would be a lot lower or higher. So we give a good range.
And as far as those different conversion factors, where do those come from?
It's based on some studies. I don't remember the actual names of the papers that were thing, but they were based on studies throughout the forensic world when it comes to looking at specifically testing blood and serum to find that conversion factor.
And as far as those studies are concerned, do they come from sort of different population bases? Is that correct?
Yeah, so that's how they were able to get the range of conversion factors that they use.
Now, as far as the water within the serum, or sort of how that works with the centrifuge, what, if any, relationship does that have to the reading that you get or the conversion factors that you use?
So the water content, essentially, if the serum being the liquid portion of the blood, water is also liquid, it makes up some of that serum that you get from it. Therefore, your higher water content, more essentially the lower the concentration could be of that, or lower or higher, depending upon whether or not your water content in that sample is lower or higher.
So as far as those different conversion factors that you're using, this is essentially a mathematical calculation, is that right?
Yes.
And so the different conversion factors that you're using for the low, the average, and the high, what are those conversion factors?
So the low is a 1.18, with the average being a 1.14, and then the high being a 1.12.
So based on your analysis, as far as the medical records of what was reported to you, using those three conversion factors, what, if anything, did you come up with as far as the low and average and high for the 93 milligrams per deciliter?
So our values that were calculated for the low was a 0.078 gram percent. The high was a 0.083 gram percent, with the average being a 0.081.
Now, sir, with reference to the alcohol that's reported in the records, are you familiar with, are there different types of alcohol?
Yes?
And can you explain sort of what those types are and what the differences are or where they come from?
Sure. So there are multiple different types of alcohol, mainly based on the number of carbons that are within that molecule. You start off with methanol, which is 1 carbon. Methanol you can find in like some rubbing alcohols. You can find them in many different labs. We have big, large vials of them. Ethanol, which has 2 carbons. That one is the common one that is in our alcoholic beverages. And it goes all the way up isopropanol, octanol, et cetera. It all depends on the number of carbons in the chain of it.
And the type that's reported within Ms. Reed's medical records, that was ethanol, correct?
Correct.
And so with regard to your training experience as a forensic toxicologist, are you familiar with the term known as a central nervous system depressant?
Yes.
And can you explain to the jury what that term means and how it relates to alcohol?
Sure. So alcohol is what is classified as a central nervous system depressant, and essentially the name kind of gives it away as to what it does. Your central nervous system is responsible for essentially all your movements, both involuntary and voluntary. So the way you move your head, the way you blink, the way you breathe, the central nervous system is responsible for all of that. With a depressant introduced into the body, it affects that central nervous system, causing things to slow down. So that's essentially what depressant means. It's going to slow down certain processes that a central nervous system would be in charge of. So you can have delayed reaction times. It can cause drowsiness.
Ask another question.
Thank you.
How would that manifest as far as a central nervous depressant affecting the body?
Objection.
I'm going to allow it.
Go ahead.
There are many different effects that you could see, or side effects from having a central nervous system depressant in the body. Lethargy, sleepiness, drowsiness, unable to walk properly, any kind of any one of those tests that you see on TV from the police when they try to get your horizontal gaze and they try to make sure you're coordinated, it can affect all those things.
Now, sir, are you also familiar through your training and experience of working in forensic toxicology with a term known as retrograde extrapolation?
Yep.
And can you explain to the jury what you understand that term to?
So a retrograde extrapolation is essentially another calculation, but it allows you to be able to calculate what the possible blood alcohol content would have been at a time prior to when the blood was drawn. Say, for instance, blood was drawn at 2, you could essentially figure out what the blood alcohol content would have been at 10 in the morning prior to it.
Given what assumptions?
And that's done with the calculation as well, is that correct?
Yes.
Now, what are some of the types of information that you would need to know or that you would want to know in order to perform a retrograde extrapolation?
We'd need to know, one, for sure, what the alcohol content would have been. We also need to know the time that the blood was drawn, as well as the time of the last
drink.
alcohol consumption.
Now, in regard to timing, as far as what, if any, limitations are there in regard to performing retrograde extrapolation as it pertains to timing is concerned?
You don't know if she went home and had a bunch to
when we do
drink.
these calculations, anything that's shorter than 2 hours, we usually don't do that conversion.
And why is that?
Because we're built in within our calculations, we allow for 2 hours. That has to do with the way that alcohol leaves the body. If the alcohol is still being absorbed by the body, we want to give it enough time to get to a point where it's coming out of the body as opposed to increasing in the body. So that 2 hours puts puts the person at a point in which that alcohol will be coming out as opposed to it being absorbed.
So there are essentially three different sort of phases as far as intake of the alcohol into the body through dissipation. Is that correct?
Yeah, we have usually, there's a well-known kind of metabolism route to which alcohol metabolizes out of the body, yes.
And so can you describe to the jury sort of that metabolism process as far as how it starts to its end point?
Sure. So with having, let's say, one drink, what the body begins to do at that point is absorb the alcohol. Usually you get like a steady line that increases with time. So if you think of a regular chart where you have the level of alcohol in the body versus time, which would be on the y-axis or the x-axis at the bottom. As time goes along, after your first drink, the body starts to absorb the alcohol. If that was your only drink and that was it, the body then at a certain point, it stops absorbing it because there's no more to absorb and it plateaus. So essentially the line goes straight. After that point, the body starts to eliminate it at this point. And then your level or your concentration of alcohol within the body decreases with time as it's getting rid of it.
And so there's sort of the absorption phase, the plateau, and then the elimination phase. Is that correct?
Yes.
Now, you mentioned that in the course of your analysis for retrograde extrapolation, it's important to know sort of when the last drink was. Is that right?
Yes.
And why is it?
That way we can get a good time in and figure out the amount of time that has passed between the last drink as well as the time that the blood was taken.
Now, did you perform a retrograde
just said it's
extrapolation
important. You didn't say
analysis with
why.
regard to Ms. Reed's BAC or the converted BAC from the serum conversion?
I did.
And so with reference to Ms. Reed, as far as you looked at obviously the hospital records, you looked at the serum conversion report, what, if anything else, did you review or look at in coming to that retrograde extrapolation analysis?
We usually get a police incident report, and that usually identifies the time in which, per their narrative, what time in which they had the last drink.
May I approach the witness room?
Yes.
So the last drink that police
So
knew
again,
of
presenting you with the document. If you could
is
just-
what they're going by. Now let me tell you, if you got pissed off at your boyfriend and went home, might you have a little drink when you got back?
Do you recognize that document, sir?
I do.
And what do you recognize it?
This is the retrograde extrapolation report that I did for the subject of Karen Reed.
Now, with respect to the time that you utilized in that report, as far as when was the time that you utilized as far as the last drink or time of operation?
The time that was utilized as the last drink,
Was it from that Proctor
it was
report
at 12:45.
of the video?
12:45 a.m., is that correct?
Correct.
And so you're using that to sort of extrapolate from 9:08 a.m. when
That's
the
after
when
she
the
was home.
93 milligram per deciliter is reported from Good Samaritan to 12:45 a.m., correct?
Correct.
Now, with regard to that 12:45 a.m., what, if any, difference would it make if it were a little bit off of that? Say it was 12:30 a.m. or it was 1 or 1:10 a.m. What, if any, impact would that have on your conversion?
So we tend to go by hours. So we kind of round to the nearest, I think, 15-minute interval. So a couple minutes or 10 to 20 minutes forward or behind of that 12:45, it wouldn't change the results by a lot, if any.
And what if you change it by a
And
couple
similar
hours?
to the serum conversion, is this done with different conversion factors as far as a low, an average, and a high?
So we usually just calculate a minimum and a maximum for the retrograde, and that incorporates some conversions as well.
Now, as far as the minimum versus the maximum, what do each of those sort of signify, or how do you come to those mathematical calculation?
So with the minimum calculation, we incorporate the 2 hour period. So we assume that maybe that 12:45 wasn't, the body wasn't at that point finished with the elimination. It wasn't in the elimination phase, so we allow it for 2 hours ahead of it. We also have a conversion factor. Once again, this is a study that was done to see the elimination rate of different people within a population, what rate they would get alcohol out of their system per hour. So we applied the lower limit, which was a 0.1 gram percent per hour, with that 2 hour allotted time interval, and then we use the lower serum conversion number, the one that was converted on the lower end. We use all of that in the calculation in order to come up with the minimum. The maximum one uses the opposite, so it uses the higher converted serum conversion number with the higher elimination rate, using the full amount of time.
And these calculations or these conversion factors are all based on sort of medical studies that you reviewed in literature that goes into your training?
Yeah, all of it was part of the training, and they came up with those numbers prior to even when I was hired there. But it is based on multiple different studies in that, looking at that elimination rate.
And so from your calculations when it came to the minimum with regard to the retrograde extrapolation, what if any calculation, what if any result did you come from with your calculations as it pertained to the minimum?
So the minimum amount that was calculated would have been a 0.135 gram percent.
And that's essentially reporting in a blood alcohol concentration, is that correct?
Correct.
And then with regard to the maximum, what if any result did you get from your mathematical calculations in regard to that?
The result was a 0.292 gram percent.
And so that range that you received is a bit of a wide range, is that fair to say?
Yes.
And why is that?
So we base those
'Cause it's a long-ass
calculations,
time.
they're based on that conversion that I did from the hospital results from serum, giving us a good range of values in the first place. But then we incorporate the retrograde extrapolation one, which uses a time factor, and that 2 hour difference using two different elimination rates, that causes a wider span of values. And it's just so that it can encompass essentially anybody within the general population, that they would be somewhere in between that lower limit and that upper limit.
So essentially from those mathematical calculations, anyone within sort of the general population with that result would be somewhere between the 0.13 and the 0.29, correct?
Correct.
May I approach this to retrieve your arm?
Yes.
This cross is going to be a revisit of the garbage in, garbage out scenario that we heard from Mr. Lally, or from Mr. Jackson.
I could have one moment, John?
Yes.
Thank you, sir. I have no further questions.
Okay. Ms. Little?
Come on, girl. Let's see what you got.
Good afternoon.
Good afternoon.
You used a method called retrograde extrapolation to reach your sort of opinions and conclusions in this case, correct?
Yeah, it was a calculation.
And that means that you rely on an assumption that a trend will continue beyond sort of observable data.
So the metabolism is actually pretty well studied. So we know that that elimination rate, unless you introduce more alcohol into the system, it declines at that rate, and it's pretty linear.
Exactly. So in other words, certain assumptions are incredibly important for you to reach your analysis.
Sure.
And that includes sort of the timing of the very last drink that the individual had. Is that right?
Yes.
if your drinking pattern is sort of different than what you assume for purposes of your calculation, then you'd agree that your entire extrapolation would be incorrect. Is that right?
Not a good question.
Yes, it could be.
And again, those assumptions sort of included the time of the incident, right?
Yes.
And importantly, the time of the last drink.
So those two will be what we use. It's the time of the blood draw as well as the time of the incident or last drink.
And your report acknowledges that the testing that was used to obtain ethanol results in this case was not performed by the Massachusetts State Police Crime Lab.
Correct.
And for that reason, the report and those results do not fall under your forensic lab accreditation standards.
Correct.
The Massachusetts State Police, as you testified, is an accredited forensic lab.
Yes.
And so you're required to meet certain minimum standards in order to uphold that.
Yes.
And you'd agree that those accreditation standards are different from accreditation standards that, say, a hospital lab might have.
They can be.
And do you ever work on testing within the Massachusetts State Police Lab for serum tests or whole blood tests?
So we did test the blood and serum for alcohol content at the Massachusetts State Police Crime Lab. Yes.
And their typical protocols are to use whole blood tests.
We use whole blood or serum.
In terms of the machinery that's used with the Massachusetts State Police Crime Lab, you'd agree that the gold standard is gas chromatography and mass spectrometry machines.
Usually with a headspace detector.
I'll let it, go ahead, you can
Sorry.
answer that.
Usually with a headspace detector, yes.
And that would detect whole blood rather than serum.
No, it just detects any volatile substance.
But you'd agree that a serum test usually, as you testified, has a much higher level than whole blood.
Yeah, due to the nature of the substance itself.
And so you kind of have to go through this extra step of trying to extrapolate, okay, how do I convert this to get to whole blood?
So what we
It's just a volume thing.
incorporated anytime we had a serum sample submitted to the lab for alcohol testing, we actually did the same serum conversion in order to figure out what the blood alcohol concentration would have been.
And that's an extra step that you have to take using conversion factors, correct?
Yep, that's the calculation.
You're not actually testing for ethanol in the blood. You're testing for an ADH, and then you have to do a conversion to get it to what a whole blood test would just automatically show you.
Yeah, so we get the serum level and then we convert it via calculation.
And typically in the Massachusetts State Police Crime Lab, you would do what's called confirmatory testing.
Yeah, so we have a screening method as well as a confirmatory test, correct?
And confirmatory testing means that you take two separate samples and you test both of those.
Essentially, well, our protocol involved testing in duplicate, but that's not always the case for the other drugs that we tested. We essentially have a screening test, which is one type of test, and then the confirmatory test would be a separate test, or sometimes even the same test, just we run the sample again.
And the reason you typically would do two tests is to ensure that there's no error in the testing.
Correct.
And that acts as a fail-safe against false positives. You
Yes.
agree with that? And it also ensures that you're testing the correct sample.
Correct.
And in this case, obviously, you didn't conduct any of the testing.
Correct.
You're just assuming the accuracy of a single test that was performed by a hospital.
Actually,
I'll allow it.
yeah.
And so if the clinical results are invalid, then your extrapolation is going to be invalid.
Yes.
Garbage in, garbage out.
Now, we discussed a lot about sort of serum testing and conversion rates. Do you recall that testimony?
Yeah.
And you'd agree that the precise conversion rate between serum ethanol levels and whole blood ethanol levels is almost impossible to accurately predict.
For each individual person, it would be difficult. Yes.
And that's because the amount of water in our blood is scientifically impossible to predict with accuracy.
I'm not aware of any kind of test that would do that. So yeah,
Because individuals are different, right?
yes,
And so the conversions that you use are based on averages from scientific studies.
yes.
But you'd agree that in certain instances, people can fall outside of that average range.
Yeah.
In fact, a comparison of, hospital serum alcohol levels, they range quite wildly. You agree with that?
Yeah.
In fact, you're aware that some studies show that a conversion rate from serum alcohol to blood alcohol can be as high as 1.59%.
I wasn't aware of those numbers, but yeah, it could range. That's why we give a wide range, and you could lie on the outskirts of either side.
And so that would mean that the actual blood alcohol content, once it goes through the conversion rate, would be much, much lower than sort of the average conversion rate that you relied on.
Yeah, it could be both higher and lower.
And that includes that range that you gave, right?
Yeah, it could fall outside the range.
Lucky he volunteered that. It
You'd
could fall
agree that
outside the
the
range.
more imprecise an extrapolation is, the less reliable it is.
Yeah, you do have to base it on good. Your starting blocks have to be good, so you have to know the times in which the blood was drawn, the time of the incident, and essentially what your value was for your BAC.
And the time of the last drink, you'd want to know that?
So we would put that around the time. Yeah, either the time of the last drink or the incident date.
And so the more sort of unknowns you're trying to account for, you'd agree the less reliable your end result is going to be.
It could be, yes.
And you'd agree that sort of the range you gave in this case, which was 0.135 to 0.292, that's a very, very large disparity.
Yeah.
Almost a sort of 120% swing.
Yeah.
That would be the equivalent of, for example, predicting a child's going to grow somewhere from 6 feet to 14 feet.
Objection.
Sustained.
It's a very large number. You'd agree with that.
Yeah, there's a large range, like I said, due to the factors involved in the calculation. That's how it gets so large.
And that's because you're acting with a lot of unknowns in this case.
Yes.
Now, you testified that your retrograde extrapolation assumes that Ms. Reed reached the elimination phase of processing alcohol at or before sort of 12:45 a.m.
Yeah, we allow for, we start for the maximum at the 12:45, and then it would have been 2:45 for the minimum.
And so for purposes of your calculation, if Ms. Reed drank alcohol after 12:45 a.m. and before her blood was drawn at 9:08 a.m., your entire calculation would be invalid.
Yeah.
Yep.
No further questions.
Hey, Mr. Lally?
Straight, please.
Good end.
So in this instance, Mr. Roberts, you're dealing with a time of incident that was known, correct?
Yes, it was given to me that it was at 12:45.
And as far as the BAC or the serum conversion that was coming from a medical record, so that was known as well at 9:08 in the morning.
The time that the blood was drawn, yeah, that was known as well.
Now, as far as the question you were just asked, if the defendant drank alcohol after 12:45, does that include sort of shortly after 12:45, or how long after 12:45 would it take in order to affect your calculations or your retrograde extrapolation?
It's hard to say where that would have skewed it. It would have definitely caused a different time frame depending on how long after the incident or the reported last drink, if there was another drink in between there. It just shortened up the amount of time that would have been prior to the blood draw for sure.
What I'm asking is, would it have any significant impact, or would there be any difference if the last drink was, say, at 1 a.m. versus 5 a.m.?
So that'd be a 4-hour difference. So
Yeah.
essentially that could, given the conversion rates, that would put the numbers very different. Yeah.
But what I'm saying is, so the 5 a.m. would significantly impact your calculations, correct?
Yes.
The 1 a.m., would that significantly impact your calculations?
No.
Okay.
You all set, Ms. Little?
If I could just ask one question. You said that you were given 12:45 as the time that you sort of based your analysis on. And to be
Yes.
clear, that was not something that was provided to you by my client, right?
No.
That was something that was provided to you from a police report.
Correct.
No further questions.
Okay. All right, Mr. Roberts, you are all set, sir. Thank you very much. No problem.
Oh, we're gonna have so much to talk about with all
Okay, your
this
next
stuff.
witness, Mr. Lally?
Yes, Your Honor, the Commonwealth call Mr. Michael Trotter to the stand.
Michael Trotter, who's this? Is he one of the police officers?
Maintaining your case in court.
You raise your right hand. You solemnly swear the evidence you give the court and jury in the case now in for the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
I don't see him on the list.
All right, Mr. Lally, whenever you're ready.
Good afternoon, sir. Could you please state your name and spell your last name for the jury?
Michael Trotter, Trotta.
And where do you live, sir?
Hey,
Sharon, Mass.
How long have you
my
lived
bad
there?
with the accent
On
there.
Sharon since 82.
And what do you do for work, sir?
I am the superintendent of public works for the town of Canton.
And how long have you held that position as superintendent of public works?
Since 2003.
And did you work for the town of Canton prior to 2003?
No.
Now, with regard to being the superintendent of public works, can you describe to the jury sort of what are your duties and responsibilities when it comes to that work?
He oversees the plows.
Typical management duties of staffing, controlling, directing, working on the budget, working on scheduling, long-term scheduling, 5 to 10 years, capital planning, overall
driver.
operations,
He's the
the
one
day-to-day
that,
operations, what
they
it
went
takes to
to find the
maintain
driver.
a
The
water
proctor
system, a sewer
said
system, the
He
road
told
system.
him no plows out at that time.
Now, with reference to, if I could turn your attention back to late January, early February of 2022. At some point in early February, were you contacted by a trooper in regard to a blizzard that had happened the week before?
Yes.
And do you recall who that trooper was or how they contacted you?
I believe it was Michael Porter, and I believe the contact was by phone.
Now, with reference to that trooper, is that someone that you knew or you had spoken to before in any way?
No.
And prior to that date, did you know a John O'Keefe or a Karen Reed or anybody?
No.
And as far as anybody within an Albert family within the town of Canton, were you familiar with them? Did you know them at the time?
No.
Now, when you were contacted in that early February of 2022, with regard to the blizzard the week before, what if anything, was the trooper asking you? What kind of information were they looking for?
He wanted to know what the procedure was when we prepare and staff a snowstorm.
And if you could explain to the jury sort of what is the procedure, or what, at that time, what was the procedure and what was sort of the makeup of what Canton DPW would do with regard to a snowstorm?
Well, we have the town is divided up into, I believe, 29 plow routes, several main routes, and side routes. The routes are generally somewhere between 3 miles and 3.5 miles long. And we have 30, I think back then we had 39 pieces of our own and probably 30-something private plow trucks. We try very hard to have 2 trucks on a route, but we generally don't get enough. So if we try to have a town truck on a route with a private plow on a route. The private plow is procured through a bid process. They have to have a contract. They have to have insurance, liability insurance, and they have to show that they've paid their taxes to the state and that they have workers' comp. And they have a contract with the town. Then the operations manager is in charge of the on-site, boots on the ground, if you want to call it that. He'll assign the specific truck and the private contractor to a route. Generally, the day before, maybe 12, 18 hours before, the two of us talk. We try to schedule the overtime so that you're not going home at 3 o'clock and then you're getting woken up at 1 or 2 o'clock in the morning to come back. We like to schedule it so when the guys go home, they know when they're going to come back. To the best of our ability, that's what we'll do. We'll tell the contractors when they are expected. And generally, if we're plowing, it starts with a sanding operation. So we would have a sanding fleet, which is maybe a dozen trucks. They'll come in early, and then the rest of the public works people come in at a scheduled time.
And so there'd be about, and correct me if I'm wrong, there'd be about 30 some odd trucks that were sort of DPW trucks?
A few more. I'm not sure the exact number. It's probably 37 or 38 because that counts sidewalk plows too. So there may be, I think there's 3 sidewalk plows, so there's probably 34 or 35, we'll say, between medium-sized trucks and the big construction trucks.
That was sort of my next question. As far as the DPW trucks are concerned, do they vary in size, or what is sort of the range and size of the town truck?
They'll go from a pickup, 2-ton pickup, a F-150 or F-250 Ford, if you're familiar with that, to a medium-duty 20,000 to 22,000 pound truck up to a large construction truck, which is generally 26, 28,000 pounds.
Now,
The large truck is a 6-wheel truck.
and as far as the other trucks, the private ones, those would sort of be subcontracted out through the bidding process, is that correct?
Yes.
And would the range, as far as the size of those trucks, would that be similar or something different?
They are pickup trucks, or usually lighter pickup trucks. There may be a couple of front-end loaders. There's probably, I don't think there's any big heavy-duty trucks, but they're probably pickups. Might be couple of Jeeps, pickups. Again, a medium duty like an F-350 or F-450 pickup. Those are Fords, and loaders.
Now, with respect to questions or what you were asked about by the trooper, was there a specific sort of street or plow route that the trooper was inquiring about?
I believe he asked who was down, that's Fairview, or down in the Cedar Crest area, that's what we call it. I believe that's what he asked me.
Madam Mayor Pro?
Yes.
So this guy we want to know because Proctor said he told me no plows out on Fairview at that time. And defense has subsequently said we talked to this guy also. There was a plow guy out there. We talked to the plow guy. Plow guy came out and showed us where he was and what he saw. So the implication is that Michael Proctor did not accurately report the information he got from this particular witness.
I'm showing you a document. Just look at that, look up when you finish. Do you recognize that, sir?
Yes, sir.
And what do you recognize it to be?
This would be a plow plan for that day. It's a plow plan for the season, but it is particularly a plow plan for that storm of January 28th through January 29 of 2022.
Thank you, Mayor Pro Tem.
Yes.
Commonwealth is seeking to introduce in a minute the next exhibit.
Okay,
I have no objection.
thank you.
Exhibit number 9. Thank you.
Trotter, when it comes to that form for you that's now been marked as Exhibit 109, I just have a couple questions for you in regard to what's listed there. So with regard to the top of the page, there's a listing as far as 1/28/2022 Boulevard, 11 p.m. Do you see that?
Yes, sir.
Now, what does that mean, sir?
That means that the first group of workforce, which would be the Sanders, were scheduled to come in at 11 o'clock that night.
Now, as far as the next entry going across the top of the page has 1/29/2022, is that correct?
Yes,
And as far as what's listed as W&S/BM/REC at 2 a.m., what does that mean?
W and S would be water and sewer. BM would be building maintenance. REC would be the rec. And they are scheduled, that would be the balance of the Canton's workforce. They were scheduled to come in at 2 o'clock in the morning.
And that 2 a.m., would that be at the same sort of central location? of
Yes,
all-
they would all report to the Bolivar Street garage. I think that address is 150 Bolivar Street.
Now, as far as the next listing, it states contractors at 3 a.m., is that correct?
Yes, sir.
And who is that referring to?
That would refer to all the private contractors that would be plowing that day. So again, it's staged.
And sort of the last sort of notation on the top of that, it indicates out at 5 a.m., 1/30/2022, is that correct?
That would be when we completed and everybody went home.
Now, with reference to the Cedar Crest neighborhood or the area that would include Fairview Road, there's different route numbers that are assigned, is that correct?
Yes, sir.
And which route number would include that Fairview?
That would be Lower Cedar Crest number 11.
And from that, that would include Lower Cedar Crest, Kings, Fairview, and Spring, correct?
Yes.
And as far as the vehicles and the vehicle types that were assigned to that route pursuant to this list, what types were they and who was assigned to?
Truck 30, which would be a town of Canton truck. That's a 43 International. Brian Lochran would be the driver. The 43 International is a medium duty truck. The next up would be 7400 International, that would be the large construction truck. And there is an absolute, a by the yard 4x6, which is I believe that's a small 1-ton dump. That would have been the private contractor that was on the route with the city truck.
And so that truck 30 to 4300 International, is that a bigger truck or a smaller truck than the 1-ton?
Then please again? Then the 1-ton?
Yes.
It's a larger truck. It's
He said it's a medium-duty truck.
like a 3 to 5
Jesus.
cubic yard truck, and the large truck is like an 8 to 10 cubic yard dump. That's a dump truck.
And as far as the height on that International, would that be, how much, would it be taller or shorter than say a 1-ton dump?
If you want, I would estimate that if you're sitting in the driver's seat of a car, you're probably 2.5 feet. When you're sitting in the driver's seat of a 1-ton, you're somewhere around 3 feet. When you're sitting in the driver's seat of this 4300, you're probably somewhere around 4 to 4.5 feet. And when you're sitting in the big construction truck, you're another 8 to 10 inches, 5 feet plus.
Now, when you're driving, or when the plow drivers are plowing the roads, what, if any, sort of instructions are they given as far as how to first start plowing the roads when they first come upon sort of dropping the plows and going?
If we're in a plowable situation, which is kind of hard to define, it's generally when we feel that traffic is impeded or may not be able to safely get up and down the street. So that's probably anywhere around 2 inches. They're instructed, and we're expecting the heavy snow. They're instructed to plow the middle of the road, keep the middle of the road open. And as they make their way through the route, they're supposed to push back a little bit. If they try to clean a whole lane and then come back and do the lane again, generally they end up being in trouble and they can't keep up if it's a heavy snow. So they're instructed to plow the middle of the road, to keep the roads open as much as they can before they do their finished cleanup.
I may have one moment, Sean.
Yes.
I'm sorry, but this whole height of the truck thing, that depends on so many factors. How big of the wheels are on the truck? Do you have a lift on the truck? I mean, it can vary a massive amount. You can have a small truck that's pretty lifted, and you're going to be up there.
Thank you, sir. No further questions.
All right, Mr. Yannetti?
Thank you, Your Honor.
Now, he promised us some stuff in
afternoon, Mr.
opening
Trotter.
with this guy.
Sir, Michael Proctor called you on February 3rd of 2022. Does that sound right?
It may be, I'm not sure of the date.
It was within days of the big snowstorm, correct?
Yes.
You knew that he was investigating the death of John O'Keefe, which had occurred on January 29th, correct?
I did not know that.
Had you heard that there was a police officer who was found dead on the lawn of another police officer in Canton?
Well, I knew, yes, I knew.
It was fairly big news at the time,
Yes.
correct? And were you aware that that was why Michael Proctor was calling you related to that investigation?
After he called and identified himself, he said that is why he was calling.
Of course. Now, you spoke with him over the phone only, correct?
Yes,
He never came down to the DPW to meet you in person, correct?
not me, no.
And he never asked to interview any of your employees, correct?
We may have discussed who was on that route and who plowed, but I'm not sure at that time if he had told me he was going to go talk to anybody else.
Oh, so it's your testimony that you may have told him the identity of the plow driver when you spoke with him on February 3rd over the phone?
I may have, but I am not positive.
You don't have a memory of him asking you who the plow driver was?
He asked, no, I don't have a memory of his exact questions.
But leaving aside the exact wording of his questions, it's fair to say you don't have a memory of him asking you who plowed Fairview Road on January 29th. Is that fair to say?
He asked me about, I believe he asked me about this plow list.
About the what? The plow list?
This plow list.
Right, but on the plow list, there's the name by the yard, correct?
Yes.
All right. There's also, to the left of that, an indication of the name of the plow driver, and it's just a first name and a last initial,
Yes.
correct?
Yes.
It doesn't spell out the whole last name, does it?
No.
But you know the full last name, correct?
Yes.
You have a limited number of employees, right? It's not a 1,000-person company, right?
Yes.
All right. And you're well familiar that Brian L. is Brian Laughlin, right?
Yes.
As you sit here today, do you have any memory of whether the name Brian Laughlin was brought up during that phone call with Michael Proctor?
I may have said to him that's who BL was, but I did I believe I referred him to the operations manager to double check who was on plowing that day.
Okay. You say you may have mentioned the name Brian L. or Brian Laughlin, but again, I'm just trying to drill down on what your memory is. Do you have a memory one way or the other as to whether the name Brian Laughlin came up in that conversation?
If you are asking me, do I remember 100%? No.
Okay. In any case, Trooper Proctor, Michael Proctor, never asked to speak with Brian Laughlin when he talked to you over the phone,
He
correct?
did not ask me, no.
I'm going to allow the question and answer.
And how short was that phone call with Michael Proctor?
If I tell you, you're going to ask me, how do I know for sure? I would say a few minutes, whatever a few minutes is.
I'm going to accept that answer. And you would agree with me that after, and you, by the way, you were trying to be helpful, correct?
Yes.
After that couple or 3-minute phone conversation, you'll agree with me that Michael Proctor never followed up again with you personally.
That's a good question. I am not sure.
Okay. Well, I'd like to direct your attention to about a week and a half later, specifically the date of February 14th of 2022, which maybe you don't remember the precise date, but around that time period, you came into work around that time period, and you learned that a defense investigator named Paul Mikowski had left his business card for you with somebody on the DPW staff, correct?
Objection.
Sustained. Ask it differently.
Yes.
I do not,
Sir, that means you,
Don't answer that question. I think he's gonna ask one that's an appropriate one for you to answer, okay?
all right.
Do you recall when you came into work receiving a business card from Paul Mikowski?
No.
Do you recall calling Paul Mikowski back?
No.
Do you recall speaking to any investigator from the defense at any point within a couple of weeks after you spoke to Trooper Proctor?
No.
Do you deny telling Paul Mikowski to call Bill Walsh?
Objection.
Sustained.
Who is Bill Walsh?
Billy Walsh is the operations manager for
The Highway Department supervisor?
yes.
Did the name Bill Walsh ever come up in your conversation with Michael Proctor back on February 3rd?
Objection.
Did that name come up when you first spoke with Trooper Proctor?
Again, I believe I mentioned it, but I am not positive.
Is it fair to say that the Canton DPW has their own plowing and sanding trucks?
Yes,
Does one of them in particular have a nickname?
if they do, I don't know what they are.
Have you heard one of your trucks being called Frankenstein?
Objection.
Sustained.
What's wrong
You
with
don't drive the
that?
trucks, correct?
No, I do not.
But Brian Laughlin does?
Yes, he does.
And Brian Laughlin was driving the truck that plowed Fairview on January 29th of
Yes.
2022?
Objection.
Let me have a moment.
Yes, it'll stand. The answer will stand, Mr. Lally.
Let me just have a moment. please.
I don't know if it's better or worse if he might have mentioned the stuff to Proctor.
Sure. Can I approach
Because I'm pretty
The
sure
witness or the
Proctor
sidebar?
the
said
witness?
Yes.
Sorry.
it didn't exist.
Do you have reading glasses as well? Or
Well, I have, yes,
are you able to read the exhibit that you have in front of you?
yes.
Terrific. I'm handing you another document, sir, and I would ask if you would compare that document with the document you have in front of you and tell the jury if it's the same document or not.
It appears to be,
Does it appear to be identical?
yes.
I will take the one back that does not have the exhibit sticker on it. Thank you, sir. And I have no further questions. Thank you.
Any follow-up, Mr. Lally?
No, Your Honor, but may I just retrieve the exhibit?
Yeah. All right, Mr. Trotter, you are all set, sir. Thank you very much.
All right.
All set.
You have another witness here, Mr. Lally.
Yes, Your Honor.
Okay, your next witness, please.
Your Honor, the Commonwealth call Mr. Louis Jutras to the stand.
Oh, boy. I'm going to have to find that one on the witness list. I do not know how to pronounce that, spell that. Louis Jutras, Jutras.
Raise your right hand. Solemnly swear the evidence given to the court and jury in the case now hearing to the truth, the whole truth, and nothing but the truth, so help you God. Thank you. I take the state.
All right, Mr. Lally.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for the jury?
Louis Jutras, Jutras.
And where do you live, sir?
Stoughton, Massachusetts.
And how long have you lived in Stoughton?
About 23 years.
And what is it that you do for work, sir?
I work for the town of Canton. I'm the manager of the Information Systems Division of the Finance Department.
And
The
how
what?
long
What
have you
was-
been
I'm
doing
sorry,
that?
what was the last part?
Of the Finance Department.
Thank you.
And sir, how long have you held that position?
Almost 25 years.
Now, if you could explain to the jury, just as far as your job is concerned, what does that relate to, or what is it that you do as a director of informational services?
Sure. So my responsibilities are for the municipal departments and all the technology associated with that.
And does that include everything sort of from cell phones to GPS in town vehicles to security systems, things of that nature?
Yes.
Now, with reference to your department, how many people work in your department?
There's 3 of us in total, myself and 2 others.
So you essentially supervise the other 2 people as well?
Yes.
Now, at some point, if I could turn your attention to around the time of January 29th, 2022, some point after that, did someone from law enforcement or from a police department reach out to you in regard to security cameras or camera systems within the town of Canton?
Yes, I received a notification from the Lieutenant Gallagher that there was a motor vehicle incident in town, that the state police would be looking for some video footage.
And so you received an initial notification from Lieutenant Gallagher telling you that the state police would be reaching out looking for video.
Correct.
And at some point shortly after that, did you receive any sort of, did anybody from the state police reach out?
Yes. Trooper Dunn reached out. We had a phone conversation. We had email correspondence relative to dates and times. We had pulled some footage from one site in Pequiside Farm that was put together. And then after that, there was a request for anything facing Washington Street, either from Town Hall or from the library.
And so as far as what was relayed to you by Trooper Dunn, what was sort of the description or what was it that you, were they asking just specifically timeframes, or did you get any other information as far as what you were looking for?
From what I recall, there were 2 different timeframes, between 12 and 1, and then between 5 and 6. That was in our discussion and correspondence relative to Town Hall.
And just to be clear, that's from 12 a.m. to 1 a.m. and then 5 a.m. to 6 a.m.?
Correct.
Now, as far as the Pequiside Farm, describe to the jury sort of what kind of location that is or what kind of town property it is and where it is in relation to the town.
Yes, so the physical area is off of Pleasant Street, which intersects with Washington Street, closest to Dedham Street and the police department. That's a large area, big white house, and we have cameras that, face the entrance, the street, and the surrounding building.
As far as the coverage from those cameras, have you had occasion on this occasion or prior occasions or subsequent occasions to look at sort of the view that the camera gets from Pequiside Farm?
Yes, yeah, we have a straight shot down from the building, down the entrance driveway, right to the street. The other cameras that are around there's a couple of doorbell type cameras that physically focus on specific sections, and then other ones cover the general grounds around the building and the backside.
All right. So can I interrupt for a minute, sir? Could you please spell the name of the firm?
Yep, Pequiside, Pequitside.
Thank you.
Pequiside.
Sir, Mr. Jutras, is it fair to say that
Thank you
the
for that.
Pequiside Farm cameras cover more of the property and less of the street out in front? Is that correct?
Yes.
Now, as far as that was the initial request was in regard to Pequiside, is that correct?
Correct.
And so the subsequent request, what was that in regard to?
That was for anything town hall or library that physically faced Washington Street.
And so the town hall and the library, sort of where are they situated in relation to each other and in relation to Washington Street?
Yep, so they physically abut on either side of Washington Street, right at the intersection of Sherman. They are diagonal to each other.
Now, as far as the recording devices or the cameras on town buildings within the town of Canton, are those, are they sort of uniform or does it vary from location to location or vary within the location?
The physical model of the recorder, as far as the manufacturer, that is the same that we have across 15 different sites. The types of cameras do change, indoor, interior, exterior, doorbell, things like that. But all the actual recording units are of the same manufacturer, just different sizes and models.
And as far as the town hall and the public library cameras, as far as The exterior cameras at least, they face in that area of Washington Street and actually capture portions of Washington Street?
Yes, yep.
Now, as far as the cameras are concerned, particularly the exterior cameras that we're talking about as far as the library and the town hall, how are they sort of set up to record? Is it one continuous recording? Are they motion activated? How are they?
Yes, the cameras, based on size and so on, they are all set up for motion in pretty much all of our locations.
And as far as from your review of those cameras, is there any sort of indication on the footage as far as date and timestamp or anything like that?
Yes, we usually have it in one of the corners or someplace along when we have the video saved off and exported.
And when you were able to pull the video that the troopers were requesting, the date and timestamp affixed to those videos, was that accurate as to what the date and timestamp actually was at the time that it's recording?
Yes, I would believe so.
And sort of those date and timestamps, you know where they come from?
The system is linked to a time server, which is remote and is used from the national standards.
Now, as far as the video is concerned from those, they're motion activated, but how far back do they go as far as how many days pass before, does it get sort of overwritten at some point?
Yes, depending on the site, most of them, because of the motion activated, because of, various request types and so on, and the number of the cameras, we usually try to get about 30 days. There are some that go longer because the site is or isn't used as much. And then there are other ones where, specifically with the library, they only requested to have a maximum of 30 days on that device.
And so when you received this request from the troopers, that was well within 30 days, is that correct?
Yes, yeah, because we're talking February 7th for the last request.
Now, as far as the video that you exported, well, let me ask you this. As far as when you were asked to retrieve that video, can you explain sort of mechanically the process, how you got that video and how you delivered that to the troopers?
Yeah, so specifically for the town and the library one, that again, timeframe provided, using the manufacturer's software product, doing the search, picking the cameras that are facing the Washington Street side, and then having the timeframe and exporting that out. That becomes, depending on the size of it, either a full executable that can just be opened and viewed, or a combination of files that has a player with it. And then based on the fact that we had already put videos together and that material was picked up, I had sent a file share link for that information.
You had sent that file share link to Trooper Dunn, is that correct?
Correct.
Now, as far as the video that you reviewed, were you sort of parsing or were you looking for specific areas, or did you just sort of take the whole time period requested and send that off to the trooper?
As far as I recall, it was the whole time frame, just because we only have 2 cameras or so that physically cover the area in question. And he had 2 separate hours in question as well. So they were able to be exported and sent.
Now, as far as this particular video, this is video only, correct? There's no audio that's attached to these cameras?
Correct, no audio.
Now, as far as access to these cameras and the footage within the cameras, who, if anyone besides yourself, would have access to remove any sort of footage from the cameras?
No one.
Now, sir, before we get to the camera footage specifically, I just want to ask you about another area. In relation to, also within sort of the ambit of your duties and responsibilities would include GPS on town trucks, correct?
Yes, Public Works has a setup via their radios for GPS information.
And so with regard to that, specifically the DPW trucks, what, if any, information did you receive from anyone at the DPW in relation to those GPS devices within the trucks shortly after the snowstorm from the 28th and the 29th of January?
Yep. So on February 1st, I received notification from the operations manager that the GPS information was not working.
And so you received information after the snowstorm that it wasn't working during the snowstorm, is that correct?
Correct.
And as far as that, as far as GPS sort of going down in the DPW trucks, is that abnormal, or how often would that occur?
Yes, it happens several times throughout the year for various reasons. They have a radio repeater. It's connected through a network. It runs software on a server that we have in-house. Server's rebooted, network goes down, things that, change for various reasons, and we need to reestablish connection to whatever recorder it is for that repeater, and then the information is then picked up.
Now, taking you back to the Canton Public Library video that you provided to the trooper, were you told anything about sort of any type of vehicle or anything to be looking for within that particular video timeframe that they were asking about?
Not that I
It'd
recall.
be so inappropriate
Did
if
you
they
recall
did.
ever actually watching the video yourself as far as
He's not the
confirming
investigator.
sort of what it was?
Yes, I mean, I watched it from the time frame to see that we had information, watched it just to move forward to the end to make sure there was information and when the recording, was physically available. But what was in it? No.
May I approach?
Yes.
So I'm showing you a disc, just ask you to, as far as that video from the Canton Public Library, you've seen that video subsequently, is that correct?
This disc with the wording on it?
Yes.
No, I have not seen this.
Not that specific disc, I'm sorry, sir, but the footage, have you been shown that particular video footage, or did you review
How
that
would he
footage
know?
before you gave it to the troopers?
What video footage is on it?
This is not mine to the trooper.
Understood. May we approach?
Okay.
Foundation problem here. How can he say what footage is on it and whether that's the same footage that he gave the trooper? What a ridiculous line of questioning. He told you it's not his disc. So if anybody deleted data from City of Canton controlled operated camera security systems, it would have to be him. I hope we find out on Cross if that includes Canton PD, or does Canton PD control their own cameras? Don't know. Be interested to know. Do the cameras also go down mysteriously and unfortunately, just like the GPS does? The network resets, the cameras go down. Does that type of thing happen? Because that would be some more remarkable series of coincidences. It goes down
So
right
you
at the
both
Sally
agree that
port.
this will be the next exhibit?
Yes. Yes, ma'am.
And that's Madam Clerk sidewalk.
Oh, I'm sorry. All right, so the parties agree that this is the next exhibit, correct?
Yes, sir. Yes, sir.
So they're just stipulating to it because, yes, it's probably
Thanks.
a piece with the relevant stuff extracted.
Your Honor, with the court's permission, I would just ask to briefly, publish portions from those.
Hold on. Yeah.
I'm sorry.
Yes. Yes.
Ms. Gilman, if I could have
Possibly
the
enhanced,
first
who
video
knows?
portion from 12 a.m. to 1 a.m. Mr. Jutras, from what's up on the screen, you recognize what's up on the screen?
Yes, I do.
And as far as the view from this camera, this is from the library, is that correct?
Correct.
And so as far as what we're looking at here, this is the view from the camera as you observed it on the security camera and as you provided it to us, correct?
Yes, sir.
I'm sorry, sir, do you have is there a laser pointer up on the desk in front of you?
Yes, sir.
Are you familiar with this area as far as the area of Canton?
Yes, yes. Town Hall is right across the street.
And I'm sorry, I stepped right over your words when you were saying that.
Yeah, so Town Hall is right across the street, and the intersection here is at Sherman, and this is Washington along the street that you'll see.
So Washington sort of runs parallel with the street, and then Sherman is the street that appears to intersect with Washington
Correct.
in the area of the town hall.
Yes, sir.
Thank you. Ms. Cohen, if you could take that down and then just put up the 5 to 6. Again, sir, what's up on the screen? Do you recognize that?
Yes.
A little bit
This
more
is
snow
essentially
at
the
5
video that
a.m.,
you
but
provided.
still not
You're
that
looking
much.
retrieved from the Canton Town Library from 5 a.m. to 6 a.m. later on that day, January 20th.
Yes, sir.
And the orientation as far as Washington Street, Sherman Street, that's all the same.
Not seeing a whiteout.
In reference to the earlier, the camera hasn't moved.
Correct.
Great visibility for a snowstorm.
I may have one moment, Charlie.
Yes.
Thank you very much, sir. I have no further questions, Your Honor.
I may proceed, Your Honor.
Okay.
Good afternoon, Mr. Jutras.
Good afternoon, Attorney.
So confirming the state police, when they contacted you, asked for 2 hours of video footage, right? Between 12 and 1 a.m. on January 29th and between 5 and 6 a.m. on January 29th, correct?
Yes, sir.
You pulled that video footage, or at least arranged for it to be pulled for the state police, correct?
Yes.
And I believe your testimony was that you checked the beginning time and the ending time to make sure that you had the right time periods for those 2 hours, correct?
Yes.
But you did not sit down and watch 1 hour of snow falling and/or cars driving by the public library, correct?
That is correct.
Did
I
you do
did
that
not.
for between 12 and 1 or between 5 and 6?
Correct. I did not.
And at the time that you provided the video footage to the state police, did you know whether or not there was any missing footage within those 2 hours?
No. Because again, I did not play every single second of the video.
Understood. It's fair to say, and you're certain, that you did not cut out any of the video footage in those 2 time periods, correct?
Correct. It's motion activated. That's the only piece.
You provided the state police with the raw footage as it existed in your possession at that time, correct?
Yes.
And at that time, you knew that the raw footage was only saved for between 30 and 60 days?
That one is less than 30, yes.
Right. Now, as of early February, when you were dealing with the state police, you knew that Karen Reed had been arrested and charged in court, correct?
I do not recall if I had that information.
You knew that there had been a police officer found dead on the lawn of another police officer in Canton?
At that time in February, I believe so.
And that likely would have been discussed when the state police called you?
I do not recall the conversation other than asking for video footage for Washington Street.
And I'm sorry, sir, if you could just keep if I can't hear you, I guarantee you that these last jurors can't hear you. Could you repeat that last question?
Yep, again, when in the conversation with it, we had the dates and the timeframes, and anything else relative to it, I do not recall specifically the conversation.
Okay. So you don't have a memory of why you were being asked for this?
Correct. I know it was for a motor vehicle accident. Who and what, I do not recall if that was ever mentioned specifically.
Okay. you would agree with me that as the IT director, you had the ability, if you wanted to download the footage onto some hard drive to preserve it, if you wanted to do that?
Yes.
Did any state trooper ever ask you to download and preserve that footage so that it would exist longer than that 30 to 60 day period?
No.
And so it's fair to say you did not do that, correct?
Correct.
You complied with what they asked you to do.
Yes.
Now, skipping ahead to April 6th of 2023, you were contacted by Michael Proctor, a state trooper investigating this matter, correct?
I do not recall.
Do you recall Michael Proctor asking you to provide to the defense in this case the same raw footage you had previously provided to the state police?
No.
And you don't recall telling him that you couldn't do that because after 30 to 60 days, the footage is gone, correct?
I had a phone call with what I thought was Trooper Dunn asking for another copy of the data and telling him that I did not have it and I couldn't recreate it.
I see. Oh, so you assume
If it was Proctor, but no, I thought I was speaking with Trooper Dunn.
Trooper Dunn was the name that you remembered from February.
Correct. That was the first interaction I had.
And when they mentioned state police, you assumed it was the same state police trooper, correct?
Yes.
It's fair to say that once you shared the footage with the state police in February of 2022, you didn't control what they did with it after that, correct?
Correct.
And you have no personal knowledge about how they preserved it or didn't preserve it, correct?
I'll allow it. Do you have any idea?
No.
And one last question. You cannot testify about whether any video was removed from the footage after you provided it, correct?
Objection.
Sustained.
Nothing further. Thank you.
You follow up?
No redirect, Your Honor.
All right, sir, you are all set.
So we're going another half an hour? Who do we got?
I do not, Your Honor, no.
He doesn't
Maybe
have any
approach
more.
just on.
So they're going to approach because he doesn't have any more witnesses available for the day. So much for that extra half hour that Judge Bev thought we were maybe going to get. Doesn't look like we're going to get that. I'm just assuming she's going to excuse the jury and we're going to be on our way. But that was a bad assumption last time. I don't want to miss if they decide there's something we need to talk about. Well, I'm showing we're down to 37 witnesses left.
So
You are unmuted.
in fairness, I didn't tell the lawyers that I was hoping to go until 4:30 today. And I understand, as sometimes happens with law enforcement witnesses, they get called away. So that's it for today. Now, next week, I would like to go as much as we possibly can on the days that we're here for full days. So Monday is a full day. I would like to go until 4:30 if everybody can, with the shortened lunch hour. Tuesday, we're not in session. Wednesday is a full day again. We'll go right till 4:30 with the shortened lunch. Thursday is a half day, maybe even closer to 12. And Friday, we will not be in session. So those are dates that we gave you before. So we will get as much done as we possibly can during that period. Okay, so those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. You've got a few days off, just disregard this case, don't think about it, leave everything here, and have a great few days. We'll see you next month.
All rise for the court, please.
Nothing until Monday. Nothing until Monday. And this schedule, this is whack. And then we get 2.5 days next week. Monday, Wednesday, full days, and a half day Thursday. This is going to drag on. This is going to drag on. I see folks wanting to know why. I don't know. I don't know if this is scheduling conflicts with the court, scheduling conflicts with the attorneys. I don't have an answer for that. I just got to assume somebody is unavailable for some reason, and so they're not able to have court on that day. And it's somebody,
If it's
somebody critical.
scheduling, I will actually see you over here for scheduling purposes.
I'm gonna just leave this on in case they come back with something to tell us. But boy, I really want to go back to Nicholas Roberts because holy cow, okay, the retrograde extrapolation, this is trash. This is absolute trash. He told us everything we needed to know that this was trash. I'm listening to the doctors testify about the draw, and I'm anticipating here's what the defense challenges are going to be to the draw, right? They're going to challenge maybe it was an ethanol swab used, so potential contamination. There's a lot of variables involved in doing these extrapolations. The serum is different from the whole blood content, just as a matter of volume. This is very simple. If you have solid things in a liquid that do not themselves absorb the alcohol, they don't hold the alcohol, then you have displacement. Those things fill up the blood. They go into the serum. It increases your total volume. Like putting pebbles in a water glass. So the whole blood measurement is a total blood volume measurement. That's why it's going to be different when you're just taking out the serum. So we're anticipating all these things. And then there's all the variation that goes into trying to convert that into a blood alcohol sample. You have the whole blood, but for whatever reason, you didn't test the whole blood. You don't have that capacity or something, I guess, because yeah, I mean, like you said, you're not interested in the blood alcohol, the whole volume. That's relevant for legal purposes. It's not necessarily relevant to medical purposes. So you just do what makes sense medically, but then to be able to convert that back, you have to make a whole bunch of assumptions with that that have to do with things like what is your hydration level, what is the percentage of blood, red blood cells that you have. That's the hematocrit language that we were talking about earlier that they brought up. That's what that means. Some people have more red blood cells in their blood than other people do. A lot of variation with that. So to try to guesstimate how a serum level converts to an actual total blood volume, it's so much guesswork. There's a massive amount of just assumption that goes into that process anyway, and that can be, especially for women, by the way, affected by a lot of hormonal issues can affect your water retention and stuff like that. Ladies, you know exactly what I'm talking about. Big variation in hydration and things like that, even under a best case scenario. So I'm hearing all this, and I know where these challenges are going. They're going to go to just the sheer number of them gives you such a wide range that yeah, it's not necessarily all that helpful information. But then, as far as I'm concerned, Mr. Roberts put the stake in the heart of the retrograde extrapolation here when he told us he based it off of the 1245 number. The 1245 time frame is what he was given to run the extrapolation. We know that's junk because we know that Karen was long gone by 12:45, and they didn't get into details, either indirect or on cross, about why would you use the time of the incident as opposed to the time of the drinking. They just kind of used those interchangeably, and he explained sometimes you'll use the time of the incident, sometimes you'll use the time of the last drink. So I'll tell you, the reason why they will often use the time of the incident, well, number one, that's the pertinent time frame. That's what they want to know. If you hit somebody with your car, they don't want to know, were you drunk an hour later, were you drunk an hour before? They want to know, were you drunk at the time this legally significant accident took place? But the reason why they will frequently use that in this retrograde extrapolation as essentially the same thing as the time of the last drink is because people tend to get arrested at the scene when stuff like that happens. When they are stopped for a DUI, that is the time of incident. So they are in police custody after that. And the police will know, you didn't sit in my booking room and swig a bunch of alcohol there in front of me. You didn't have any more alcohol after the point in time when I took you into custody. So that's why they'll use that as the last time. It's giving them the benefit of the doubt that that's the latest possible time they could have had something to drink would have been seconds before that incident when they got pulled over. Because after that, the cop had him in custody and can attest they didn't drink anything after that. That is such an absolute terrible fit for this particular case because number one, we don't know exactly what the time of the incident is, but we certainly know nobody was arrested at the time of the incident, and we have no knowledge whatsoever about what she might have drunk after she went home. After she went home, where she's angry, she is leaving apparently angry voice messages on Joan O'Keefe's voicemail. She might have had something to drink. I'm just going to put that out there. Doesn't seem all that unreasonable to me. And as far as when we know for sure the last possible time she had a drink, well, it would have been closer to midnight, right? Because that's when everybody is leaving the bar. There's no proof that she was drinking in the car or something like that. If we accept Michael Proctor's version of events, right, where he sees it on the video, let me just go ahead and find that, where they get the video. Leave CF McCarthy's at 10:40. So they don't get specific. He doesn't get specific on the times at the waterfall, just they enter at 10:04. She was grabbing the drink she walked into. Observed on this video consuming 2 additional drinks, 1 shot and 1 mixed drink. Those ones are not time stamped, but we know she's leaving by 12:10. That's it. That's when she walks out the front door, is at 12:10. So that's the last possible time, more than a full half hour before when they're said to run the retrograde extrapolation from. Trash. Trash, absolute trash. And I mean, again, this is giving Trooper Proctor the massive benefit of the doubt that what he claims to have seen on video, time-stamped, that actually exists, because we haven't seen it. Nobody's shown it to us. They've shown us a lot of this bar video, but not the drink after drink after drink after drink that Trooper Proctor told us you can see on that video. We haven't seen any of that. So this is all giving him the benefit of the doubt that she did in fact have drinks at this time on these videos that can be identified. Because if you don't have that, what you have is somebody who had a drink earlier and nobody has seen her get any additional drinks. Nobody has seen her have a different glass. Nobody has seen her order anything else. The bartender doesn't testify anything about serving her. She's had 1 drink over this entire time frame. That's what people have testified to. That's going to be a whole different situation with rate of absorption, rate of elimination. If you're not like down in a whole ounce of alcohol at one point in time and you're spreading that over time, the the time of your last drink, all right, it looks like they're done. The time of your last drink is not going to be that in, because you've been nursing it for hours. This is not the average situation of, you drink a drink within a few minutes, and then you have a few more drinks. Oh, this is trash. This is trash. 12:45. There is no chance that 12:45 was the time of her last drink. And for purposes of this math calculation, the time of the last drink is what matters. It's only the incident that matters if police have you in custody after that and can determine you didn't have any alcohol after that. So it's a last possible time you could have had anything to drink is moments before the police pulled you over. That's when the incident matters. That is not this case. Yikes. And so I wonder, we got a lot of defense experts here, a lot of people coming in. Have they redone the calculation with different parameters? I don't know. Do they even need to? Do they even need to? Is this enough? Is this enough to be like, wow, what a bunch of trash. What a bunch of trash this is. And yeah, the reason why it matters, 2 of these 3 charges, it matters. It's an element of the crime that she's under the influence at the time that the things happen. She's charged with recklessly. This is like the lesser sort of version of the homicide that she's charged with. She's charged with intentional second-degree murder. And then she's charged with recklessly hitting him with her car while under the influence. You got to prove she's under the influence to get there. Same thing with the final charge, the DUI. You got to prove she's under the influence. So that's why they have to prove something. This is some weak sauce evidence to get me to she was drunk. No, not buying it at all. Not buying it at all. 12:45, it's like you're looking for the wrong answer. You put it as late as you possibly could. 12:45, she's already home. Why did we even come up with 12:45 as the time of the incident? 12:30 seems a little bit more accurate, right? This is when all the texting was and stuff. You're trying to give yourself as much benefit of the doubt as you can because you need it to be high. You need that result to be high. Yikes. Absolute trash. Absolute trash. Well, Dr. Rice was weird. What's our takeaway from today? Dr. Rice, he seemed strange. He seemed strange. I don't know why he wanted to seem to make excuses for why there wasn't evidence. I don't know. It's very strange. Just acknowledge, yes, there's no internal injuries. There's no head injury. It doesn't matter why you didn't check. You didn't see him. That's sort of the bottom line. It's okay if they didn't exist. It's fine. It's okay if you didn't see the gash on the back of his head if it doesn't matter for purposes of resuscitation. That's fine. Nobody cares. But just a little bit odd with his trying to put the ER statement about a vehicle accident in his notes, that he was told that. Not in your notes, dude. It's not in your notes. It wasn't in his notes. It's not in anybody's notes. You can't tell me you wouldn't write that down if it's a suspected motor vehicle accident, because wouldn't that tell you what you're trying to look for? Wouldn't you have a pretty good idea with your years of residency and trauma and in the ER of, you've probably seen thousands of car accidents and you know what kind of injuries people tend to present with when they show up in the ER after having been in a car accident. So that's going to guide you about what you should be looking for that might interfere with your ability to resuscitate this guy. Yeah, if he's hemorrhaging out internally, then it doesn't matter how long you pump on his chest until you solve that problem of the internal bleeding. You're just at best you're going in a circle. But he's still dying until you fix that problem. If his brain is swollen and it's interfering with his internal processes, your brain, you get a bad brain injury, your brain will swell, and then that's how it kills you, is because the parts of your brain that control things like your heart pumping and your ability to breathe and just all of those natural processes, those get pressed up against your skull basically, and they can't function, and you'll die. That's how people die from brain injury. I would think you would want to know that, if we're going to sit here and work on resuscitating this guy, but it's not going to matter because his brain isn't going to let his heart start to work again. His brain isn't going to let his lungs start to work again. I would think you would want to know that. It's kind of relevant to your resuscitative efforts. You would need to do something to relieve the swelling on the brain. So they'll typically literally open up the person's skull, open your skull right up, give the brain some room. This stuff seems pretty relevant to me. So really, really weird that he's defensive about what they did and what they saw, and that he wants to get that in there about being told about the motor vehicle accident, but it's not in your notes. It's not in your notes. And this is one of the only guys now, of course, they don't ask. You knew this had to do with Karen Reed. You found out later it was about this case. This is a prime situation for, you heard that after the fact, and you've now since reincorporated that into your memory of events. He didn't ask about it. Doesn't mean they can't argue it. But they definitely didn't ask about it, and that would be helpful. It would be helpful to know if he knew something about this case from just watching the news. Was he interested in it at all? Has he followed it? Dr. Gary Fowler, the pathologist, okay, he didn't do anything. He's the lab director. He's there to testify to what the policy is. This weird confusion of using algorithms in place of protocols. No, they are not algorithms. I promise you, medicine like this. Well, I can't say that anymore. There probably is medicine now that's being done by algorithm, right? You're plugging stuff into the computer, and the computer is running its programs, and it's spitting out, telling you things to do. There's probably actually a lot of medicine that is happening that way. But in terms of how to do a blood draw, that's not an algorithm. That is just a protocol. So that was weird. I don't know where that came from, but I don't know, just put it out there. All of this sort of nebulous about the policies and the alcohol swab. They know you can't use an alcohol swab when you're searching for doing a blood test to specifically look for alcohol. So they know that. So he says they've removed all of the alcohol swabs from the ER so that doesn't happen. But they also said that alcohol and drugs of abuse, these are not routine. These are not routine tests that they run. So why would you have all the alcohol swabs out if this isn't a primary driver of your policies? That seemed a bit strange. Like you would use alcohol for all the other ones because it works, it's good, it's effective. Like you pointed out, you wait a while, it evaporates. Shouldn't cause too many problems. It's just when you're specifically testing for alcohol, you don't want to mess that up. But so what does that mean then? If they have no alcohol swabs down in the ER, are they routinely then disinfecting everyone with the betadine? Like you said, is that their normal? What are they using if they're not using alcohol swabs? That was strange to me. It's not consistent with, this is an unusual test, but you have to remove all of the alcohol swabs to accommodate this atypical test that you do from time to time. I don't know, that seemed weird. But then nobody will come out and specifically say, a non-alcohol swab was used in this case. It was not an alcohol swab. We can say definitively, maybe it's in our records, that a non-alcohol swab was used. They're just all over about what the policy is and how it would normally be, and we're very aware that this can be a problem. Doesn't mean you didn't do it in that situation. People can mess up. It does happen. You know, people fail to follow the protocol. People make mistakes. People grab the wrong vial. People administer the wrong medication. These things are not unheard of at all. Human error is very real. So I understand your policy is not to make mistakes. People make mistakes oftentimes in spite of the policy. And so nothing in here definitively establishing for me the phlebotomist who swabbed her and took the blood draw used a non-alcohol swab. That's all I want to see. That's all I want to see in the notes. That's all I want to hear somebody tell me definitively in this case that can be established. Didn't get that. Don't know if we're going to get the phlebotomist. Maybe we'll ask her personally. I don't know. But I feel like if it's in the notes, given all the time we spent talking about what's in the notes there, I'd have been told that because it's a pretty important fact. And we wouldn't have had to spend all of this time talking about the policy to try to get me to infer that, well, they must have done it that way on this occasion because that's their policy. I don't know that. I don't know that they followed the policy on this occasion. I don't know that they didn't make a mistake. I don't know any of that. I want to see it in my notes so that I can have some confidence. Mr. Roberts, I liked him as a witness. He was great. Man, I would love to have that guy as a toxicologist in some of my cases. Rarely are they that accommodating to the defense. My goodness, he was very, very happy to give the defense all kinds of concessions. The garbage in, garbage out concession is really the main one. Yeah, if the assumptions are bad, then your calculation can be wildly inaccurate. And he's like, yep. I mean, it's true. You can't really fight that. But at the same time, you know, when you're on the defense side, you kind of get used to people fighting you on every little thing like that. The calculation 0.135 to 0.292. Yeah, that's a massive range, well over 100% variation, right? At 0.13, you double that would be 0.26, 0.27. The range is higher than twice the minimum. I mean, this is a massive range. And that's because of the amount of time that they're having to try to account for with all of these variables involved for them to be able to say, go back over this length of time and calculate how we got here. It's going to be exaggerated versus if you're taking it, you get the blood sample 2 hours after the time of the last drink. There's just a lot less wiggle room, a lot less time for all of those variations to operate, to play out. So yeah, they sure tried to get that to that 1245, but no, that is not under any interpretation of the evidence in this case. That is not a reasonable assumption of the time of the last drink. It's just not. It's off by at least an hour. At least. She's wrapping up. They're leaving at midnight. She's finishing that drink at best at like 11:45, 12 o'clock. Not buying this calculation at all. Mr. Trotter, I'm thinking out loud because I can't decide, is it worse for Trooper Proctor if Mr. Trotter did tell him, yeah, there was plows out and Brian Laughlin drove that plow on Fairview at that time, and then Proctor didn't do anything about it, and from pretty sure what we're told, it's represented to us that there was no plow. So I went back and I looked at my notes from Mr. Yanetti's opening. He says the snowplow driver didn't see anyone lying outside when he does his passes. He says Proctor claimed the supervisor. That's this guy. It's got to be Mr. Trotter here. unless it's the operations guy, and maybe we'll get him too, claimed the supervisor told him Fairview Road had not been plowed on that night. Told him definitively it had not been plowed. So you can't reconcile that with he got the information, he got the name of the guy from Mr. Trotter. You can't reconcile those things. And that doesn't look good. That doesn't look good for Proctor at all. I'm kind of thinking that's actually a little worse for him than just the old I didn't bother to ask the questions. I negligently declined to acquire this information that was relevant to my investigation. That's bad. But I got the information and lied about what it was. That's worse. That's definitely worse. And that's really what this is seeming to set up. If what we are getting from Mr. Yannetti that he committed to us in his opening, if that's what we get, that's what Proctor said. The supervisor told you Fairview hadn't been plowed that night, then there's no real way to reconcile even what this guy does remember. He maybe doesn't remember specifically using that name, doesn't remember specifically talking about that, but you're talking about that plow list. You're talking about that. I mean, you knew you were talking about that. The whole plow routes. He asked who was down in Fairview in the Cedar Crest area, and you talked about the plow plan. That's going to have Mr. Laughlin down there plowing. It's probably going to say what vehicle he's on. Yeah, no real way to square that if that's the conversation that they were having. And Mr. Proctor is later saying, supervisor told me the road hadn't been plowed. I don't know that we're going to be able to reconcile those things. Didn't remember anything about the defense investigator. That seemed a little off. I just would expect you would remember a follow-up about that. I would expect you to remember a defense lawyer coming in. That's got to be less common than the police coming in. I mean, I would think the police coming in, it's not going to be an everyday thing, certainly, but they investigate motor vehicle stuff. You're the plow guys. You're the ones, I mean, the way people drive around plows sometimes. I mean, it's ridiculous. Some people just lose their mind. You can't wait for the plow. You can't get stuck behind the plow. You know, the plows are going slow, whatever. People will drive like nuts around plows. I'm sure they cause accidents around the plows. It can't be that unusual for the police to need to talk to the plow people about the conditions at the time, about the people who were out, etc., etc. But the defense lawyer following up with you to talk to you, that's got to be far more unusual. It's just less often that you're going to have anything valuable for them. It's less often that the case is even going to reach that level of follow-up by somebody. Seems to me like that would stick out in your mind, but whatever, it doesn't. It doesn't matter. If they sent the investigator to do it, the investigator is going to testify about it. And this is the big lesson in why criminal practitioners, you must have investigators to do this stuff, because you need them to be a witness in the future when people on the stand who dealt with them in the course of the investigation don't remember what happened. You need them on the stand to do it. It can't be you. It can't be you. Even if I am very involved in my investigation, even if I'm doing the interviews, I'm running all this stuff, I'm asking the questions, I'm gathering the information, I am having an investigator there with me, because I can't testify as a witness in my own trial. If that witness gets on the stand, they don't remember, they need to be refreshed, or they need to be impeached, or something like that. I can't do it. It can't be me to get on the stand and say, well, actually what he said is this. So you have an investigator do that. That's why they're there. So he's going to remember, and that's really all I think that's necessarily going to matter. I want to check real quick. I want to look through the witness list and see if we have anybody that looks like the operations supervisor. I don't think we do. His name was Walsh, right? Mr. Walsh. We have Brian Loughran. I've been saying his name wrong. It's not Lachlan, it's Loughran. So the plow driver himself is coming, but not the operations guy. So is he going to be a scapegoat? Is he going to be the scapegoat in this, that we're going to say he's the one that told Proctor nobody plowed that night? Maybe. I don't know. I want to see that square get closed. And then finally the IT guy who runs the cameras. And what we got from that is any modification of the video would have happened after the fact. I don't know if there's been modification of the video. I don't know what proof there is of modification of the video. I don't know. This is just foreshadowing something that I have to anticipate is coming. So all he did was he got a request for certain time frames. He downloaded it, and that was that. This specific time request, on the one hand, sure, I can understand why they did that, because at least they think they know what they're looking for. The issue is this is very targeted. And it's targeted to Karen being out on the road specifically. We know that because of the 5 to 6 time frame. That's when she woke up early, went back out, was drove to John's house, driving apparently, trying to find him, and ultimately ends up over there at Jen McCabe's and so on and so forth. So this is targeted to Karen and tracking her movements. Well, targeted, and that cuts both ways. If she's your suspect and you're confident she's the perpetrator and that's all you need, great. This is still pretty early on in this process. I mean, you're taking her word for it that she just went straight home after she dropped off John and sat there and went to bed, didn't go anywhere else till she got up at 4:30, whatever it was, and was in a panic and decided to start looking for him. Normally, you don't just take somebody's word for something like that. I mean, especially if it's not difficult to just get the whole day, get the 24 hours or whatever. You get more than what you need, because you can always just go look at the relevant time frame. You can go look at the period where you think it matters. You don't lose anything by over-saving. Unless there's stuff on that cameras you don't want to catch. Unless there's stuff on the cameras around, say, 1:30-ish, perhaps, that you don't want to be picking up. You don't want it to be available. You don't want it to have to be provided to the defense, because they might look for it. Just another little circumstance there where it really wouldn't have hurt them to be broader in their investigation, to widen the net. It wouldn't have hurt them at all. And it really would have eliminated a lot of this potential to argue you had tunnel vision. You were just so focused on Karen Reed that you didn't explore viable investigative alternatives. You wouldn't have that argument if you'd gotten all the video for the last 24 hours or whatever. You wouldn't have that argument there. And so now we're waiting till Monday. Nothing more till Monday. That's what the jury is going to be left with, is that yeah, if something happened to that video, it was outside of what he did with it. He has no idea what they did to preserve it, if anything. That's it. That's what the jury is left with for the weekend. So when I said, Mr. Lally, If he was really good, he would have this timed primacy recency. He'd have us set so that the jury would hear something very powerful for the Commonwealth right before you go into a long break. It's going to be the last thing that happened before your break, so it's going to tend to stick with you. And the defense got to turn that to their advantage. The last thing that they heard was any sort of hanky-panky with the raw video file that was done when this witness wasn't able to recreate it. That would have been them. No idea what they did with it. That's where it got left with them. That's what they're going to remember now. So I don't know where this guy learned to try cases. I just really don't. I really don't. Has he never had a hard case he's had to try before? Have they all been like so easy that none of this stuff matters? I don't know. It's just kind of wild. All right, let's go ahead and get us back to the comments. This is the one we left off on from Nikki B. Might we see law enforcement custodian of records testimony, missing Sallyport video access readers, etc.? Yeah, I would expect that. I would hope that we do. May not get it from the Commonwealth, although I would think we would need at least some of that from the Commonwealth because they want to use it, don't they? Don't they want to show us the time that her car got to the Sallyport? Isn't that part of their argument that police went and got it directly from Dighton and took it straight there, and so there wasn't time for hanky-panky with the taillight on the road? No shenanigans with the taillight on the road, because the times would require them to have driven straight from Dighton to the Sallyport. They want those images of the car in the Sallyport. So are we just getting the photos from the Commonwealth? Those can be independently authenticated. They don't necessarily have to have anything to do with any of the video. We don't get the car entering. I don't know. I'm not sure what to expect. So I don't know if we'll get any of this from the Commonwealth. But yeah, I'd like to think that if they don't, then certainly the defense is going to call it in, because you got to point out the absence of evidence. When there is evidence of absence is not absence of evidence, right? It's the fact that there isn't evidence of something does not disprove that thing happened. This is just a basic kind of logical principle that applies to things. But absence of evidence can be very telling if that evidence should be there. If everything else being equal under all of the circumstances, that evidence should be there and there's not, then why it's not there can really matter. And so especially in a case where we are building up arguments here that law enforcement was misbehaving, law enforcement was not doing this one by the book, they were not coming at all of this stuff with clean hands, then yeah, the absence of evidence is going to be pretty pertinent. So I would expect, yeah, the defense is going to want to call somebody to establish this video should have been there and it's not. Some part of this is missing or whatever. The access readers, I don't think they admitted that. Did they admit it, or did they just like let him cross him on it? I don't think it's admitted yet, because they will likely need some kind of authentication for that as well. Now, I don't know, again, the Commonwealth could stipulate to that. Not totally sure how that would go. If they stipulated to the chain of custody for the access readers and that made it into evidence, then you don't need a custodian for it. That's typically what you need the custodian for, is to provide the foundation that this is authentic, this is what it's supposed to be. I'm the one who personally got it. I delivered it to them, so I didn't modify it. And what they have that they got from me is the thing it's supposed to be. If they stipulate to that, then you don't have to bring the custodian of records in. So I don't know. I don't know the details on that, but I would expect that they would, yeah, at least want somebody who can talk about how the things work. I mean, are these things that are just going to randomly malfunction? They're going to pick up key swipes, phantom key swipes from standing too close to the door. You're going to want to follow up on that. You're going to want to follow up on that. You can't just let that one, you can't let that one sit there. Especially not if you're relying on those key swipes to show, hey, Brian Higgins is hanging out in the police department all day. He's going in all of these areas where the investigation is going on. Oh, and he's there with Chief Berkowitz at the same time. That's what the key swipes need to show. So what? They're standing on opposite sides of the door or something and got butt swipes? I don't know. I don't know if it's necessary, I guess, honestly, with the access codes. I just do you have to debunk that? Is that one that speaks for itself? You don't have to debunk that. Everyone will think that's stupid. I don't know. I really don't. So yeah, very possible the defense will want to call some of these people, whether or not it's actually to establish custodian of records, which, you know, I don't know, but to at least point out the absence of evidence that should be there. Yeah, I think that's going to be necessary. Ed 2276. What's the legal basis for the state having a right to demand a jury trial when under the Constitution, the right to a jury trial belongs to the accused, not to the state? So I think this is going back to the comment when I was talking about Judge Bev's appeal record and the case she had with the sexually violent person. The state had demanded a jury trial. It's COVID delays. She said no, to hold out for a jury trial would violate due process. So I'm going to let him have a bench trial. And that got reversed on appeal. So the reason why it applies in that particular circumstance is because it's not a criminal trial. It's a civil action. It's quasi-criminal in the same way that like contempt proceedings, you know, sometimes contempt is just directly criminal, but sometimes it's like quasi-criminal because it's not, there's a threat of incarceration there, but there's not necessarily like a crime that's on the table. With the SDP stuff, he's not going to be convicted of anything new. It's just a question of whether he's going to be committed or not. So yeah, it has to do with his liberty and his confinement, and it gets some criminal protection for that way. But it's still a process. You don't have the full panoply of civil rights that you have associated with a criminal process. The due process is a little bit more flexible. And it's statutory. It's a statutory proceeding. So the legislature is going to get a lot of say and have a lot of influence over what that procedure looks like. And as long as the defendant gets a right to claim a jury trial, I don't really know of a constitutional argument to say that his right is violated if the state also gets to demand a jury trial. There's no constitutional right to a bench trial. There's a constitutional right to a jury trial, and you can waive that. So that's the kind of the bottom line, is because the legislature decided the state should have that right to be able to invoke it. I've seen different rules in different places, different states, different jurisdictions on whether the state in a criminal trial has the right to demand a jury. And I've seen sometimes they say it does, sometimes they say it doesn't. Haven't really seen a constitutional argument for that, like a federal constitutional argument against that. I think a lot of times some of that stuff, it can arise again out of state statute, sometimes independent state constitution. You can always give more protections under the state constitution than under the federal constitution. You just can't give fewer. So if it's not impairing a right that the defendant holds to give the state the ability to also demand a jury trial, if that's not impairing any of his rights, which it's not a right to have a bench trial, then I think they're probably within their rights to require, allow that type of statute that requires both parties to agree to a bench trial if that's going to happen. Vicky McNamara, not at all law related, but I love Karen's look today. I wish we could get her daily outfit details. Somebody is doing that. I've seen it on Twitter. I don't remember now who it is, but I have seen people have been very good at going out and finding her pieces, what she's wearing. They can find the, you know, the designer, the maker, whatever, if it's like a fancy label or whatever. Some people have been tracking that type of thing and finding it. So we may very well find out who is this? Who is she wearing? As they say on the red carpet. We might get those details. I like to see the full. I like to see the full body just to see how it looks. I mean, that's how a suit is normally supposed to be worn. You're normally going to be seen in it standing. It looks different when you're sitting down, especially when it's a skirt suit. Skirt, a little on the short side for sitting there in court. But I'm sure it looks, you know, much more professional, whatever, demure, modest when you're standing, and it's you know, it's full length, probably, you know, knee slightly above knee or something like that. But I'd like to see the whole outfit. I didn't see what she had underneath the jacket. I only got kind of a glimpse of that nice bling on the jacket, all those zipper details. It looked like it was a non-collared jacket, very contemporary. I like that look myself, the collar with no jacket, or the jacket with no collar. Very modern look. And then you put that in with the metal details, the bling with all those zippers. It's kind of punk. Got a little punk look for a skirt suit. So yeah, I liked it a lot too. I liked the texture of the fabric. It looked luxe. It looked very high quality. It looked like a, you know, thick linen type of blend or something like that. Maybe a woolen blend. Good texture, gave it a little depth of color. Good color on her, that blue. I really enjoyed it. So yeah, keep an eye out if you have the misfortune of being on Twitter, X, whatever. People are following that, so it is out there. You can find it. Crinny, right now he states the state has to convince me that John didn't find out about the texts and they didn't get in a fight and they didn't leave him outside. Yeah, John finding out about the texts. I mean, that is a logical explanation for the difference of opinion about the party, isn't it? Higgins is there at the bar. He's texting her. She's trying to ignore him. Does she want to go in a house where he's hanging out with fewer of them in a different setting and hang out with them there? No, if she's giving him the brush off, she probably doesn't. She probably doesn't want to go. If John doesn't know any of this stuff went down, then maybe he's more interested in going. Conversely, if John does know this stuff went down, maybe he wants to go have a chit chat with this guy that he thought was his friend, but is chatting up his girl behind his back. And apparently, like in his own house, at his own party, while they're sitting there watching the Super Bowl. Didn't they say some of these texts are at that party? Like in his house, dude. Yeah, he might want to have words with Mr. Higgins about that if he knew about it. And that absolutely feeds into a situation where you have alcohol, you have testosterone, you have fighting over women. Yeah, I can see a fight happening. I can see a fight happening under that scenario. That seems like a much more plausible, everyday, predictable kind of series of events than something happened that caused this woman out of the blue to enter a murderous rage for the first time probably ever in her life, because she doesn't have a record as far as we know. She doesn't have a history of being violent and stuff. Her history is that she buys people too much stuff. She makes people too uncomfortable with picking up the tab at the restaurant for you know, a couple dozen people in Aruba. That's her vice. Her vice isn't violence. We haven't heard anything like that. Nothing at all like that. So out of the blue, something undetermined, something happened that would trigger this murderous rage in her so that she backs the car into him and somehow he doesn't know it's happening. He's not able to get out of the way. He's not able to dodge it. I mean, or maybe some drunk guys got in a fight over a girl. Which one of these seems more plausible? Pretty clear to me. Pretty clear to me that some drunk guys got in a fight over a girl seems like that's not a hard sell on a series of events. So yeah, I can understand this perspective too. That's kind of what I'm thinking as a possibility, that this had to do with some kind of conflict between John and Brian Higgins over Karen. This is the immediate situation. They're all in the house. It makes sense. It definitely makes sense. Everage, what do you think the jury might feel if the prosecution doesn't call Proctor the lead investigator? Yeah, so we talked about this a couple times. They have to call him. They can't not call him because the defense will call him anyway. They will get everything in that they want to get in. And then they'll also have that little extra weapon of the Commonwealth wouldn't even call their own investigating officer because they knew all of this bad stuff was coming. They didn't want you to know any of that. They wanted to keep that from you. They didn't want you to hear all of these bad details about what he did and so forth. The Commonwealth is stuck. They don't have a good way out of this situation. They have to call him. So I'm pretty confident predicting, yes, they are going to call him. They are not going to leave that to the defense to do it. Michael Muddragon, Andrea, have you ever seen an expert witness turn out to be a joke? What's done? And what's done if both sides accept them as an expert and realize the mistake afterwards? I don't know if this means that it's a joke to put the witness on, like a ha-ha, the attorney is literally choosing this person as a joke. It's not a serious witness. That would be a violation of quite a few ethics rules to do something like that. I mean, the main one just being candor to the tribunal. If I put someone on as an expert, they're not really an expert. There's some issue going on here then with qualifications. If I'm calling an expert and their expertise is not really relevant to my case, well, that should, the gatekeeper role of the judge should keep that from happening. It's not relevant. It's not relevant to the expertise. So what I'm imagining from this question is kind of a situation like we had with old Dr. Spiegel back in Depp v. Heard, where he looks like a joke. I mean, it looks like a joke. If you had told me that somebody was going to get on the stand as an expert in Fairfax, Virginia, and psychoanalyze Johnny Depp based on how he played Captain Jack, yeah, I would think that's a joke. I would definitely think that's a joke. But it happened. It happened for real. The judge allowed it to happen. The judge was on notice that this was going to happen, allowed it to happen anyway. What happened? It makes them look like the joke. It makes you, the person who called this witness, you look like a joke. If this is what you can come up with to make your case, that somebody is going to psychoanalyze Captain Jack, no, it's just facially ridiculous. So that's, I mean, the worst case scenario, something like that I've seen. But yeah, people get called as experts for, I mean, I would like to say they're jokes, but usually they're not ha-ha funny jokes because somebody's life, somebody's liberty is on the line in this type of situation. I've told a story before. I've mentioned many times. There's a famous case in Washington State that's from back in like the early 1980s, because I talk a lot about junk science in the courts and just the kind of trash that gets admitted when somebody wears the label of expert. Somebody gets to wear that hat. Well, I'm an expert. I have special training in some pseudoscience. And then because of that expertise, they get carte blanche to go ahead and share all of that to the jury. So there's a very famous case in Washington where a guy gets qualified as an expert from his dog tracking. He's got a tracking dog. which I guess is fine. Yes, dogs can do that type of thing. People do train dogs to track scent and stuff like that. But what was quite interesting about this guy is, according to him, his dog was trained to detect the scent of fresh guilt. Fresh guilt scent is what he testified this dog was able to track from the scene of, I think it was a motor vehicle accident, to the defendant and find him there. Fresh guilt. And what's shocking in so many ways is that this was a trial court actually allowed this in. A judge sitting on the bench is given this evidence and thinks, yes, that's valid and probative and great, and the jury should hear that. That should be part of their decision making, that a dog followed a fresh guilt scent to the defendant because this expert said so. Sounds like a joke. I would love for it to be a joke, but it actually happened. Somebody got convicted for it, and it had to go up on review in Washington for a reviewing court to be like, yeah, no, that's bullshit. This isn't science. This is not valid. You cannot bring this into a case. So yeah, stuff like that happens. It's not very ha-ha funny. It's not much of a joke. People get put away on trash like that all the time because of an expert who says stuff that when you think about it, when you really sit and think critically about it, it should be obvious. It should be obvious that that's junk. But it happens a lot of the time because you put that expert on the stand and then they have special gravitas and influence with the jury. You're an expert after all. Why wouldn't we just defer to you? And so they can just make up all kinds of psychological things, phenomena, fresh guilt scent. It's just about as ridiculous as it gets. Tara Rayner, Lally is short for lullaby, monotone, and boring. Yeah. I mean, just when we think things are getting good, Lally gets back up. And no, we're back. We're back in our snooze. I never knew a prosecutor could make a murder case so boring. If it weren't for the defense here, we would be losing our minds. We would be so bored. It's just terrible. Ed2276. Doc said he noted on the medical record there were no injuries anywhere below the neck line, but says he didn't do an assessment of those areas. Sounds like falsifying the medical record to me. I think he's just trying to hedge his no injuries, Well, I didn't look. I mean, he didn't observe them. He's not falsifying anything to say he didn't notice them. That's really what it means. He didn't notice any injuries anywhere below the neck, but he's going to go out of his way to tell us. Well, I also, by the way, I didn't look very hard. But he did make it pretty clear. He says the abdomen was atraumatic. So that means you looked at the abdomen. You didn't make that determination just by guesswork. You didn't assume the abdomen was atraumatic. You didn't decline to look at the abdomen and then draw inferences about it. No, atraumatic. You inspected it and you found no injury, and that's very, very significant with a motor vehicle accident because that's where most people are going to get hit. When you're standing, you're going to get hit somewhere in the torso. You're likely to have internal injuries, stuff like that. You're thrown, the massive force. When a car hits you, car is going to throw you. It's going to do things to your whole skeletal system. No back injury. Yeah, I'd be looking for that kind of stuff. So I think that was just him trying to hedge. I put in my notes that I didn't note anything, but just so you know, I really wasn't looking that hard, so it doesn't mean that the things weren't there. Nicola Maxwell, Jeff Burkhardt, I've seen it. She's good. Martial arts is the only sport I watch, and her skills are impressive. That video actually inspired me to sign back up to my boxing gym when my broken ribs heal. Well, I assume you're talking about something I did with boxing, and thank you. I'm really not that good. I've just been doing it a long time. And so, I'm better than the newbies that show up, but I was never, exceptionally talented as a boxer. I found it very late in life. I really wish I had found it as a kid. When you're still young and flexible and you just have so much time to be able to develop those skills. You know, maybe I would have been better, but like, no, I don't hit especially hard. I'm not all that fast. My big asset in the ring is that I'm long, I'm tall. I tend to be taller than other people my weight that I would be fighting with. So I get a reach advantage. And that's great, but you got to know how to use it. And that's where I've gotten better and better over the years, is just being able to use my reach. But thank you so much for the kind words. I do appreciate that. It's nice to hear. Oh, you don't, you know, better than, hey, you look like a dumbass out there getting your ass handed to you in the ring, which is what happens a lot of time with the guys that I'm in with. So, James Casatelli, can this ridiculous schedule be used as grounds for an appeal if she's convicted? No, it's not. It's going to be one of those areas where the court has nearly unlimited discretion in deciding its schedule. The Court of Appeals is not going to say your schedule is unconstitutional or something like that. I don't know the reasons for all of these delays. I mean, I just have to assume these are scheduling conflicts that people have already had. The only way I see the scheduling getting to be a problem is if this thing starts to drag on and on and on longer than what we had anticipated it was supposed to be, because that can create problems with jurors now start having conflicts. If we start losing jurors because they're like, yeah, you told me it was going to be a 6-week trial, and that's what when we were doing hardship excuses and things like that, I didn't mention that I've got this really important stuff on week 8 because I had no reason to think we were going to go that long. But now it's coming up, and I don't know, I've got a medical procedure scheduled or something like that. That can be an issue if you start losing jurors because the time is dragged on. And then the other way it can be an issue is if you start limiting the defense evidence because the prosecutor has taken up too much time. That's going to be an issue. You may want to get the case done, but you needed to have sped the Commonwealth along here if that's the concern. You don't get to let them just have free rein to take up all the time and then deprive the defense of the opportunity to put on their case. It's the constitutional right is to present a defense. There's no constitutional right for the prosecutor to present, 20 different versions of snow videos, okay? To spend however long we spent with John O'Keefe or Paul O'Keefe on the stand looking at the driveway at John's house being snowblown the next morning, the next afternoon. None of that was relevant. It didn't matter at all. So no constitutional right to do any of that stuff. There is a constitutional right to present a defense. So if you start limiting the defense, that can cause issues. Michael Corey, can you explain what lost video he's referencing? I'm lost. So I don't know all of the details about this either, but there are several pieces of video that I have been led to believe should exist and do not. Some of it, I believe, is video of the library. There's been some talk about some video from the library that got missing, and I believe that's because they think it implicates what's her name? Allie McCabe. She's out driving around in this time frame, right? She talked about it in her own testimony. She acknowledged driving around up to, what was it, 1 o'clock, 12:30, something like that, when she's back home in bed. So 12 to 1 time frame. Would she be on this video? I mean, maybe if that's the normal route and stuff like that. But then, of course, there's the Life 360 that suggests, no, she was out and about at different times, that she would have potentially gone past the library during one of those, and she would have been seen. The other issue where I think there might be some suggestion of missing video from the library is because if Karen would have gone by, I believe the idea is we would have seen her tail light. Her tail light would have been visible at the 5 to 6 a.m. time frame, or the 12:40 to 1 if it's capturing her when she goes home. It would show us, would potentially show us the condition of the tail light. So these are what I am kind of remembering as far as why that library video, what may be missing and why. The Sallyport video, we know that some portion of that is gone. And I believe, if I remember correctly, the details were like just right at the time frame when they happened to be bringing Karen's SUV into the Sallyport, like a 40-minute section right there just happens to be missing from the police department. That's weird. Okay, that's weird. That's where I would like to have heard stuff like, if this video evidence goes missing, can that be like the GPS, where it's just innocuous, it just happens, the network goes down, networks go down, I get it. Does that shut down the cameras? I'd like to know that. In part because you could then validate that. You could say, okay, we have a period of time here where video is missing. It's because the server went down. You can go get server logs and stuff to verify that. The Commonwealth would be able to show me, yes, there was this incident. The IT department can document it. They can show you here in the records where it was doing this. And that corresponds with the time of the cameras going down. Why do I think I'm not going to get anything like that? Why do I have a suspicion I'm not going to get anything like that? So those are the missing pieces of video that I'm aware of. Hopefully there's a lot of people in the chat who know a lot of the ins and outs, the details of what happened in the pretrial proceedings. So if I've gotten any of that wrong, please correct me. Please spell it out. That's my misunderstanding. We're interested in the library because it might show Allie McCabe driving around with Colin. We're interested in the library because it might show Karen's taillight, and we're interested in the Sallyport because it's supposed to show us Karen's car at the time it arrived, and then we would see the condition there as well. We would see the condition of that taillight when the car drove in, and not just whenever after the fact they decided to take a picture of it. Moon Goddess. At Jeff Burkhart, according to Newsweek, there are 2 hearings on Thursday. One is at 10 a.m. The second will be behind closed doors at 1:30. So this is jumping to Kohberger. Since we don't have anything else going on in this case this week, we're done for this week. I'll see you on this case back on next Monday when they're back in court. But I am going to be going live on Thursday at 10 o'clock to cover this hearing in the Brian Kohberger case. So this is a continuation of the motion that we saw the beginning of last week when the Detective Mowry from the Moscow Police Department testified about all the stuff he didn't do and the work he didn't save and the records he lost, but then got back from the FBI, but then looked at the day before. I mean, not a great look for the whole cast forensics in this situation. This is going to be a continuation of that hearing. So I don't know if there's going to be more testimony or if they're just going to go to argument on it. I don't know. We're going to have to see. But once again, we're kind of back in the situation of trying to glean what it is that the state is not turning over and what is their reason for that. What is their justification for either concluding that the defense isn't entitled to it or not having it. If it's something that you're supposed to have, you should have had, then why don't you have it? So I'll be looking for clues to all that type of information at that hearing, and hopefully just get a little bit of better insight into what is going on with this cell forensic stuff, this location forensic stuff. The biggest, I'm just going to sideline for a little bit since I'm talking about Kohberger. The biggest thing out of that hearing that really caught my attention was how he's the guy, Detective Mowry, he's the guy that was tasked with putting the stuff together for the grand jury. And that was very strange to me because in the probable cause affidavit, seemed pretty clearly that it was the FBI that was running the cast stuff. and they provided it to Payne, and Payne, you know, made conclusions about the locations and stuff like that, and conducted his investigation accordingly. So we know the FBI was involved with this, at least early on. Why did they not use the FBI with the grand jury? Why did they go use this guy and his screenshots that he was able to create? It raises the question, does his process not line up with the FBI's? Does his conclusions not line up with the FBI's? Did the FBI not get called because their analysis took them somewhere else? Raises the question. I don't know if that's the explanation, but it's just very strange to me that you relied on them for your probable cause to arrest, but then you don't use them for the grand jury. You use this guy who went to some software training classes and didn't save his work and just screenshotted what he was doing. Yikes. It doesn't look good. It doesn't look good. So anything that I can learn from this hearing about what on earth is going on with this location analysis, I want to know it, because it's such a huge piece of that case. I've said before, and I will reiterate, even if the defense is able to prove unequivocally Brian Kohberger was somewhere else at the time that these murders were committed, or at least his phone was somewhere else at the time these murders were committed, I am fully confident that the state is still going to go forward with trial. They will take this case all the way to the end based on nothing but that trace DNA, if that's all that they have, because that seems to be all that they have. It seems to be all that they have, and it makes a lot of sense to me that that is really what drove the train of this investigation. They didn't have evidence of personal conflicts or animus or connections or just something like that that would give them a clear target to focus on, to track, to look at their movements, look at their media, all that stuff. They didn't develop that through their just ordinary investigation into what were they doing, who were they talking to, who did they know, who had a motive, that type of thing. So what they had is this piece of trace DNA that they were able to develop from the knife sheath. That's what they had to go on. This is where it led them, and it hasn't panned out. Said it many times before. I just don't think this investigation has gone the way that they thought it did. They thought that trace DNA was going to be the smoking gun. They were going to be able to back it all up with evidence they get from his car, evidence they get from his home, from his computers, his devices. All of this stuff was going to be able to back it up, and it does not seem that any of that has happened. So I don't know that they have anywhere else to go. If the location stuff goes away, all they have is the trace DNA. Yeah, I think they're still going to trial on that because they don't have anybody else. They don't have anybody else. So, yeah, Kohberger coming up on Thursday. The 10 o'clock hearing is the one that is open to the public. There's a second hearing on the same day at 1:30 that's dealing with the investigative genetic genealogy stuff. That one is closed, so we're not going to be able to see any of that. But the one in the morning dealing with the motions to compel, the location-related stuff, those the judge has decided reversing course that we're going to be able to see them and what's going on with those. So I will be there for that. Feel free to join me if that's a case that you're interested in. I'll just be doing it like this, live stream the hearing, give you my thoughts afterwards. Plain iron, have a coffee or tea on me. Thank you so much. I will do that. I would love that. I mentioned last time I'm really into the silver needle white tea right now. I'm obsessed. It's been like a couple months now. I don't know why. It's just so good. I love it. And that stuff is not cheap. Hate to say, your loose leaf silver needle white tea, it's not cheap. So I'm getting a lot of brews out of each little bit of leaves I get. So I thank you for this. This will definitely keep me in silver needle white tea for quite some time to come. So that's it until Monday for Karen Reed. That's it until Monday. Ended it on a strong note for the defense. A lot more just what are we doing here from the Commonwealth. Did we get anything from any of the Commonwealth that landed? I mean, the whole point of this was to get to that retrograde extrapolation, the range of 0.135 to 0.29, whatever it was. I mean, that was supposed to be the big damaging bit of evidence for the day. And boy, what a dud. It was a dud. It was a dud. It did not land. It did not land. The garbage in, garbage out problem. The 1245 last time of the drink, it's just problematic on its face. How did you not know? How did you not know that is going to be an obvious problem with this calculation? You know perfectly well she did not have a drink at 1245, and it was probably at least an hour earlier that she last did have a drink of alcohol. Terrible. Terrible. So really undermined themselves. Not a whole lot there. Not a whole lot there. That was a real upside for the Commonwealth today. Then once we get into the plow drivers, it just seems like we're back into rebuttal mode, to defense mode. This isn't about your case because you didn't get anything about the plow driver. The defense had to go get that. They had to get that information. So you're just calling this guy preemptively to try to create the impression that he's your witness, that he has something to add to your case, but he doesn't. He doesn't. And what he is giving us seems like it is actually setting up the defense for later on when Trooper Proctor is on the stand. If Trooper Proctor said that this guy told him, the supervisor told him, roads weren't plowed, that's a problem. That's a problem for the Commonwealth. Even if you didn't get the plow driver's name, you didn't chit chat about the plow plan for that night and about who was down in Fairview at that area, you didn't get that and come out of that with, well, it didn't get plowed, because we're going to find out it did. We're going to know the details of when and how that happened, how it was planned, all that. They knew in advance. He's on the list. Brian L. is on the list as the driver for that route. So, didn't get plowed that night. No, it's not gonna work. Anything else that went well for the Commonwealth that day? Anything else? I don't think so. I don't think so. Today was about the retrograde extrapolation, and that one failed to launch. This was the rocket going up and not making it into orbit, having a little incident along the way. No, it did not land. It did not land at all. There's so much wiggle room in it anyway, and then your assumptions are garbage. Your assumptions are garbage. People I saw were questioning how might her MS diagnosis play into any of that. I don't know. I really don't know. I'm not an expert on that type of thing at all. What it sounded like they were trying to set up is an argument having to do with lactic acid, potentially. I don't know if MS might cause you to accumulate more lactic acid if you've got, it's kind of like an inflammatory type of situation going on. Might you have high lactic acid? I don't know, maybe. It seemed like that was kind of what they were trying to open the door for, that then because of that, you're going to have more of this metabolic byproduct in your system that is the same thing as the metabolic byproduct for alcohol, but it's not there because of alcohol consumption, alcohol metabolism. It's there because of lactic acid metabolism. So maybe they'll have an expert on their side to get into that. But that's really the only way I can think of there being some type of interference with that test, with the bio test. Now, if we were talking about FSTs and how could MS affect somebody on FSTs, well, yeah, now we've got potentially a lot, because MS is a disease that can affect your movements and stuff, your musculoskeletal just your function, your ability to like walk in a straight line and do the walk and turn and things like that. So if we were talking about field sobriety tests, yeah, no question, I can definitely see an argument that a disease that affects your motor movements is going to affect your ability to perform well on FSTs. But as far as a chemical result for something that looks like alcohol, no idea. But it sounded like they were setting up this argument that has something to do with lactic acid. And that could be the explanation for why she had that high result at the 9 in the morning when the blood was drawn. So alternatives to the possibility that it's because she had been drinking so much the night before that's what her level was at 9 in the morning. Alternatives, no, she has a disease that causes her to have high lactic acid buildup, and that can create confusion with this test because they test for the same byproducts. Or if you haven't ruled out to me in your medical records that you used an alcohol swab, possible explanation there as well. You used an alcohol swab, you contaminated the sample, but she wasn't drunk at that time. So I see those things being kind of set up, and they'll probably just be addressed. If they don't have specific defense experts to come in and talk about that type of thing, then they'll probably just address that in their closing arguments. So yeah, that's what I got out of that. But the lactic acid, that does make a lot of sense, and it is a very different test. It's a very different test than the gas chromatography, mass spectrometry that she brought up as the gold standard. Yeah, that is normally what you want to do when you're testing for a volatile material, because it's far more precise, far more accurate. It will relate to that actual blood volume measurement that you're interested in, legally speaking, not just the serum level that can matter for therapeutic purposes. And it's getting around that issue of, because you're directly testing for the alcohol, you're not testing for metabolic byproducts of alcohol that can also be metabolic byproducts of other things. So a couple lines of attack there on the serum evidence. Garbage in, garbage out, man. Garbage in, garbage out. And it makes sense. It makes sense. It makes sense to me if they had the blood result, they already knew what the blood result was. That sure would explain why Trooper Proctor might feel pretty safe about making up some lies about what's on that video evidence at CF McCarthy's and the waterfall, because he thinks there'll be stuff there, it'll back it up. If it was that high, she must have been drinking a lot the night before, right? I mean, 0.09 at 9 a.m. That's a lot. That's quite a lot. I mean, yeah, you were pretty drunk the night before. If you're still above the legal limit when you wake up and are going about your business the next day, you had a pretty good load on the night before. So it would make sense that if that's what he's expecting to see, he wanted to lie. You make that up, you'd expect to see it. But we sure haven't seen it. And once he put that in his statement of facts, I expect to see it. But boy, we haven't seen any of that video from the waterfall or from CF McCarthy since then, have we? It's been quite a few days since we've seen anything there. Did not see this steady stream of drinks that Trooper Proctor said very specifically he was able to see her drinking on those videos. So that could explain why. He thought he was going to be able to get away with it because her blood alcohol tested high the following morning. It gave them what they needed. If you're going to frame somebody, you rely on the little bits and pieces of evidence that you have. If you know she's got a broken taillight, you know she dropped him off at the house there the night before. You know she's got a high blood alcohol level the next morning. Well, it would give you all that you needed to be able to construct something around that. So can't say for sure yet that is what happened, but we're getting closer. We're getting closer. And I do feel like we're getting a lot closer to that than we are proving that Karen Reed murdered John O'Keefe with her car. So, I'm going to call that a day, guys. That was a full day. We'll see what we get Monday. I'll plan on being back then, bright and early, 5:45 a.m. PST. This is just getting to be my new normal. I'm getting pretty good at waking up at 5 a.m. now. Who says you can't teach an old dog new tricks? Feeling pretty good about that one. But at the same time, I'm also very glad this trial is happening in May and not in December. That would be a whole different situation, trying to get up at this time of morning. So I'll plan to see you Monday. I'll be keeping an eye out on the commentary, see if anything interesting comes up in the meantime that people have to talk about. But otherwise, I'm just going to continue to wait and see if the Commonwealth ever proves Karen Reed hit John O'Keefe with her car. It'd be great if they would get to that, but I am just becoming increasingly skeptical that we're ever going to see it. So maybe next week we'll find out. Thanks so much, guys. Appreciate all of you in the chat. Appreciate all of the support, the super chats, the memberships, all of that. Really appreciate you guys showing up, making this a fun scene for everybody, making this not an echo chamber. I'm not here to be an echo chamber. I'm not here to tell anybody what they want to hear. I'm here to give it to you straight, tell you what I think. You can do with that what you will. If it's persuasive to you, great. If it's not persuasive to you, that's fine with me too. I'm not, claiming to be some ultimate authority of anybody here. I just have been in this position, and so I have thoughts about what I'm seeing based on my experience there. So I enjoy seeing a lot of this conversation in the chat. People do have different perspectives, and you know what? I'm cool with that. As long as everybody's cool and you're not an asshole with your opinion, then we're not going to have a problem. So appreciate that. Love the chance to see it. And if you see anything interesting too that you want me to check out, like I said, if you're on the horrible place that we call X, do feel free to tag me. I'm just going to be keeping an eye out on things to see kind of what the conversation is over the next several days and going into next week, in the hopes that we might kind of get some perspective on what's coming. I'm always looking to get filled in a little bit more on the background of what led us to be where we are here. A lot of that pre-trial stuff that was developed that I'm not nearly as familiar with a lot of people. So see anything like that, definitely feel free to let me know and I'll take a look. And until then, guys, I'm going to check out. I'll plan on seeing you next week. Thank you so much for being here, and I'll plan to see you on Monday.